Adventures in Legoland, written by Marc Stevens, read by Jace Johansson. It is easy to believe that something must be true because everyone else believes it. But the truth often only comes to light by daring to question the unquestionable, by doubting notions which are so commonly believed they are taken for granted. Is it possible that everything you think you know is just a public relations scheme? Preface. This isn't a book about how to win conflicts with bureaucrats or a self-help book. This book contains some of my experiences in various courts, especially tax and traffic-related proceedings, as they are known. This is what I've learned about the true nature of these violent, humiliating, and ultimately self-defeating events. Winning is a very misleading word, though. In my experience, once you've had any communication with them, then you've already lost. By bureaucrat, I mean any cop, judge, lawyer, government employee, or any other agent of any pretended state. A bureaucrat herein is any individual who does not deal with people on a mutual voluntary basis, what I call compulsory trade. I say you've already lost because, at the very least, they've cost you your valuable and otherwise productive time, and I don't mean just the stop on the street or the time you take to read their friendly mail. For example, if you get a traffic ticket and decide to just pay it, then the productive time you spent earning that money is lost when handed over to the bureaucrat. You didn't work for yourself or your family. No, you worked for a bureaucrat who did nothing productive to be entitled to your money. By productive, I mean creating value for which people are willing to freely exchange. If you instead decide to have what politicians call a trial, then that time is spent and wasted as well. And if by some miracle you somehow win, traffic court is not where you will be awarded money for your time spent. This is true even if you win and prove there was no basis for the ticket in the first place. The only way you'll ever win with bureaucrats is you're being wiser for the experience and possibly learning one more way to keep communication with bureaucrats to an absolute minimum. I won a traffic case in an Arizona justice court in December 1995. I won because the cop admitted that he was not qualified to write traffic tickets. Despite driving out there, 4 hours total, and my time at the so-called trial, I was not given anything to compensate for my loss of productive time except experience. There are universal rules at work here. With bureaucrats, you always lose. This is because whenever you find yourself being forced to deal with them, nothing productive is being done. Bureaucrats don't create value. They only take it. Bureaucrats feed off the productive. I keep this in mind if I ever get a ticket or any other communication from them. Either way, I am going to lose my valuable time. It's only a matter of degree. Remember, that's how a bureaucrat lives, off your productive time. As long as there are bureaucrats, your productive time may be forcibly or violently taken. Things will not change when the bureaucrats enjoy such mass support, whether actual or pretended. I think of it as damage control. Once a bureaucrat sets his guns on me, then I am going to be damaged. I only need to decide what is the best way to keep the damage to a minimum. No man's life, liberty, or property are safe while the legislature is in session. This was said by the great Mark Twain. This book is written about personal experiences, some 7 years or so, in the traffic, tax, and other courts from the standpoint of the victim. I have consulted with and helped people who have had traffic tickets and other harassments from bureaucrats in Arizona, California, Washington, New York, Nevada, Colorado, Florida, Oregon, New Mexico, Ohio, Pennsylvania, Michigan, Missouri, Idaho, Utah, Oklahoma, Texas, Maine, Virginia, Indiana, and North Carolina. During this time, I have noticed things are generally the same no matter where you are. There are some subtle differences here and there, but they are usually just in form, not in substance. While you may be geographically located in Washington, when in a traffic court or any other American court for that matter, you enter what I call legal land. This is the place where bureaucrats live. As the Cheshire Cat put it in Lewis Carroll's Alice's Adventures in Wonderland, the only sense is nonsense. The good news is, because of the way bureaucrats operate, and after spending some time with them, it's fairly easy to predict how they will react and what they will say in any given circumstance. I wrote a script for a woman who had a case in the Yuma, Arizona Justice Court. Her husband went to court with her and called me afterwards, amazed I predicted what the judge said almost verbatim. He asked how I was able to do that. I told him it was easy. All bureaucrats operate the same way. The only real differences are the individual reactions. As will be shown in this book, bureaucrats, if faced with certain questions, will always sacrifice one of two things, and in doing so will show there is no case. However, don't misunderstand. This does not mean a case will be thrown out. To do this, it's important to know who and what you are dealing with. Understand, as you are reading this, the principles are what are important here, and not the particular examples I use in order to demonstrate a point. The fact I often refer to traffic courts does not mean the same thing does not apply to any type of court. Introduction. Going to court is usually a very intimidating, humiliating, and sometimes degrading experience. Lawyers and other bureaucrats probably designed it that way. There is always a risk of going to jail for contempt if the judge gets ticked off or just doesn't like you. I have often wondered what it would be like if a judge came prancing out of his chambers and the whole gallery of people in the courtroom were also wearing black robes. While most people look at traffic courts or any court as a necessary evil, they might be surprised at the underlying violent nature of it all. I'm sure most people believe that if someone doesn't wear a seatbelt when driving a car, that they should get a ticket and pay a fine. But who thinks that same person should be handcuffed in front of their children and hauled off to jail? Unless, of course, that person was profiting from such violent actions. What rational person thinks that same person should also lose his car because he didn't put a seatbelt on? Yet this could happen every time a bureaucrat gives someone a ticket. Yes, bureaucrats believe they have a right to take your car if you are accused of something as petty as a non-violent traffic offense. Don't take my word for it. Look up the so-called forfeiture laws in your area. In legal land, it's perfectly okay to steal a car if you label such armed robbery a forfeiture. In legal land, a political label magically transforms robbery into something honorable. What I have found in my experience is that traffic courts are not a necessary evil. They are just evil. The people who do business as traffic courts do not tolerate challenges to their pretended authority very well. Most challenges, even if only in the form of harmless questions, result in a judge getting very upset and threatening physical violence, i.e. contempt. When going to any court, you enter what I call legal land. Legal land is very similar to Alice's Wonderland. It's where words and phrases mean whatever a judge or other lawyer thinks they should mean. This is a fantasy world where theft and violence are okay if you have a badge or a fancy political title. It's a magical world where facts are opinions and opinions are facts. Legal land is where facts spontaneously become opinions and then turn back to facts. It's an enchanting place where slavery is freedom and submission to degrading and humiliating searches is a patriotic duty. Legal land is also where there are millions of ever-changing, incomprehensible rules, but not one of them that's binding on the individuals who make up those rules and enforce them on others. In legal land, I've been threatened with contempt on a few occasions for merely asking a judge what rules apply to the proceedings. How is that for antisocial behavior? Legal land is a place where you own property and at the same time you don't. It's a place where a person is competent, then incompetent, then back to competent again, all within a few minutes. Legal land is where an error is not an error if committed more than once. Legal land is a place where reality may be disregarded as legally defective and a nullity. It's a place where political allegiance is more important than facts. It's a world where being non-responsive is equated with due process, good faith, and fairness. This book, however, is not a patriot book with patriot-type arguments, nor is it a self-help book. I don't make any legal or political arguments that people are not required to have a driver's license because they are allegedly only for commercial uses of the roads. The so-called 16th Amendment was not ratified, and similar types of arguments. This isn't an anti-government or anti-state book, and I don't advocate violence in any form or under any political banner. I don't see politics as an excuse or justification for violence. I don't believe in a collective right to steal and murder, nor do I believe armed robbery is okay, even if you have a majority vote or a costume called a uniform on. I believe parents are responsible for raising their own children, not mine. I have no right to have my neighbors pay for my children's education. I don't think my children have a right to an education at the expense of others, even if I or some faceless bureaucrats deem that education necessary. If someone thinks his child is entitled to have their education paid for by another, they should be willing to pick up a machine gun and walk door to door collecting it themselves. This book contains my experiences with individuals who forced me to participate in their trials and what I have learned in the process. This is not written because I am allegedly bitter at having lost some traffic cases. If someone does consider me bitter, so what? Such uninformed opinion does not affect the truth. If you were mugged, wouldn't you be bitter? Does that magically relieve the mugger of responsibility? If people were not bitter, lawyers would be out of a profession, wouldn't they? I'll flip this argument around. Is it an offense to a traffic ticket to claim the cop is just bitter? Because of what I have learned, I personally have no political beliefs. I define politics as organized violence and deception. I believe forcing my opinions on others is wrong, whether I directly or indirectly through what I call political voting. I believe that while I have the right to use my property as I see fit, I have no right to tell other people how to use their own property or interfere with their free use of it. I am not impressed by political pecking orders, and I don't think it's necessary to initiate the use of violence. I also believe that no service, however valuable it may allegedly be, should be provided at the barrel of a gun. A service is proven valuable by the number of people willing to voluntarily pay for it. Just because you drive a Dodge doesn't mean I have to. In other words, just because you may feel the need to be dominated by another person such as a governor, doesn't mean I want or need to also. If you need a king, that's your prerogative. However, your choice to shop at Sears doesn't obligate me to contribute a fair share of their operating expenses, and if I don't, it doesn't mean I have to leave the geographic area I choose to live in, i.e. Sears, love it or leave it. The thought of how far the human race would have advanced without government simply staggers the imagination. Doug Casey, 1979. Chapter 1. Know who you're dealing with. One of my favorite lines from the movie The Untouchables is spoken by Sean Connery. There's an intruder in his house seeking to kill him, and he says, just like a dago to bring a knife to a gunfight. If I don't know who and what I'm dealing with, then I can't be very effective if I choose to defend against a bureaucratic attack. What is critical to understanding who and what I am dealing with is this. Bureaucrats never ask permission to aggress against someone or their property. I know you may laugh at this, but this simple truth should not be overlooked because this is the basis of the most effective method of exposing their proceedings for what they really are. If you think of bureaucrats are a benevolent group of caring, peace-loving individuals who respect the property rights of others, then ask a bureaucrat if they require your permission to proceed against you. They will tell you in no uncertain terms they do not. In my experience, some bureaucrats will actually laugh if they think I am suggesting their jobs depend on my freely given consent. This, however, is the reaction I hope to get. Let him pound his chest at what a man he is by not having to ask my permission to control my life and my property. I never underestimate the importance of this issue because it's the only real issue. I'm dealing with men and women who take control, also known as jurisdiction, over people's lives and property without their consent and are usually very proud of it. In other words, they acquire control over your life and property through violence and organized coercion. Why is this so important? Do you equate violence with good faith? I don't. Unlike bureaucrats in places like China, bureaucrats in the geographic area known as the United States put up a pretense of legitimacy. This pretense, or public relations scheme, conceals what is really going on: the taking of property and productive time through violence. Political language is designed to make lies sound truthful and murder respectable, and to give an appearance of solidity to pure wind. George Orwell. Here, political words conceal the true nature of what is going on, such as jurisdiction, constitution, nation, state, license, court, law, statute, arrest, contempt, and so forth. This does not mean that I return that violence with more violence, because I don't. I do the opposite. Do you remember how the people of India, through peaceful non-cooperation, caused the British to show their true colors? The British slave-mongers had a choice. Which one was more important to them, their pretense of legitimacy and civility, or their true violent criminal nature? Apparently, it was the massive lie their government put forth they were civilized that was more important. Gandhi and his followers were able to rid themselves of the British without resorting to violence. The English exposed themselves and then left. That is how I do things. I make the bureaucrat choose between the true violent nature of his business and his pretense of legitimacy, knowing he's going to sacrifice one of them. I just hope it's the violence. Political words and opinions are used so there is a perception that bureaucrats are a wonderful, benevolent group of men and women protecting people and their property. But it's just a pretense, fraud, hoax, swindle, charade, etc. Without violence, bureaucrats could not function at all. If I took control of your life and property by force, I would be a criminal, and prancing around with a silly crown, calling myself a king or a sovereign, makes it no less a vicious act. And it still won't change if I get a few friends to prostrate themselves on the ground, genuflecting and proclaiming me king. Change your perception for a moment. Look at the situation such as a traffic stop, and imagine it without the legal opinions and costumes. Just look at the actions and what is really happening. This is similar to the story of Alice in Wonderland, when Alice realized the so-called queen was just a playing card. Alice just stopped accepting the mental conception that a playing card was a queen, and the queen lost her power over Alice. Another example is the story of the emperor without any new clothes. The real question here is, why would you call a naked man an emperor and not a naked imbecile? A friend of mine was talking to someone on the phone who stated the Queen of England was a so-called sovereign. He asked what she was sovereign over, and the guy told him, the people. So he asked, what if everyone left England? As humans, we typically do three things with the messages we receive from our sensitive. 1, we delete. 2, add to and/or. 3, distort them. Because this is not a psychology book, I will keep it simple. Consider these deletions, distortions, and additions to reality as opinions. Reality equals facts. Deletions, distortions, additions equal opinions. Every time a bureaucrat spews forth an opinion, he is deleting, distorting, and/or adding to reality. This is very important. A typical traffic stop involves a man dressed up like a cop, committing numerous crimes against his victim. I mean crimes in the lay or layman's sense of the word, not in the so-called legal sense. These are not considered to be crimes because in legal land, it's not false imprisonment. It's called an investigative detention or some equally inane political label. Nothing has changed except the label or opinion that's been added to it. The political or statist legal land words cover up the real issue and distort reality. The reality that someone is taking my property through physical violence, threats, and organized coercion. Don't distort, add to, or delete anything from reality. Know who you are dealing with and don't bring a knife to a gunfight. Chapter 2. Never assume anything. I don't accept any presumptions or opinions, delete, add to, or distort things. Instead, I question everything. This tends to really irritate my wife. Whether I think I understand something or not, I question it anyway. I ask them to be responsive and explain it. I wouldn't just assume the guy who gave me a ticket is a police officer as if a person's job makes it okay to use physical violence and coercion against me. Just as important, I don't assume the cop, the primary or sole witness, understands what is going on or what he is talking about. I do not add opinions, I only look at the facts. He's a man with a gun and a costume called a uniform. Not only that, he took control of my life and property without my freely given consent. I take this to mean that he's a man with a gun who has no respect for human life, at least not while he is on the clock. In other words, his job description is to be antisocial. When I assume or accept presumptions and opinions, deletions, distortions, or additions to reality, I relieve the bureaucrats of their alleged burden of proof and make the taking of my valuable time easier for them. If that is the case, then why put up any kind of defense? Bureaucrats have to make what they do look legitimate. That is, give me so-called due process of law, a fair trial, or, heaven forbid, administered justice. If the way they operate isn't seen as legitimate and fair, then people would not support them, at least not as many as do now. If people didn't support them, then they wouldn't pay taxes. Without taxes, there is no way to pay the men with machine guns to force compliance. Apathy has a strange way of doing that. Let's face it, the only real difference between what the men and women doing business as the IRS do and what a common thief does is the political label attached to it, i.e., one is legal and the other is not. Taking property by force is robbery, and the victim doesn't usually care about opinions. Whether something is legal or not is not a factual description of reality. I once asked a former IRS lawyer from Phoenix named Eric what the factual differences were between the act of stealing and the act of taxation. He initially sneered at me. That's an easy question. One is legal and the other isn't. I told him that was non-responsive. I only wanted the facts. Just before slamming the phone down, he spit out, "Okay, you're right. They're the same thing." I guess it's tough realizing you spent 18 years defending and profiting off of armed robbery. This pretense of fairness, together with the fact that violence is the nature and basis of how bureaucrats operate, form the foundation for framing a very effective method of exposing bureaucrats for who and what they really are. They will actually expose themselves. I don't have to make any arguments or say that they have no case. They will do that for me in their zeal to steal my property and productive time. Those who attack the rationale of the game and not the players are its most formidable adversaries. James J. Martin, in an introduction to Lysander Spooner's No Treason, the Constitution of No Authority. So again, the foundation for my questions are: they operate by physical violence and coercion, and they are supposed to administer justice, i.e. act in good faith, and give me a fair trial. To rational people who respect human life, these 2 points will always contradict. I ask questions to expose this contradiction. If you examine the opinions used to justify the violence, then you'll see contradiction after contradiction after contradiction. Bureaucrats don't have to answer any of my questions either. Being non-responsive also strips them of any pretense of good faith. According to their own rules, I am supposed to be informed of the nature and cause of the charges and proceedings, and they refuse to answer my questions? Doesn't look fair to me. Physical violence and justice are opposites here. In the real world, I exploit it as best I can. I have no pretenses. I know in legal land, violence and justice are soulmates. In my experience, bureaucrats have no problem using as much violence as is necessary to get compliance with their whims and opinions. It's just part of their job. No matter how much violence is used, they blame it on their victim. Yes, your husband's dead, but he had it coming. He should have had a seatbelt on, and he should have answered the officer's questions faster than he did. I think asking questions is more effective because the burden never shifts to me. Why should I have to prove anything? What if I'm accused of being the Easter Bunny or the Tooth Fairy? Either way, they have no case. This is true even if damage is caused. If you don't believe this, let me give you some examples. Although, don't misunderstand, this is not advocating causing damage. If I bust my next-door neighbor's window, I am only responsible to him to replace his window, not some schmucks down the street. A woman telephoned me because she changed lanes without looking and damaged someone else's car. A cop then gave her a piece of paper known politically as a ticket. I asked her a few questions such as if she had insurance to cover the damage she caused. She told me she did, and the insurance company was taking care of it. I then asked her if she believed she was obligated to the cop in any way. She initially believed she was. I asked her what facts she relied on to support her legal opinion. She was unable to answer. This is because there is no obligation. I told her I would ask the cop the same question. When not permitted to delete, add to, or distort reality, bureaucratic attacks cannot be justified. Unless you've made an agreement by your individual freely given consent, then any so-called obligation is no obligation because it is based upon coercion. If this is not true, then consider the average thief on the street. If he sticks a gun in your face demanding money, are you obligated to give him your money? Even if you give him the money, are you obligated to keep giving him money months and years later if he returns? What if that same thief claims to be your sovereign and demands your genuflect after giving him your wallet? Consider this. I walk up to you and say, "Oh yeah, by the way, Frank just agreed with me that you should be my slave. I mean, citizen. We signed a contract, rather a social compact. Now come with me and start paying your fair share by scrubbing my toilets." Would you honor such a contract? Would it be a contract? For any lawyers reading this, do you really think valid obligations are created by violence and organized coercion? I wouldn't think any rational person would think so because that would be the same as saying armed robbery is a legitimate business. However, in legal land, armed robbery is legitimate if you carry a really cool-looking metal badge and a high-sounding political title. Lysander Spooner said it best. If taxation without consent is not robbery, then any band of robbers have only to declare themselves a government, and all their robberies are legalized. Lysander Spooner, letter to Grover Cleveland. Criminals could also set up their own courts. Bandits have not usually kept supreme courts of their own to legalize either their robberies or their promises to pay for past robberies out of the proceeds of their future ones. Perhaps they may now take a lesson from our Supreme Court and establish courts of their own that will hereafter legalize all their contracts of this kind. Lysander Spooner, letter to Grover Cleveland. Having courts, lawyers, and opinions does nothing to make robbery any less of a crime. That is all political sleight of hand to delete, add to, or distort reality. Lysander Spooner was a lawyer who competed with the post office bureaucrats who eventually used violence to shut him down. I highly recommend his writings, in particular his No Treason, The Constitution of No Authority. Most can be found on the internet. My second example is that of robbery in California. I'll use car theft to illustrate. Without political opinions, theft is the taking of property by force without the owner's consent. Bureaucrats catch a man they believe took the property by force. This man is then put on trial. He is convicted and put in a cage referred to politically as a jail. The big question is, just how do the bureaucrats pay for all of this? This includes the cops, judges, clerks, detention officers, lawyers, jurors, and the cost of running a cage, jail, and feeding the hapless people stuck inside. While the political answer is taxation, the layman's answer is they take property by force. In California, that would mean taking it from over 35 million people. Incidentally, taxation in the political sense is also the taking of property by force. However, such theft is considered legal. In other words, to punish and pay for one act of forcibly taking property, crime, bureaucrats commit the same act, crime, over 35 million times. And this does not include property forcibly taken from so-called corporations. You've heard the saying, 2 wrongs do not make a right. Well, I'd like to update that. In legal land, it's 35,000,001 wrongs do make a right. This is then hailed as justice and printed up in fancy law books. This does not mean I advocate the forcible taking of property, quite the contrary. I think robbery is always wrong, whether one is wearing a costume or not. Bureaucrats wear uniforms. Non-bureaucratic robbers wear stockings on their heads. Robbery is robbery, whether done by an individual man or ostensibly by majority vote. A good analogy is this. You have 2 children, and you don't want the older child hitting the younger child. The older child hits the younger child anyway. To punish the older child, you spank him. This is even better if, while spanking him, you yell at the child, "Haven't I told you not to hit your brother?" However, to more correctly demonstrate how bureaucrats operate, imagine the same situation, but instead of spanking the older child, you send him to his room and hit both the younger child and your spouse. You could then go door to door in your neighborhood, hitting everyone else. If anyone complains, you just tell them it's the only way to punish your older child, or it's the best system of justice in the world, and if they don't like it, complain to your congressman. Bureaucrats never have a case, despite all appearances to the contrary. If a man commits armed robbery and gives part of the money to some poor people, he is still an armed robber, and his action is no less heinous. The act itself does not change if he frolics around like a nitwit, calling himself a so-called sovereign. In legal land, theft is okay. Armed robbery is SOP, standard operating procedure. This will be shown in greater depth later on. For now, I just want to point out the following. This will show theft is considered okay with a cool-looking badge and an antisocial attitude. Quote, "A person commits theft if, without lawful authority, such person knowingly controls property of another with the intent to deprive him of such property." Arizona Revised Statutes, Section 13-1802. Close quote. Only in legal land can the exact same act be a crime and not a crime. This is a classic example of distorting and adding to reality. Let's see what happens when we unravel this example of bureaucratic reasoning to see how far it extends. Arizona Revised Statutes, Section 13-1105. First-degree murder classification. A person commits first-degree murder if, without lawful authority, intending or knowing that the person's conduct will cause death, the person causes the death of another with premeditation. Arizona Revised Statutes, Section 13-1508. Burglary in the first degree classification. A person commits burglary in the first degree if, without lawful authority, such person or an accomplice violates the provisions of either Section 13-1506 or 13-1507 and knowingly possesses explosives, a deadly weapon, or a dangerous instrument in the course of committing any theft or any felony. Arizona Revised Statutes, Section 13-1410. Molestation of child classification. A. A person commits molestation of a child if, without lawful authority, by intentionally or knowingly engaging in or causing a person to engage in sexual contact, except sexual contact with the female breast, with a child under 15 years of age. B. Molestation of a child is a Class 2 felony that is punishable pursuant to Section 13-604.01. Arizona Revised Statutes, Section 13-1904, Armed Robbery Classification. A. A person commits armed robbery if, without lawful authority, in the course of committing robbery as defined in Section 13-1902, such person or accomplice, 1. Is armed with a deadly weapon or a simulated deadly weapon, or 2. Uses or threatens to use a deadly weapon or dangerous instrument or a simulated deadly weapon. B. Armed robbery is a Class 2 felony. Arizona Revised Statutes, Section 13-2903, Riot Classification. A. A person commits riot if, without lawful authority, with two or more other persons acting together, such person recklessly uses force or violence or threatens to use force or violence, if such threat is accompanied by immediate power of execution, which disturbs the public peace. B. Riot is a Class 5 felony. And finally, Arizona Revised Statute, Section 13-1402, Indecent Exposure Classification. A. A person commits indecent exposure if, without lawful authority, he or she exposes his or her genitals or anus, or she exposes the areola or nipple of her breast or breasts, and another person is present, and the defendant is reckless about whether such other person, as a reasonable person, would be offended or alarmed by the act. This has special applicability to former presidents. While there may be a generous amount of sarcasm here to make a point, think about this. What is more damaging to people, theft or indecent exposure? Which one would you prefer to see licensed? Asking questions can be a very effective way of getting to the truth. It's how we learn. I keep 6 honest serving men. They taught me all I know. Their names are what and why and when and how and where and who. Rudyard Kipling. I think if a person is afraid to ask a cop or a judge some questions, then it may just be that part of them is already convinced they are not dealing with a benevolent individual. If someone has a problem answering a few questions, then there are only one of two things going on. The individual has no answers or the individual is withholding the answer. In either case, it is difficult at best to maintain a perception of legitimacy. This is the case if the bureaucrat gets angry with you for doing no more than asking a question. What kind of individual threatens a man with violence, such as contempt for doing no more than that? When tyrants cannot prevail by deceit, they burst into open rage. Geneva Bible, Note I, Exodus 1:22. I helped a man in Washington with a criminal traffic case. The cop claimed this man was within the state. When he asked the cop what facts he would base this opinion on, the judge said the witness could not testify, and if any more questions like that were asked, he would have this man held in contempt. This, of course, is legal land speak for having an armed man violently place him into a cage for the vicious crime of asking a question. It's similar to saying collateral damage for the cold-blooded murder of men and women and children known politically as civilians. Can you imagine a law making it a crime to ask a bureaucrat a question? Take the robe off the judge and imagine the same thing in a slightly different context. I'll use Sears as an example because it can be extremely difficult for people to stop deleting from, adding to, or distorting reality. In other words, just changing the name from City of Phoenix to Sears can help to negate all your previous conditioning, at least for the sake of this illustration. You're at Sears, and an employee, cop, pulls a gun on you claiming you cannot leave Sears because you owe Sears $500. You say you don't understand why he has made this claim, so he gets upset and calls other employees, backup, and his manager, the judge. The employee tells the manager you owe Sears $500 and you refuse to pay. You then ask the employee to tell you what facts led him to believe you owe $500. What did you allegedly purchase? The manager then yells that the employee cannot answer, and if you ask any more questions like that, you are going to be held against your will. Jail. If you look at what happens in a traffic case, if all you do is replace the name with Sears, then you may start to see the true nature of what is happening. Here's another example. I helped someone in Sacramento. The judge was an older man named Joe. Joe refused to allow me to help this person at all. Joe threatened me with physical violence, contempt, if I spoke. And mind you, this was not to Joe, but just quietly conferring with the man I was helping. How was that for antisocial behavior? Would you cage a human being for speaking? After the hearing, I politely told Joe, I think your threats were unprofessional and unwarranted. Joe was not pleased and called a deputy to throw me out of his courtroom. Outside the courtroom, I spoke with the man I was helping and opposing counsel. This armed deputy approached me again and told me I had to leave the building now. I said I was talking to someone and wasn't ready to leave. This armed man then threatened to arrest me if I did not leave. I asked him why and said, am I in contempt of the building now? He made an approach and I told him to back off because I was leaving. As I was leaving, I asked who the presiding judge was and where his courtroom was. It was a lawyer named Parks and he was across the street. I found out Judge Parks was on the 6th floor and we got into the elevator. Before the doors shut, 2 cops running full speed got into the elevator with us. We spoke to them and learned that they were on a call up to the 6th floor. Along the way, another cop who ran to the elevator got on. At the 6th floor, all 3 cops ran out and were joined by 2 more cops. We walked out and followed them because we had learned in the elevator that they too were headed to Judge Parks' courtroom. As it turned out, they were called about me, though they were still unaware. After looking around for a few minutes, totally confused because there was no perp around, the youngest cop eventually asked me if I was thrown out of the building across the street. I answered yes. He asked me who threw me out and I said, Joe. This cop looked very puzzled and asked who Joe was. I said, he's the guy who wears a black robe and sits 4 feet off the floor. For some reason, this really upset him and he snapped back, you mean the judge? I replied that I don't look at Joe as a judge. To me, he's just Joe. I was escorted out of the building and all I wanted to do was speak to the presiding judge regarding my getting thrown out of the first building for no reason. However, just referring to the judge as Joe had a profound psychological effect on this cop. And why is that? Because he was no longer following the judge's orders, just Joe's. Not too easy to justify violence in the name of Joe, is it? There are several other points of interest here. I was thrown out of the building across the street by Joe. Despite 5 cops running full bore to Judge Parks, no incident report was filed and Joe was not brought up on charges by anyone for calling in a false report to the police. Say what you want about being thrown out of a courtroom, let the baby have his courtroom, but to also be thrown out of the building as well? And what about the building across the street? Exactly how far outside the courtroom does this superhuman power called contempt extend anyway? Maybe World War II could have been avoided by having a traffic court judge declare Hitler to be in contempt. Notice, too, I was in the elevator with the cops, and they had no idea I was the object of their call. I must have been a real subtle threat that even the discerning eye of professional law enforcement could not pick up. And why no incident report? Probably because there was no incident, at least not caused by me. I spoke to the captain of those 5 courageous cops the next day, and he asked why I didn't speak to him the previous day while in Sacramento. I told him, frankly, sir, because here in Arizona, I'm out of range of your guns, that's why. Last, Joe was not brought up on any charges of calling in a false police report. If I had done that, you can rest assured, I would have been charged and convicted in short order. But why not Joe? My lay opinion, based on years of experience dealing with bureaucrats, is the law is not applicable to bureaucrats, while it is applicable to the productive of society they seek to rape, pillage, and plunder. I've also provided the California Attorney General's office with documentary evidence of felonies committed by lawyers and have never gotten so much as a letter of acknowledgement. You would think that they would want to arrest me for filing a false report. In either case, a felony was committed. So much for their zealous enforcement of the law. It is also interesting to note the Judicial Conduct Commission did absolutely nothing with my complaint about Joe. Chapter 3. Never disagree with them. Zen in the art of litigation. I believe this is critical. I don't want these people ticked off at me any more than they already are. I could go to jail or worse. While I have been threatened with contempt many times, I have not been thrown in jail for it. However, I do not think going into court and being argumentative is effective. If I disagree with a judge and tell him he's wrong, he's just going to sneer at me. You can appeal. If I keep disagreeing with him, then he's probably going to start threatening me with physical violence and contempt. The result is that I do not think disagreeing with a judge accomplishes anything positive. It only gets me labeled argumentative, and I am viewed as an opponent. Bureaucrats already view non-bureaucrats, productive people, as the enemy, so I don't want to help confirm this opinion. This is a very real us and them attitude with bureaucrats, especially with cops, and arguing with them doesn't do me any good and it might cause me harm. I know this from personal experience, having known many people who are or were cops. If a judge snaps he has jurisdiction over me, then I don't tell him he is wrong. As will be shown below, that's an opinion the judge can deny. It's far more effective to just ask him to explain factually where, when, why, and how his so-called jurisdiction over me was acquired. I want to know where, when, why, and how it happened so I can possibly avoid it in the future. I put the burden where it belongs, on the unproductive individual seeking to forcibly take my productive time. I call this Zen in the art of litigation. I am no longer the opponent. It's pitting the bureaucrat against himself. There is no fighting, arguing, or other resistance, just asking for the facts and watching a bureaucrat's confidence collapse along with his pretended case. He may still be violent, but his confidence is declining steadily. It could probably be a mathematical formula. Whereas a bureaucrat's confidence drops, his level of anger and violence rises. A very effective question in this regard, and one I've never had a responsive answer to, is this. Except for physical violence, how was your alleged jurisdiction over me acquired? This question may not be denied or rejected because there is nothing to deny. The judge has 2 choices here, as with any question. He is either responsive or he is not. If he's not, I don't really care because then he's showing his true colors. In a sense, without answering, he is answering. He could just keep refusing to be responsive. That's okay. Every time he does this, his pretense of good faith and fairness wears a little thinner, as does the patience of anyone taking his charade seriously. And that is the point here anyway. I cannot actually win. I'm in damage control, and I can only frame and ask questions designed to cause him to damage his pretense of good faith by not being responsive. This is a no-win situation for the cop and the judge. The questions are framed to box them in and expose the fact there is no case against me, unless baseless legal opinions, political gibberish, and fantasies constitute a case. Of course, despite no evidence or even a hint of fairness, cases can be lost. After all, this is legal land. This just proves justice and fairness is not the end goal of bureaucrats. No, the end goal is domination and taking property by force. The rule may be expressed in this manner. Their purpose is to steal as much property as possible using the least amount of violence. Some judges like to respond to such questions with claims the Supreme Court gives them the authority or jurisdiction over me. This usually sedates people, and that is the end of the issue. However, this is still non-responsive. I have asked for the facts, not some obscure collective opinion of a bunch of lawyers doing business as a Supreme Court. A Supreme Court opinion is just that, an opinion. The opinion of a lawyer and a bureaucrat. It's not a statement of facts. Yes, it may contain a statement of facts, but that usually has nothing to do with me. A good example is Marbury versus Madison, decided about 200 years ago. Factually, this case has nothing to do with me or the absurd claims some cop may have made against me. It comes down to this. Who cares what a bunch of dead lawyers and bureaucrats think anyway? Do you really trust lawyers and bureaucrats? And if they are taken seriously, then why? Anyone familiar with bureaucrats knows it's not necessarily the opinions of dead lawyers that's the problem. It's usually the bureaucrats trying to ram those opinions down your throat at the barrel of a gun that's the problem. Why would anyone care what a bunch of dead lawyers wrote 200 years ago if there wasn't any physical violence behind it today? After all, with enough physical violence behind it, anybody could force anyone to accept anything as the law. If a gun is put to your head, then anything the individual with the gun says is now the law. The point here is that it's not so much the written word that's the law to be obeyed, it's the physical violence backing the bureaucrats' whims at the moment. One reason why people in Florida ignore the edicts or pretended law of Fidel Castro is because they are out of range of his guns. Another is probably professional courtesy on Castro's part. Professional courtesy may also help to explain why the California Franchise Tax Board only steals, the lay sense, from people in California and not in Mexico. Just by agreeing with bureaucrats and asking them to provide the facts on which their opinions are based sets them up for a fall. By doing so, they cannot convince any rational person I am being argumentative or putting forth, as they would quote, patently frivolous legal arguments long rejected by the courts. They are either responsive or they aren't. Either way, their case is breaking down fast. Everything the state says is a lie, and everything it has stolen. Friedrich Wilhelm Nietzsche. Chapter 4. Never give them something to deny. This is simple. If I give a judge something to deny, then he will. This lawyer wants my valuable time, and it's very easy for him to deny absolutely anything and everything and then snarl at me, "You can appeal." I realized this after a criminal traffic trial in a Mesa Justice Court, now that's an oxymoron, in 1995. I thought there was no way I could lose. I was charged with committing the heinous crime of failure to produce ID. How the people of Arizona survived that crime spree is a testament to both the resilience of the people and the bravery of their finest public servants. There was no less than 5 at the stop. Who knows what would have happened had I been just allowed to go home that night. I went with a Supreme Court opinion called Brown v. Texas, 443rd U.S. 47th, 1979. It held you could not be arrested for not providing ID to a cop. How could I lose? I read the relevant parts of the judge, and he sneered down at me with contempt. "That's your interpretation." I was stunned. I had read from the opinion verbatim, and he claimed it was only my interpretation. Needless to say, I lost, and that is how things tend to go in legal land. The point is, arguments and opinions can be denied, and now the bureaucrat can say they have been responsive, they just disagree with me. In legal land, this is enough to satisfy so-called due process requirements, or what is more accurately termed the pretense of justice and fairness. So, if I have to put forth an opinion or an argument, I just use one the judge and the cop have used. I send it right back to them as a question. Feed their testimony back to them in question form and then sit back and watch it all fall apart. For example, I asked a clerk in an Arizona city court if a photo radar ticket was a civil case. She said yes, that she had written the ticket. I then said, "Is this in the nature of a contract dispute or a tort?" She started to stutter and stammer and finally spit out that she had no idea. From her own mouth, there was no case. At that point, all I had to do was ask her if there was a cause of action against the friend I was helping. How could she answer this question when she had no idea if the case was in the nature of a contract or a tort? Chances are she would answer yes, that's fine. I now have 2 conflicting opinions. Not only did I have 2 opinions that conflict, but, just as important, neither one is mine, so I am not the opponent any longer. Pit the bureaucrat against himself. It's now a question of which opinion will be rejected. Bureaucrats, such as judges, just love rejecting and denying anything a non-bureaucrat puts forth to defend themselves when attacked, whether in traffic court or with the IRS. This is because there is a predetermined outcome. That being the case, I only give them their own opinions and fantasies to deny. It's like watching a dog chase its own tail. Question: how do you make a bureaucrat chase his own tail? Answer: agree with him. Chapter 5. Take away the judge's discretion. One key to being effective is to take advantage of the so-called rules used to maintain the pretense of fairness. I want to do and say things that will put the judge in a position where he or she really has no choice. He has to either admit there is no case against me, or he is going to make a huge mistake or error in procedure that even the lawyers doing business as the appeals court cannot easily look past. One way to do this is to question the cop so his two lawyers, the prosecutor and the judge, have him declared incompetent, incapable, or unable to testify. This is very easy to do, and I've done it every time. I never have to declare this. The judge and the cop's other lawyer do it for me. Actually, the judge represents everyone, plaintiff, plaintiff's lawyer, and the defendant. The specifics on how I've had every witness declared incompetent or unable to testify is described in later chapters. When the judge does rule the cop may not testify, then I ask if his testimony, including the ticket the cop wrote and any police report relied on, should be stricken from the record to be consistent with the rules of evidence. In Arizona and federal rules of evidence, Rule 602 requires witnesses to have personal knowledge of facts or they may not testify. This, of course, is a basic rule of fairness. I do not tell the judge to do anything. I only ask him if the testimony should be stricken in order to be consistent with the rules of evidence and fairness. The judge is really on the spot now. This is because under their so-called adversary system, a judge allegedly has no discretion to declare a witness incompetent to testify and still rely on his testimony. Without too much legalese, it's unfair to rely on a witness who is not competent to testify or rely on a witness I cannot question. Remember, it is not my opinion the witness could not testify. It's an order of the court, meaning it's the judge's opinion. That usually means that unlike my worthless, legally defective, non-lawyer opinions, bureaucrats are supposed to respect and comply with them. After all, when an honorable lawyer gives an opinion, it's the law. If the judge refuses to be consistent and accepts the testimony anyway, then I have two conflicting orders of the court. One is wrong. Which is it going to be? I don't care which one as long as the reviewing lawyers are responsive and consistent. If I still lose, then consider my appeal. There are no opinions of my own to bring forth for an appellate judge to deny as frivolous. I just lay out the two conflicting opinions of the judge that ran the case. The judge declared the witness is incompetent to testify, and the same judge relied on the testimony of that same incompetent witness. This, in a sense, sanitizes the case on appeal. It's no longer a traffic case no one cares about. It's an issue of evidence and fairness. This is especially important in tax cases. The lawyers reviewing the appeal, commonly called appellate courts, hold the opinion that great weight should be given to a trial judge's determination of a witness's credibility. One example of this is found in Re. Estate of Shumway, 197, Arizona 57th. Well, the problem here is there is not one determination, but two, and they contradict each other. I say, go right ahead. Give great weight to the judge's determinations, only give great weight to both of them. He said the witness could not testify, not me. If the reviewing lawyers fail to give great weight to both decisions, then there is a failure to review. This sets up a no-win situation for the judge. In either case, there is a denial of cross-examination. If he was wrong to decide the witness could not testify, then the refusal to permit me to question him, cross-examine, is fatal to the decision and incurable. If he was correct, then relying on his testimony is fatal to the decision. If I have to appeal, then the appellate lawyer, usually not the prosecutor from the traffic court, has to defend the judge's actions. If he is responsive, he has to justify the judge's conflicting opinions. He has to justify why the witness could not testify and be cross-examined, and why the judge relied on his testimony anyway. He has to argue that denial of cross-examination of the only witness is somehow not an error. This is why I have only had one appellate traffic brief filed against me or someone that I have helped in 7 years. That brief was filed by a lawyer in Arizona, and he misrepresented the truth. This lawyer just flat out lied, claiming I never asked the cop about the facts. At least 5 witnesses would disagree with this lawyer. However, this is legal land, where the facts are usually not relevant, only arbitrary political opinions backed by a gun. In fact, in legal land, the facts and the truth may even be seen as unimportant to a determination of the facts. This is shown by many cases, such as U.S. v. Steppard, 876, Federal Supplement, 214, District of Arizona, 1992, where lawyers decided that anything offered by a certain non-lawyer was legally defective, for no other reason than because he was not a member of a bar association. Lawyers routinely ignore anything brought forward by anyone who is not a member of their labor union, gang, clique, or organization, usually known as a state bar. Quote, "What Carroll purported to do for Paul in place of a lawyer was a nullity." End quote. People ex relatione, Department of Public Works versus Malone, 232 California Appellate 2nd, page 531, page 537. When is a rock not a rock? When a non-lawyer makes the claim or presents the rock, facts, to a judge, or it's called a nullity. Judge says, just ignore it. Their political allegiance is not the same as ours, so let's just disregard everything these non-lawyers say or do on anyone else's behalf. In legal land, it's not a rock unless a lawyer hands it to another lawyer pretending to be a judge. I'll bet if a non-lawyer hit a judge in the forehead with a rock, he'd drop his legalese really fast. He wouldn't consider the lumps on his head to be a nullity. Just how many times does a non-lawyer have to hit a lawyer with a rock before he stops considering the rock legally defective or a nullity? Let's use the same reasoning these lawyers use in another context. Let's say I cut a friend's hair and charge him $10, but I don't have a so-called license. Quote, what Carol purported to do for Paul in place of a licensed barber was a nullity. End quote. How about building a house? What Carol purported to do for Paul in place of a licensed contractor was a nullity. What happens to the house in such a case? Does it magically disappear to be consistent with the lawyer's opinion? Would the hair suddenly grow back because a judge declared the haircut a nullity? Would it disappear if he was reversed by an appellate judge? My gosh, what would happen to a man who had heart surgery by a doctor whose license fee was, gasp, lost in the mail? If a pilot lets his license lapse, would a plane he was allegedly flying suddenly plummet to the earth, killing everyone on board? Is a dog without a license really a dog or another nullity? If I drive without a license, is that a nullity? If so, then where is the crime? Can a nullity really be a crime? A nullity is defined by lawyers as something without legal effect, being null. Ballantyne's Law Dictionary, page 871. And null is defined as non-existent, void, of no legal effect, page 871 supra. If it's non-existent, then where is the alleged crime? Quote, what Carol purported to do for Paul in place of a licensed driver was a nullity, end quote. What I see is that there are two kinds of truth or reality in legal land, i.e. legally defective truth and legal truth. I call this selective reality, what lawyers call legally defective truth. It can then be cast aside and ignored. After all, what does truth have to do with due process and the finding of facts anyway? Come to think of it, both the state and the United States were allegedly created by millions of non-lawyers. Would that make the United States a nullity? Bureaucrats want reality to conform to their opinions instead of letting their opinions conform to reality like normal people. Chapter 6. Never argue the merits. I personally don't care what a cop has actually charged me with. I think the opinion, or charge as they call it in legal land, is irrelevant. The real issue is his method of operation vis-a physical violence and threats of physical violence. There is no way to use physical violence and still maintain a pretense of fairness or good faith. One's gotta go. Remember, those who attack the rationale of the game and not the players are its most formidable adversaries. James J. Martin. Arguing whether or not I have a driver's license or ID takes the attention away from the fact that they are using physical violence and threats of physical violence. The whole situation is unfair, so why argue any alleged merits? Who are they to force me to do or say anything? That is the real issue. A good analogy is a mobster convincing a businessman his business needs protection. He'll make him an offer he can't refuse. Maybe he'll threaten him with contempt. However, the protection is not where your focus should be. It's the coercion, the taking of money by force. The so-called protection is a superficial part of this violent scheme. It gives the illusion of a service, and there is less attention given to the taking of one's property by force. It's called sleight of hand. It's not the economy. It's the coercion. Can you imagine arguing with a mobster that he failed to protect you? The point is the actual charge is irrelevant because the nature and basis of the relationship is violence. As will be shown in later chapters, the central and most important issue here is, what is the nature of the relationship? If the relationship is based on violence, then why bother trying to reason with them? Complaining and rambling on about civil rights usually doesn't stop carjackers. After all, don't bureaucrats, or the state, if you will, operate in the same manner as the mob? Let's say you want to start a business, such as a barber shop. You open your shop and start cutting hair on a voluntary basis. Several weeks go by, and one day a bureaucrat strolls in and sees that instead of licenses hanging up on the wall, there are pictures of prominent mobsters. He tells you that you need a license to be a barber. You tell him you've been profitably cutting hair for weeks with no complaints. Apparently you can be a barber without a license. He then makes you an offer you can't refuse. If you don't get the license, the city will shut you down. This means armed men will stop you, violently if necessary, from entering into mutual voluntary agreements with your customers to cut their hair at a mutually acceptable negotiated price. What a crime! Such a sadistic animal doesn't deserve a trial. What is ironic is at least the mob is ostensibly offering protection, while the bureaucrat offers nothing in return. Yes, the public may think licenses are necessary for protection, but as will be shown in the conclusion, there is no duty to protect anyone. It's an insolent lie. Licenses are about domination and money. You pay the license czar, or you are violently shut down and, quite possibly, depending on the nature of the accusation, forcibly thrown into a cage. And why? Because you had the audacity, yes, even the temerity, to provide a valuable service on a voluntary basis. Now, that certainly warrants the use of violence, does it not? Because the relationship is based on violence, the actual charge is irrelevant. This, however, does not imply that if somebody damages another person or their property, they should not be held responsible. Force cannot give right. Thomas Jefferson, The Rights of British Americans. Chapter 7. About the so-called judge. Going to court can be very intimidating. I think things are set up for that very purpose. After all, why else would a lawyer have to wear a black robe and sit 4 or more feet off the floor? If that's not enough to intimidate you, he also has an army of heavily armed men to carry out his every whim without exercising any personal discretion of their own. The judge is also free of all personal liability for his actions against you. From personal experience, cops appear to worship judges and believe judges can do whatever they want while on the bench. How do I know this? Cops have told me this themselves. Cops also believe they are somehow relieved from responsibility for their actions if done while on the clock or if ordered to do so by an honorable lawyer. That's the old, I was just following orders excuse. While this was rightfully rejected at the Nuremberg trials of the Nazis for crimes against humanity, it is still a standard defense with bureaucrats here. I called the cops on a judge while in the Peoria Justice Court back in 1998 for a breach of the peace. The cops showed up and asked me what was going on. I told them a man was threatening me with physical violence. I told them who it was and was told, he's the judge. He can do whatever he wants. We can't touch him. I said, really? What if he starts smoking crack up there on his bench? The cop, a little ticked off at that remark, said, sir, he can't do that. Then I said, now that we determined he can't do whatever he wants, let's see about arresting him for a breach of the peace. The cop still refused to do anything. Why? Because the laws don't apply to everyone, as bureaucrats would have us believe. The time-worn line that nobody's above the law is political rhetoric or just plain old BS. In the real world, there are plenty of examples where bureaucrats do not follow their own so-called laws. If you don't believe me, ask a cop or bailiff who works in a court what you can do if a judge threatens you with violence. For anyone who thinks I'm being too critical or I am divorced from reality or in an alternate reality, turn it around and imagine that I was the one doing the threatening. And keep in mind that threatening violence is considered a crime. Arizona Revised Statutes Section 13-1202. Threatening or intimidating classification. A. A person commits threatening or intimidating if such person threatens or intimidates by word or conduct. 1. To cause physical injury to another person or serious damage to the property of another. Or a person commits threatening or intimidating if such person threatens or intimidates by word or conduct to 2. Cause, or in reckless disregard to causing, serious public inconvenience including, but not limited to, evacuation of a building, place of assembly, or transportation facility. Or a person commits threatening or intimidating if such person threatens or intimidates by word or conduct. 3. To cause physical injury to another person or damage to the property of another in order to promote, further, or assist in the interests of or to cause, induce or solicit another person to participate in a criminal street gang, a criminal syndicate, or a racketeering enterprise. B. Threatening or intimidating pursuant to subsection A, paragraph 1 or 2 is a class 1 misdemeanor. Threatening or intimidating pursuant to subsection A, paragraph 3 is a class 4 felony. Notice this does not contain the phrase, if without lawful authority. Going to court is less intimidating if you remember the judge, contrary to what cops may believe, is only a lawyer wearing a black robe and sitting 4 or more feet off the floor. Isn't it funny that the Wizard of Oz was just a man behind a black curtain, or robe, if you will? Interesting parallel, don't you think? The cop, on the other hand, is just a man with a gun who, more often than not, blindly follows orders for a paycheck. Everything beyond that is probably just going to be an opinion or fantasy, such as jurisdiction. Remember, don't distort, delete, or add to reality. This is where they start to have a more difficult time. The bureaucrat is trying to maintain a pretense of fairness to conceal the violent nature of his proceedings. This is not an easy task for anyone. In my experience, the pretenses usually drop very quickly and they resort to violence or threats of violence in most cases. So-called jurisdiction is an issue where a bureaucrat will usually get upset when challenged. Although a judge will always vehemently maintain he has jurisdiction over me or some other non-bureaucrat in his court, this judge will not be responsive to questions as to how this jurisdiction was acquired. Getting upset and threatening violence, so-called contempt, is part of the intimidation process, just like the wizard did. I think the resulting fear is, of course, intended to keep people from questioning what is going on. If questioned, people might start to see the hoax being perpetrated on them. If so, they might begin to withdraw their support as a result. A good citizen is someone who doesn't question what his public servants are doing. A good citizen leaves everything to the alleged authorities. He obediently listens when they scream, "Pay no attention to the man behind the black curtain." Traffic cases are either civil or criminal, although, in my legally defective non-lawyer's opinion, this is a superficial political distinction and nothing more. The only real difference is the amount of time they are planning on stealing from you, and the level of violence they are intending on using or are prepared to use against you. Bureaucrats tend to use more violence in so-called criminal traffic cases, they arrest you, hold you in a cage for ransom, politically known as bail. There is also a chance that if found guilty, they may want to cage you for a period of time. The benefit, if any, of having a so-called criminal case against you is there is more of a pretense of fairness provided in their pretended rules. Examples are probable cause, hearings, pretrial discovery, juries, and rules of evidence. These alleged rules are not absolute. In my experience, these rules mean nothing to lawyers and bureaucrats, unless as a ruse to take your productive time. If these rules get in the way of a bureaucrat taking property, then guess what happens? The bureaucrat ignores the rule and moves on. A great example of this is with what bureaucrats call jurisdiction. The lawyers doing business as the Supreme Court have ruled many times the burden of proving jurisdiction is on the plaintiff. Quote, "Federal courts are courts of limited jurisdiction. They possess only that power authorized by the Constitution and statute, which is not to be expanded by judicial decree. It is to be presumed that a cause lies outside this limited jurisdiction, and the burden of establishing the contrary rests upon the party asserting jurisdiction." Cases cited in, quote, Willie v. Coastal Corporation, Bender v. Williamsport Area School District, American Fire and Casualty Company v. Finn, Turner v. President of Bank of North America, and McNutt v. General Motors Acceptance Corp., as an included reference in Kokinen v. Guardian Life Insurance Company, U.S., 1994, page number 93 to 263. Thus, the entire burden of proof in so-called criminal cases is supposed to be on the plaintiff, and that burden of proof is supposed to rise to the level of what lawyers call beyond a reasonable doubt. However, challenge so-called jurisdiction in a traffic court and the judge in every instance will obediently do the very opposite of the alleged supreme law of the land by assuming it for the pretended plaintiff or lawyer claiming to represent the plaintiff. I have never seen or heard of an occasion where a judge turned to the cop or prosecutor and said, "How about it? What facts do you rely on to prove jurisdiction?" Even in cases where I have won, this has not happened. Just change the names here from State of Arizona versus Stevens to Tooth Fairy versus Stevens. If I challenge jurisdiction in this case and the judge jumps in claiming he has jurisdiction, it's clear the judge is representing the Tooth Fairy. It doesn't take a rocket scientist or a Juris Doctor to understand this is unfair, but the rules don't apply to bureaucrats because we're now in legal land. And why should they follow their own rules? It's very short-sighted to think violent people will always follow the rules, if at all. Violent people, as a rule, typically have no use for rules. Unlike normal people, they use violence to get their way. It's an example of bureaucratic nonsense, such as the rules of war. If these individuals followed rules, there would be no wars. I've had judges tell me straight out that the rules do not apply to them. That's right. traffic judges have told me the Arizona rules of procedure in civil traffic violation cases did not apply to an Arizona civil traffic violation case. I've also asked, then which rules do apply here, and have been threatened with contempt. However, with the fear instilled by this judge's violent ranting and threats, how many of the people waiting behind me challenged him in any way? Bureaucrats use violence and threats of violence because it works in most cases. They get what they want from the productive without having to be productive. If a case has been labeled civil, the following questions have proven very effective. This is only with regards to exposing the truth, separating fantasy from reality. Remember, there is no real way to win with bureaucrats. It's all about damage control, just limiting your exposure to them. Going in and disagreeing with them will make bureaucrats, or anyone for that matter, defensive and is counterproductive in my lay opinion. They label me argumentative and use that as an excuse to run over me, as if being argumentative somehow relieves bureaucrats of their professed duty to be fair. You're entitled to a fair trial as long as you keep your mouth shut. You have the right to an attorney as long as you're not argumentative, etc. At the initial appearance, the judge may ask me what plea I would like to enter, responsible or not responsible. This alone is degrading and certainly makes me appear to be the victim of this entire process. I like to say that I intend on pleading responsible. However, I am not a lawyer, so I don't understand the nature and basis of the charges and the proceedings, and I then ask, is there evidence of a complaining party? This is one of many loaded questions I ask, so I always expect an emotional response. If you are not yet convinced what is being done in a so-called traffic proceeding is criminal, you may be very soon. This is why it is very important to bring witnesses and a court reporter to court. People will not believe what happens in response to such a seemingly innocent question. The judge, however, may not fully understand what I am asking and may say, the state of Arizona, of course. If so, I politely inform him, that is non-responsive. My question only required a yes or no answer. I did not ask if there was a complaining party. I asked, is there evidence of a complaining party, yes or no? I have never had a judge answer this question. No one I have worked with has had a judge answer responsibly either. Judges react violently and threaten to forcibly put me in a cage. In the real world, this alone is a denial of a fair trial and evidence this violent individual has no intention of being fair. If he answers this question by saying yes, I would then ask, okay, what is that evidence and who gave it to you? Also, why are you relying on it without challenge? Facts and opinions are two separate things, and I'm supposed to be permitted to confront and question all witnesses against me. The most evidence that could be shown here is an opinion made with regards to other people who live in the same geographic area as me made by a cop. I can guarantee that if I live in the same area that they don't represent me as a part of any so-called state or otherwise. For those who may disagree, consider this. Can someone really represent me if I don't freely consent that they should do so? Represent me against my will? That's insane, even if it's alleged to be for the good of the whole. That would mean the cop represents me, or the very person he gives a ticket to. Does anyone think a slave monger represents the people he claims are his slaves? To represent me, or anyone for that matter, there must be something called a principle, agent relationship based upon mutual voluntary consent. This means I direct the agent and I may be held personally responsible for the agent's actions. Have you ever tried to hold a congressman responsible for not voting the way you want him to? Then does he really represent you? To represent means to stand in place of. Ballantyne's Law Dictionary, page 1095. Just who is this pretended prosecutor, rather persecutor, or cop, standing in the place of? Certainly not me. The phrase, the state, is an alter ego, or doing business as, for men and women who do business using physical violence in a given geographic territory. I have found that the cop, lawyer, and judge use the same alter ego. Now, how's that for fairness? For those who claim I am being irrational here, who do all three proudly claim to represent? The cops and judges put forth the opinion the cop somehow represents the people. However, in support of that allegation, they will put up about as much evidence vis-a-vis tangible facts to support the opinion they represent the people as I can. None, absolutely nothing. It is physically and psychologically impossible to stand in the place of hundreds of people, let alone millions. How can someone stand in my place if they have never had any contact with me? I once asked a prosecutor in the Phoenix area to give me the names of the people from Page, Arizona, he was allegedly standing in the place of. You can guess his response. And yet he had a burden of proof that is supposed to be beyond a reasonable doubt. If anyone doubts this is an element of a so-called crime or civil cause of action, then consider who the victim or damaged party is supposed to be. If anyone thinks it's easy or even possible to represent a few hundred people, consider how many times the honorable lawyers doing business as the United States Supreme Court have ever agreed on a single issue. There are only 9 of them, and they have rarely been unanimous in their agreement about anything. If 9 people rarely agree on a single issue, then what is the possibility that millions will ever agree about anything? Not likely. This is why there are so many major fast food chains, because people don't agree and are free to choose. Amazingly, all are in business at the same time, make a profit, and don't put a gun in your face when they hand you your tacos or special sauce. Another example which effectively demonstrates the idea that prosecutors represent everyone is a myth and a hoax. It's clear that despite whatever opinion you and I may have held about O.J., there were plenty of citizens who did not want to see O.J. put on trial. I would venture to say that there were tens of thousands, if not hundreds of thousands, of such people. Was Marcia Clark standing in place of those people? The answer is obviously no. She was not representing or speaking for them. When Marcia Clark claimed to be representing the state, it is clear state of California does not mean the whole body of people politically referred to as citizens and residents in California. If you get a traffic ticket, do you think the lawyer playing prosecutor, or the cop for that matter, is standing in the place of you, your spouse, and best friend? Not possible. In legal land, it doesn't matter that a prosecutor is standing in the place of no one except maybe the cop and the judge, because all he has to do is to give his opinion, and that is enough. In legal land, the opinion of a bureaucrat is a substitute for facts. The irony is, when I present facts, they are labeled time-worn legal opinions. In Arizona, the cop signs the ticket as the complainant, allegedly representing the people. However, this is only an opinion, leading to the next question. Isn't that just an opinion? Depending on the answer, I could then ask, is there evidence, that is, facts, to prove this cop represents this group of people? This is also a yes or no answer. I could then follow up with, what evidence is that, and who provided it, if the answer is yes. If no, then there is no evidence of a complaining party and no case. Any citations to law or the Constitution are non-responsive to the question because those are more political opinions. As subsequently shown herein, if the judge wants to rely on a Supreme Court opinion as evidence of jurisdiction, that's okay, as long as I can cross-examine those lawyers whose opinion he's relying on. I would then ask him again and also tell him a responsive answer is desired. I may even politely ask the judge if he knows the difference between a fact and an opinion. I asked a guy named Paul from the Temple, Arizona IRS office this question, and he got very upset with me and suggested I leave the building. I only asked Paul the question because every time I asked for facts an opinion was based on, he would say, Mark, the courts have ruled... ... This is not a superficial or frivolous issue either. If it were, then bureaucrats would not get so upset and law dictionaries would not define both words. Fact, a deed, an act, that which is real, that which is true, an actuality, that which took place, not that which might or might not have occurred. Ballantyne's Law Dictionary, page 449. Opinion, an inference or conclusion of fact which a person has drawn from facts which he has observed. Ballantyne's Law Dictionary, page 893. Experience has shown this to be a very important issue. It's not unusual for lawyers, whether in suits, robes, or otherwise, in order to justify the most egregious facts, to label facts as opinions and call them frivolous. This is also a favorite tactic of so-called U.S. attorneys in tax cases. I have seen a statement such as, we received form letter ... on May 24th, 2000... described by a lawyer as being nothing more than a frivolous and groundless legal argument. It's one thing for a lawyer to make such an absurd claim, but quite another when a judge accepts it. I worked on a tax court case where the IRS lawyer filed a motion to dismiss and claimed the required lettered statement of facts was missing from the complaint. This was her grounds to have the complaint thrown out. We replied by pointing out the lettered statement of facts was A through T, comprising pages 2 through 8. The judge agreed with his fellow lawyer by denying reality and threw the case out. The interesting thing is that, on appeal, The alleged missing lettered statement of facts was not mentioned at all by the IRS lawyers. Why didn't these lawyers defend their position on appeal? You have to also realize that this is not an isolated incident, and if lawyers can get away with this in a tax case, then they can get away with it in rape and murder cases. Defendant: Your Honor, I couldn't have shot President Kennedy. I was born in 1979. Prosecutor: Your Honor, I object. That's a frivolous legal argument and should be stricken. Judge: I agree, and any more of those frivolous arguments, and I'll hold you in contempt. I'm still amazed at some of the opinions state lawyers throw out. It's as if they'll say anything they want to and feel they can get away with regardless of how divorced from reality it may be. But remember, this is legal land where deleting, distorting, and adding to reality is standard operating procedure. One recent tax case involved an appeal. The main issue was the denial of confrontation. The witnesses were not permitted to testify because they were determined to have lacked personal knowledge of the facts. Although the testimony, so-called assessment, is inadmissible under the California Evidence Code of 702, this law has never hindered a bureaucrat from accepting a fellow bureaucrat's testimony. Despite being an incurable error, as upheld in State v. Hanley, quoting Brookhart v. Janus and Smith v. Illinois, stating, denial of cross-examination without waiver would be constitutional error of the first magnitude, and no amount of showing of want of prejudice would cure it. This group of lawyers, also known as an appellate court, wrote instead, We presume there were other FTB or Franchise Tax Board employees who provided or could have provided the requisite foundation for admission of the documents in question and could have shown how the proposed taxes were assessed by the FTB. Unbelievable, isn't it? As far as these lawyers are concerned, it's perfectly okay to deny cross-examination as long as they presume there were more witnesses you were also not permitted to cross-examine. Just exactly who are these alleged witnesses? Let's not leave out the fact the FTB previously agreed there were no other witnesses, and the court was obligated to resolve all presumptions against the Franchise Tax Board. Yes, Mr. Simpson, you were not permitted to cross-examine Cato, but that's okay because there were many other witnesses who testified that we never told you about that you could not cross-examine either. Now that's fair, isn't it? Still want your life in the hands of honorable lawyers? It's no surprise the three lawyers who decided this case did not want it published or even cited by their fellow lawyers, honorable or otherwise. To conform to reality, the above case should read, denial of cross-examination without waiver would be constitutional error of the first magnitude, and no amount of showing of want of prejudice would cure it, unless, of course, we presume there were other witnesses that were also not cross-examined. You see, sticking to the facts makes bureaucrats commit blatant errors like the ones I just cited. Again, this is because their MO is coercion and violence while maintaining a pretense of fairness. Can you imagine the riots that would have ensued had O.J. been convicted at his criminal trial and then the same appellate court? Yes, the above quote is from a recent case, summer 2002 in California, were to uphold that conviction by stating, we presume there were other Los Angeles police officers who provided or could have provided the requisite testimony explaining why a vial of O.J.'s blood was taken to the scene of the crime and why there is blood unaccounted for. Getting back to the case above, what if the judge tells me that he's not there to answer my questions? I remind him I would be happy to pay the fine. I just don't know how or understand what is going on and ask, is it fair for you to proceed when I don't know or understand what is going on and there is no evidence of a complaining party? If he tells me to get a lawyer to explain it to me, then I would tell him, I don't want a lawyer, I just want you to answer a few questions. Apparently you think there is evidence here. Are you concealing that evidence from me? This brings up yet another issue about not being able to defend yourself competently. Lawyers hold the opinion that only a fool has himself for a client, and that all non-lawyers are incapable of defending themselves. This opinion from the lawyers doing business as the United States Supreme Court was the basis for a movie starring Henry Fonda called Gideon's Trumpet. Quote, even the intelligent and educated layman has small and sometimes no skill in the science of law. If charged with a crime, he is incapable generally of determining for himself whether the indictment is good or bad. He is unfamiliar with the rules of evidence. Left without the aid of counsel, he may be put on trial without a proper charge, and convicted upon incompetent evidence or evidence irrelevant to the issue or otherwise inadmissible. He lacks both the skill and knowledge to adequately prepare his defense, even though he have a perfect one. Gideon versus Wainwright, 372 U.S., page 335, from 1963, end quote. This is very important. Think about it for a moment. Wasn't I forced into this situation? Is it fair to knowingly force someone into a situation where they cannot competently defend themselves? No, it isn't, and it doesn't matter that I may be able to pay for a lawyer either. After all, why should I have to anyway? Yeah, some may say, well, you shouldn't have broken the law, as if that opinion somehow negates the alleged requirement bureaucrats are supposed to be fair. Oh, that's right, I forgot. A fair trial is only for people who haven't broken the law. Don't delete, distort, or add to reality. If the underlying proceeding is itself unfair, that is, based on violence, then how does hiring a lawyer make it any less unfair? It doesn't. It's still based on violence and still unfair. I'll use an analogy to demonstrate this because I am sure lawyers or other bureaucrats reading this may accuse me of mixing apples and oranges. Let's say a guy walks up and shoots me in the foot for no reason. No rational person would deny such an act is, at the very least, unfair. Now, is that at any less unfair because I may have insurance to cover my newly acquired, though unwanted, medical needs? Is it fair for you, or a bunch of you pretending to be a state, to bust my car window because my insurance covers such damage or because I can just buy another one? I could give analogy after analogy like this, but I've made my point. Just because someone may hire a lawyer does not make the situation any less unfair. This is another example where I have them expose their contradictions. It's just not possible to give someone a fair trial when the trial itself was based on violence. After all, if there is a predetermined outcome, then it doesn't matter if you have a lawyer or not, does it? This is why I always ask, is it fair to force someone into a situation where they cannot possibly defend themselves? Or, do you equate violence with good faith? I would also suggest that without evidence of the complaining party, there is no case. I may also remind this judge that if forced into a trial, I will ask the witness, i.e. the cop, the very same question. I tell him I am prepared to pay his fine if he will just be forthcoming to answer my questions. He could also be honest and drop his pretense of fairness and make me an offer I can't refuse, like other common criminals. Another question I ask is in regards to the nature of the charge, in this case that it is civil as opposed to criminal. I ask the judge, is this civil case in the nature of a contract dispute or a tort? This question really sets them up for a fall and always exposes the truth there is no case. If a judge insists there is a cause of action for me to plead to, then he should be willing and able to answer this question. If he is so extraordinarily confident he has lawful jurisdiction over me, so much so he's willing to use violence against me, then he should answer this simple question, unless, of course, honorable is synonymous with non-responsive and violent. I have never gotten an answer to this question, and for good reason. There is no case. They have no right to charge me or you with anything. This, however, does not mean people should not be held accountable for their actions. Just as you are not personally accountable to me for not walking around with ID in your pocket, I am not accountable to you or any of the bureaucrats pretending to represent you. The so-called civil cause of action can only fall into one of two categories, contract or tort. Yes, there may be more than one cause of action presented, but each charge must fall within one of those two categories. With bureaucrats, they never do. So what is their defense to this, if any? Can they just say a case brought by the state does not have to fall within one of those two categories? Yes, but if they do this, it would be yet another admission that their own rules don't apply to them. They only apply to you, their victim. So here's the setup. A contract, of course, is an agreement consisting of several elements. Quote, it is elementary that for an enforceable contract to exist, there must be an offer, an acceptance, consideration, and sufficient specifications of terms so that the obligations involved can be ascertained. End quote. The 5 or so lawyers doing business as the Arizona Supreme Court, as well as other courts, have long held that there must be a meeting of the minds for there to be a contract. Quote, it is well established that before a binding contract is formed, the parties must mutually consent to all material terms. A distinct intent common to both parties must exist without doubt or difference, and until all understand alike, there can be no assent. If one party thinks he is buying one thing, and the other party thinks he is selling another thing, no meeting of the minds occurs, and no contract is formed. Contracts are founded on the agreements, not on the disagreements of the parties. Where they misunderstand each other, there is no contract. As the restatement describes it, a contract is formed if there is manifestation of mutual assent to the exchange and a consideration." End quote. Restatement second of Contract, Section 17, 1979, quoted in Hill Schaefer Partnership versus Chilson Family Trust, 799 Pacific 2nd, page 810, 814, 815. And we, the lawyers of the Arizona Supreme Court, compiled basic concept of contract law. The sine qua non of any contract is the exchange of promises. Restatement second of Contract, Section 1, 1981. From this exchange flows the obligation of one party to another. First Williston on Contracts, Section 1 at 2, 1957. Carroll versus Lee, 148 Arizona, page 10 and 12 through 13. Obligations, as even the Supreme Courts agree, are created by an exchange of promises, not by the barrel of a gun or by some other weapon or form of coercion. "Give me your money or we'll put you in a cage, steal, and then sell your house" is probably not the exchange of promises meant here. However, this is exactly the way the IRS and U.S. attorneys do business, although they pretty it up with fluffy political language as if they are fooling anyone, i.e., pay your taxes, file your tax return, or we'll levy your property, prosecute you, and then put you in jail. So, if the judge claims it is a contract dispute, then obviously there must be a contract. But in the lawyer's own opinion, to have a contract, there must be evidence of an offer, a meeting of the minds, an acceptance, and consideration. That alone contradicts the underlying violence of the proceedings. I don't know about you, but I have never freely consented to anything demanded or otherwise required by the men and women parading around as a so-called state. And it doesn't matter that I may live in the geographic area known as Nevada. I see nothing in the above Supreme Court opinions indicating mere geographic location is an element of a contract. For example, I seriously doubt my neighbor is obligated to wash my car for no other reason than because he lives next to me. The sine qua non of any contract is geographic location. While this example is admittedly asinine, it's how bureaucrats operate, isn't it? The lawyers doing business as the Supreme Court tell us that many times, such as in Cohn versus Graves, 300 U.S. 308 at 312 and 313. Isn't that the basis of America, love it or leave it? A good analogy I've used to demonstrate the nonsense contained in opinions such as Graves is with Sears. There is a Sears in Houston, Texas. Sears provides a valuable service to its customers and also to that part of the community who never sets foot in their store. One way Sears does this is by providing jobs to people living in the general area. Those employees then spend part of their paychecks at other businesses in and around Houston. However, just because I may live in the same area does not mean I have an obligation to contribute to Sears' operating expenses. An obligation to pay a fair share is not magically created because there is a Sears operating down the street. What makes the men and women doing business as Sears any different than the men and women doing business as the so-called state? Just because you drive a Dodge doesn't mean I have to. Just as important, just because I choose not to drive a Dodge or pay a part of Sears' operating expenses doesn't mean that I should have to move to another area or not be permitted to shop or just browse in Sears. It just means I don't want to drive a Dodge. That's all. It should not be taken as an affront to the other people in the area. Geographic location is not an element of a valid enforceable contract, not even in legal land. In order for a valid contract dispute to exist, there must be evidence of both a loss and a wrong. Damnum et injuria, loss and wrong, the two elements which must exist in combination as essentials of a cause of action. Ballantyne's Law Dictionary, page 304. Damage without wrong, loss or harm resulting to a person which is not the result of the violation of a legal duty. The practical sense of the expression is that there is no cause of action. Ballantyne's Law Dictionary, page 304. The Supreme Courts are pretty consistent here. For there to be a cause of action, there must be both 1. The breach of a duty, and 2. Actual damage. See Allen v. Wright, 468 U.S. 737, 1984, quoted below. No cop has ever accused me of breaching a contract or causing any actual or pretended damage. Cops blindly follow orders with no real understanding why they are doing what they are doing or what it all means. Judges appear to know this, and that's why cops are never permitted to testify beyond a certain point. In other words, this helps to conceal what is really going on, not only from you, but from the judge's partner in crime, the loyal cop as well. Despite this, I still ask my questions. If the question is answered, it never is, yes, there is a contract, then I would ask, is there evidence of a contract? And of course, if this question is answered with a yes, then I could ask, what is that evidence and where is it, so that I may examine it? The other side to this is a so-called tort. A tort is defined by lawyers as tort: a wrong independent of contract, a breach of duty which the law, as distinguished from a mere contract, has imposed, an injury or wrong committed either with or without force to the person or property of another. Ballantyne's Law Dictionary, page 1284. Notice lawyers think the law is more important than a mutually voluntary agreement. To really grasp the significance of this, read ahead at what a law is. A tort consists of two elements, the breach of a duty and damage. Here the duty is not created by a contract or an agreement, it's allegedly created by the so-called law. There is no damage to anyone if I travel without identification, so half of a cause of action is missing right there. What about this alleged duty I am supposed to have breached? The pretended duty created by law? I'm only interested in facts, not opinions. Facts speak for themselves, so I leave the legalese or the lawyerese to the lawyers to make sense of. So, factually, what actually is a so-called law, and where, when, why, and how did it create this alleged duty on me? Have you ever examined exactly what a law is? Before anyone can accurately claim or establish, beyond a reasonable doubt, a certain law created an obligation, or anything for that matter, you need to know what a law is first. Then you can examine exactly where, when, why, and how an obligation or duty was allegedly created. Think about this for a moment. If there was no law about having a so-called barber's license, then there could be no cause of action for cutting hair without one. The law itself is being used against me, and I'm supposed to be able to question all the evidence and testimony being used. The burden of proof includes proving the law created a duty beyond a reasonable doubt, or by a preponderance of the evidence in the case of a civil cause of action. Words are, of course, the most powerful drug used by mankind. Rudyard Kipling. So what is a law, or a so-called statute, anyway? What is it, and why does it appear to have an almost hypnotic effect on most people? That hypnotic effect is probably due to the level of violence used to force compliance with it. But exactly what is it, and how and why does it allegedly create any obligation whatsoever? A law is an opinion backed by a gun. That's it, folks. That's all it is. The rest is just political window dressing, as I will show. For example, a statute is just another fancy word for a law. Even a judge's opinions are called the law. Lawyers call this decisional law. Lysander Spooner said it best, quote, "What then is legislation? It is an assumption by one man, or body of men, of absolute, irresponsible dominion over all other men whom they can subject to their power. It is an assumption by one man, or body of men, of a right to subject all other men to their will and their service. It is an assumption by one man, or body of men, of a right to abolish outright all the natural rights, all the natural liberty of other men, all other men, to make all other men their slaves, to arbitrarily dictate to all other men what they may and may not do, what they may and may not have, what they may and may not be. It is, in short, the assumption of a right to banish the principle of human rights, the principle of justice itself, from off the earth, and set up their own personal will, pleasure, and interest in its place. All this, and nothing less, is involved in the very idea that there can be any such thing as legislation that is obligatory upon those upon whom it is imposed." Close quote. Lysander Spooner's Natural Law, or the Science of Justice, a treatise on natural law, natural justice, natural rights, natural liberty, and natural society, showing that all legislation whatsoever is an absurdity, a usurpation, and a crime. Part first. Lawyers, not me, define a statute as the written will of the legislative department. Ballantyne's Law Dictionary, page 1212. The lawyers doing business as the United States Supreme Court hold the same belief. See John P. King Company versus Council of Augusta, 277 U.S. 100 at page 102 to confirm. Simple observation shows us that factually a so-called legislative department is just men and women. If not, then what is a legislative department? Rocks, flowers, puppies, reptiles, raisins? It follows that a so-called law is just the written will of men and women. We should not forget this written will differs from mine in that I don't force my written will on anyone under any pretense of protection, and most assuredly not at the barrel of a gun. Does the law seem as sacred to you now? Don't confuse a political law with a natural law such as the law of gravity. The law of gravity is not the invention or whim of man, it's an observation. Just as important, when was the last time you were forced by another person to comply with the law of gravity? And why is that? Amazing, the Earth rotates on its axis every day without a sacred act of Congress. In my experience, no judge has admitted or acknowledged the so-called law is just the written will of some individuals, even when he is made aware of it. Pay no attention to the man behind the curtain. That's why I request what is called judicial notice. I request that the judge take judicial notice. The statute I was charged with breaking is factually the written will of individual men and women. No judge has ever complied with this, despite the fact that taking judicial notice is mandatory under the rules of evidence. In Arizona and in the federal courts, it's Rule 201D. In California, it is under Section 451 of the Evidence Code. Try imagining why an alleged benevolent, honorable protector of the people would refuse in every instance to take notice of what the law really is. Why the refusal to comply with the mandatory function of his exalted office? Then consider this happens in every instance, no matter what the geographic location. What are the odds? What are these honorable lawyers afraid of? It's called the three-monkey defense. Hear no evil, see no evil, speak no evil. When confronted with the truth, judges are non-responsive. Their sacred law isn't so sacred when it's just the written will of some men and women. I ask for judicial notice of what a pretended law is because the cop is supposed to prove beyond a reasonable doubt this so-called statute created a duty on me. If the judge takes notice a statute is nothing but the will of a group of men and women, then the cop has to bring forth the facts he relied on to support his opinion their will created a duty on me to act or not to act in a certain way. The cop is pretty ill-equipped to do this because his traditional accoutrements, gun, stick, badge, uniform, antisocial behavior, etc., don't help him any. In other words, swift and blinding violence is about as effective here as it is in solving geometry problems. Maybe Congress can pass a law magically transforming everyone into a mathematician. In fact, in every single instance where I have asked a cop what a so-called statute was, they were unable to answer. They just don't know, and lawyers don't think they need to know. Yes, cops won't hesitate to kill you if they think you are a violator, but while they are killing you, they cannot tell you what you are allegedly violating. Has this created any reasonable doubt in your mind yet? This cop is certainly not in a position to testify he saw me violate a statute when he doesn't even know what it is. Your Honor, I'm the one who discovered the theory of relativity. Really, Officer Carroll, what does the E stand for? How should I know? That's irrelevant, Your Honor. I agree. During one trial in Arizona, I asked a cop if he knew what a license was. He admitted he didn't know. I suggested that since he didn't know what a license was, that he was in no position to testify, I was required to have one. What did the judge with the robe do? That's right, Judge Donald bailed his buddy out. He asked, "Officer, do you know what a license looks like?" "Yes, I do, Your Honor." The judge's response, "That's good enough for me." Not surprising that the appellate court, yet another lawyer who was now a federal judge in the Ninth Circuit, ruled she saw nothing wrong with what her fellow politician did. The judge is not supposed to have any discretion to permit such an individual to testify because Section 602 of the Arizona Evidence Code states, "A witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter." If the cop doesn't know what a statute is, not what one says, but what it is, then he has no personal knowledge of the matter and may not testify, unless, of course, personal knowledge is now synonymous with gun, badge, and a willingness to kill men, women, and children for not following orders. If this cop doesn't know what a so-called statute is, then it's impossible for him to prove, beyond a reasonable doubt, I allegedly violated one. This is much easier to understand if I don't use the word law. Instead, I'll use XYZ so you are not hypnotized by the word law. Cop: "Mark broke the XYZ, Your Honor." Mark: "Okay, if you say so, but what is XYZ? Cop: "I don't know, but you broke it all right." Would you rely on this guy's testimony? Traffic court judges do every day. It's no different if accused of breaking the law by a man who doesn't know what a law is. I once worked on an IRS case with a lawyer. We initially lost the case and the judge used the Constitution as grounds to throw the complaint out. We filed a motion to reconsider and requested the judge to take judicial notice the Constitution was a written instrument. This fact was supported by observation and by the lawyers doing business as the Supreme Court. Quote, "The Constitution is a written instrument. State of South Carolina versus U.S. See also McIntyre versus Ohio Elections Committee. Decided April 19th, 1995. This judge refused, although it's mandatory under Rule 201D of the Federal Rules of Evidence. Without disputing the truth, she claimed the facts were inappropriate. Susan's decision was based on the Constitution, but what the Constitution literally is was somehow inappropriate. Yes, Virginia, there is a Santa Claus. If you don't acknowledge what it is, you may as well as substitute XYZ for law or Constitution. Tell me exactly what the Constitution or law is without using the word Constitution or law, and you'll see what I mean. Nowhere in the Federal Rules of Evidence can I find where a judge can refuse to take notice of facts because they feel it's inappropriate. Relevant? Yes. Inappropriate? No. Couldn't the facts of a brutal rape and murder be considered inappropriate also? You may be asking yourself why a judge would refuse to take judicial notice of what the Constitution is factually, especially when her entire decision is based on it. After all, judges take a pretended oath to preserve, protect, and defend the Constitution, and yet they run, sometimes literally, when asked to take notice of what it is. Why is that? I think it's because they know or are realizing they cannot prove the Constitution created any obligations on anyone. Can you explain how a 200-year-old unsigned written instrument transfers property rights? The same thing happens when I ask notice to be taken. The law is the written will of a group of individual men and women. Bureaucrats do not like talking about how and why what they call the law allegedly became obligatory, binding, or how and why it created some pretended duty they are accusing me of somehow breaking. It's as if they know it's not binding on me, them, or anyone else, and they are afraid of letting the cat out of the bag. Maybe cops would be less enthusiastic to kill in the name of the law if they knew it was just an opinion. I arrest you in the name of Ted Kennedy. I like to cut to the chase. I may ask, what facts are currently before you proving when, where, why, and how the written will of individuals ostensibly labeled legislature became obligatory on me? They are the ones who are supposed to prove their case beyond a reasonable doubt. How was that done without these facts? Can you just assume the law is binding? Yes. Bureaucrats do it every day. However, what is the point of a trial when facts are assumed? What about the part about beyond a reasonable doubt? I did a pretrial conference with a lawyer I used to work with. We were in San Jose meeting with 2 IRS lawyers. The lead lawyer snarled contemptuously at me. What makes you think your clients aren't subject to federal law, Mark? I said, what is federal law? She was a bit puzzled by this, thought for a moment, and then said, that's what Congress says. I responded by saying, okay. Isn't Congress just a group of individual men and women? She agreed it was. I then asked her, what facts do you rely on that my client is subject to the will of these individual men and women? She refused to answer, and her younger co-worker arrogantly stated, we don't have to prove anything like that, and the court will let us. I then said, okay, let me see if I have understood your pretrial position correctly. You are saying, we're the IRS, and we can do and say whatever the hell we want, not to have to prove a damn thing, and the court will let us get away with it. Is that right? She refused to answer, and they wound up refusing to return any of our discovery materials, including refusing to attend depositions. That, however, is typical when the opposition has no case. You see, bureaucrats believe they don't have to prove the law that they ram down people's throats is actually binding on anyone in any way. Beyond a reasonable doubt? Who are they kidding? Bureaucrats don't believe they have to prove their law is binding at all. They believe their fantasy is real, and if it's questioned, then the person who has the temerity to ask is labeled a wacko or being in an alternate reality. And I agree in regards to the alternate reality. My reality is based on tangible facts, and a bureaucrat's reality, legal land, is based on opinion heard from honorable lawyers and other bureaucrats. This is all just a normal, everyday part of legal land. Bureaucrats only need to hold an opinion and a gun, and that's all. What is more, their opinion the law is binding and or applicable is a sacred cow, quite literally immune from challenge. The rules of evidence, confrontation, and fairness be damned. And why is that? Yes, lawyers spew forth nonsense such as the courts have long held in defense of their adversary system. Of course who wouldn't defend their own business? However, legal opinions are not facts. I once had a former IRS district counsel tell me over the phone that if I were a lawyer, I would be disbarred for challenging a revenue agent's opinion the law was binding. disbarred for challenging a witness's testimony. And why is that, Mr. Former District Counsel? You guessed it, control, to keep the truth from getting out. The truth being the law binds no one. What would happen if just 100,000 victims of bureaucratic attacks challenged this legal opinion? Think about it. It's only an opinion. Confidence would collapse. This is why a lawyer representing the IRS told me a revenue agent's legal opinions, collectively known as a notice of deficiency, were irrelevant to whether the notice was correct. Apparently the whole is not equal to the sum of the parts. In other words, his legal opinions, including the one the law created a so-called tax liability, were irrelevant to whether the asserted tax liability was correct. That's the equivalent to convicting a man of rape on nothing more than cop. He did it, Your Honor. Honorable lawyer. And how do you know this? Lawyer. Your Honor, I object. That's wholly irrelevant to whether this idiot is guilty or not. This man is a cop, and his official opinion is more valuable than that of an accused rapist. I was in an informal conference with individuals claiming to be a Department of Revenue in Phoenix. I handed the revenue agent her so-called notice of proposed assessment and asked her if everything on there was true and correct. The response? She and her comrades vehemently refused to answer the question. However, I think rational people would agree that she did answer the question by her actions. But why would people so extraordinarily confident in their so-called assessment refuse to answer this question? Some may argue that whether the law is binding is somehow irrelevant to whether a tax liability is created, that a revenue agent's or cop's legal opinion should not be challenged as any other witnesses would be. I will briefly demonstrate why this is irrational and inconsistent with the very system facilitating the attack. Real crimes do not depend on the existence of a law to prove they were committed. I'll compare tax evasion with a real crime. Section 7201. Attempt to evade or defeat tax. Any person who willfully attempts in any manner to evade or defeat any tax imposed by this title or the payment thereof shall, in addition to other penalties provided by law, be guilty of a felony and, upon conviction thereof, shall be fined not more than $100,000, $500,000 in the case of a corporation, or imprisoned not more than 5 years, or both, together with the costs of prosecution. Title 26, United States Code. Notice this pretended crime depends entirely on the existence of some so-called title or law. Without this so-called law, there is no crime. The same is true of the affront to humanity called failure to prove ID. Aren't crimes supposed to be proven beyond a reasonable doubt? Isn't the applicability of the law an essential element here? Can this legal opinion then be assumed by a non-lawyer, gasp, and not to be subjected to challenge? I guess proven beyond a reasonable doubt means spewing forth incomprehensible legal opinions. However, now compare 26 U.S.C. 7201 with a real crime. 13-1102, negligent homicide classification. A. A person commits negligent homicide if with criminal negligence such person causes the death of another person. B. Negligent homicide is a Class 4 felony. Arizona Revised Statutes. Proving a person caused the death of another person is certainly possible without this so-called law. Person A pointed a gun at person B's head and fired ... Try making a case for tax evasion without a so-called tax code. Let's see, person A earned $50,000 a year and put it in his pocket. Yeah, some crime. Shoot the bastard. He doesn't deserve a fair trial. Just in case anyone thinks I am advocating or believe people should not be held accountable for their actions, consider all I am doing here is using the so-called system against itself. I am pointing out the contradictions and inconsistencies. If some revenue agent forms an opinion, then that opinion is supposed to be subject to challenge, and it doesn't matter what the subject matter of the opinion is. For goodness sakes, even expert witnesses are subject to cross-examination. If you aren't supposed to challenge a revenue agent's legal opinions, then what is the point of having a tax court? If proving the law is binding is not relevant to proving tax evasion beyond a reasonable doubt, then a bureaucrat could jerk some poor soul out of Fiji and convict them. In simpler terms, you could be convicted of not getting a dog license despite not having a dog. But, Your Honor, I don't have a dog. That's irrelevant. The statute requires every person to get the license. Then again, a dog without a license is a nullity. Wait a minute. I think they may have something here. Do you realize men and women claiming to be an IRS and so-called Justice Department bring exactly the same factual claim to your property as you do? Let me explain. You acquire $100,000. To prove you have a right to that money, you put forth the following facts. You entered into a mutual voluntary agreement with another man to trade services. This agreement was carried out in New York. The IRS then claims $39,000 of it is theirs. What facts do they rely on to support this legal opinion? That's right, you acquired $100,000 in New York. Exactly the same set of facts to support your claim. Everything beyond that is political mumbo-jumbo. And don't forget the New York State bureaucrats also lay claim. Think about this. Whether the law is binding or not is really a jurisdiction or control issue, so I like to ask. Except for coercion, exactly where, when, why, and how was your control over my life acquired? There is never a responsive answer to this question. How does the judge maintain a pretense of fairness when he refuses to inform me of the nature and cause of the charges and proceedings? All I want to do is pay the fine and leave. Why doesn't he just let me? There are times when there was a release bond I was going to assign over for the fine, and they have refused to let me. They were already paid, and yet they still refuse to inform me of the nature and cause of the charges and proceedings. What does that tell you? Also consider I haven't disagreed or argued with them in any way. On the contrary, I've agreed with him. He has control and I want to pay him. I only want to know how jurisdiction was acquired. What's the problem? Why would a judge refuse to answer a few questions and take the fine? I was once with a guy who put the checkbook right where the judge could see it. It was right on the bench, and he told the judge he was going to write a check for the fine because he didn't want a trial. This judge not only got extremely upset, he called in the police to have us arrested. While our complaint about this was ignored, years later, the Arizona Supreme Court censured him for having an anger problem. Who would have thought? A judge cannot be honest about what's going on because he's the main player in this vicious scam. He has to put on the pretense. His dog and pony show called a trial is to provide the illusion of legitimacy. That is why he will not tell me what is really going on and just take his blood money. He cannot just be honest and say your money or your life like other criminals. He probably knows the people waiting behind me would run out of there as fast as they could if he did. What if the judge is non-responsive by citing a Supreme Court opinion as an answer to how jurisdiction was acquired? I would say, really? Okay, since you are relying on that opinion as if it's evidence, can I cross-examine the lawyers who wrote it? I say this because the judge is relying on the legal opinion of his fellow honorable lawyers, so I'm supposed to be entitled to cross-examine those lawyers too. I am unaware of exceptions for lawyers higher up on the political pecking order. You see, everything being used against me is supposed to be subject to challenge. If the judge wants to order the lawyers doing business as the Supreme Court to appear as witnesses against me, who am I to complain? If he doesn't want to order them to be cross-examined, then he shouldn't be trying to substitute their opinions as evidence against me. The rules of evidence are pretty clear and standard around the geographic area commonly referred to as the United States. 2 rules from Arizona and the federal rules are as follows. Quote, a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter, end quote, Arizona Rule 602. Quote, who may impeach? The credibility of a witness may be attacked by any party, including the party calling the witness, end quote, Federal Rule 607. In California, the equivalent is Section 702 of the Evidence Code, where it states the testimony of a witness concerning a particular matter is inadmissible unless he has personal knowledge of the matter. If the judge wants to be non-responsive and cite opinions and not facts, that's okay. He's just digging a deeper hole for himself. Let him rely on opinions I can't challenge. Doing so conflicts with his pretense of fairness. You see, this is not only unfair because the judge is now assuming the prosecutor's burden of proof, but he's also denying cross-examination and taking the testimony of witnesses who obviously lack personal knowledge. That's a pretty good list of errors, wouldn't you agree? And that's all in the first 2 minutes. I'm sure lawyers would protest, claiming I may not cross-examine the lawyers doing business as the Supreme Court. Go ahead and protest, argue, object, and disagree. Rule 607 contains no exception for lawyers, even honorable ones in flowing black robes. I won't force the judge to be responsive. If he chooses to be non-responsive when I ask for facts and instead relies on opinions of his fellow lawyers, that's fine. I'm supposed to have the right to challenge all the evidence being used against me, including opinions, even those offered by so-called expert witnesses who are not even present or know they are being used as witnesses. Lawyers can protest their own rules all they want. It only proves my point. It's the inconsistency that's important here, not whether or not I get to cross-examine a few lawyers. I don't want to cross-examine them anyway. Have you ever tried to get a straight answer from a lawyer you're not paying? Besides, I have productive things to do. It just isn't fair for a judge to use opinions as evidence against me while at the very same time denying challenge. It only goes to show that there are no binding rules for bureaucrats because they just don't follow rules. Just like peeling back the layers of an onion, the more you examine what these people say and do, the more it falls apart under its own dead weight. Men with guns who have no respect for human life typically have no use for rules either. So, in regards to this, I just want to mention another political lie. Yes, I know that's redundant. Before I move on, a well-known opinion is the Constitution allegedly established a government of law, not of men, and a so-called limited government and the rule of law. This is statist propaganda to the hilt, and I'll show you why. Regardless of what the Constitution may say in any other clause, the only important one is the necessary and proper clause, because this clause effectively negates the rest of that document. You want to know why? Because necessitas non habet legem. Necessity has no law. Ballantyne's Law Dictionary, page 837. This definition, and the fancy Latin that lawyers will sometimes spew forth in order to confuse you even further, reminds me of many a traffic court judge. Necessitas vincit legem. Legum vincula erudit. Necessity supersedes law. It laughs at the fetters of the law. Ballantyne's Law Dictionary, page 837. Yes, when confronted with rules such as 602 and 605 of the evidence rules, judges laugh at the law and do whatever they want while sneering, "You can appeal." Don't believe me? Try it and you'll see. Yes, these lawyers laugh at the very law they ram down our throats. Can you use necessity as a defense when charged with one of their pretended crimes? Still think they represent you? As it turns out, the rule of necessity is a convenient political or statist way of saying bureaucrats can do whatever they want, and the alleged law, such as the Fifth Amendment, is just not applicable. A great example is in the Arizona rules of the Supreme Court. The so-called supreme law of the land is that if forced into court, you are supposed to get a fair and impartial trial, or your life, liberty, and property are not supposed to be taken away from you. This is commonly known as due process, Fifth Amendment, or having your day in court. This, however, is just not consistent with the facts. The term due process, as it turns out, is very, very misleading. If you look at the Arizona rules of the Supreme Court, Rule 81, Code of Judicial Conduct, the judge's ethics rule, I know that's an oxymoron. The commentary for Canon 3E1 says, by decisional law, the rule of necessity may override the rule of disqualification. What this actually means when you strip away the lawyerese is a judge's opinion is more important than his following the rules and giving you a fair trial, such as recusing himself as your judge whenever he is asked to rule on any cause about which his impartiality might reasonably be questioned. To recuse means to disqualify himself, i.e. to step down from the bench, that seat that he sits on behind a big wooden table 4 feet off the floor, so that another judge can replace him. In essence, it means, by decisional law, the rule of necessity may override the rule of law. If you cannot receive a fair trial, then they are not supposed to put you on trial at all, or take your life, liberty, or property away from you. However, lawyers and bureaucrats are not in the fairness business. That's why they completely disregard the so-called law whenever they feel like it by using what they call the rule of necessity, their idea of necessity. Whether you believe it or not, will not change the reality there is no such thing as a government of laws, not of men. This is because the law itself is nothing more than an opinion by one man or a body of men, as Spooner put it, backed by a gun, and this includes so-called decisional law, as lawyers call it. A government is a group of men and women doing business under physical violence under the political banner of necessity. Their opinions are just political window dressing to conceal that violence. Go ahead, conduct your own law library or internet search of Supreme Court opinions using the keyword necessity, and you will find the most egregious acts of violence that have all been justified by what they say was necessary. Cop: we had to kill him, Your Honor. Judge: and why is that, Officer Mitchell? Cop: it was necessary to get his car away from him. Judge: was he engaged in or wanted for a crime? Cop: no, but I hardly think that's relevant, Your Honor. Judge: neither do I. The fact that the laws and the rules of the court do not apply to bureaucrats is shown every day by the judges themselves if the right questions are asked in traffic court. Sometimes you can see this for yourself even if you don't ask the right questions, just by having a basic understanding of what is right and fair. The issue of how the judge acquired jurisdiction control is just one, but is very important, maybe even the most important. Jurisdiction is supposed to be an element of a so-called crime and a cause of action. The burden of proof is supposed to be on the party asserting it, and in a criminal case, the burden is beyond a reasonable doubt, while in a civil case, it is supposed to be by a preponderance of evidence. Supposed to be. Remember, this is legal land, where nothing is what it's supposed to be. Well, it's bad enough if the judge assumes jurisdiction on behalf of the alleged complaining party, but it's an insult added to injury to also use an opinion against me I cannot challenge. I would therefore ask, is the use of opinions I cannot challenge factually consistent with the confrontation clauses? Using so-called evidence not subject to challenge is not a trial in any sense of the word. For the lawyers out there, do not mix apples and oranges here or accuse me of doing the same. This is not to say an issue of so-called law may not be settled by citing an opinion of the Supreme Court. On the contrary, this is an issue of evidence and facts, not of law. It's also an issue of being responsive to a simple question. I should not be given an opinion when I ask for the facts. Some may ignore that I asked for the facts and say it's well-settled law that the judge has jurisdiction. It is also well-settled law that you're supposed to wear a seatbelt, so why have a trial at all when the charge is failure to wear a seatbelt? Come to think of it, if I have to accept opinions without challenges, then what is the point of having a trial under any circumstances? If it's so well settled, then why not repeal civil rules such as 12b-6, one of the motion to dismiss rules? If it's such well settled law, then why do U.S. attorneys always file motions to dismiss when someone sues the IRS? The judge is supposed to be impartial and independent, not in my opinion, but in their opinion. This is so-called independence would be subverted if he is assuming jurisdiction for a party. This will be discussed in greater detail below. As stated earlier, a cause of action is supposed to require the breach of a duty resulting in damage. So I may ask, am I being accused of breaching some duty? If this is answered, then the answer would most likely be yes. I would then ask, where, when, why, and how was this alleged duty created? Keep in mind, this presupposes the judge has answered whether or not this civil case was a contract dispute or a tort. Chances are this question will not be answered. Most questions are not answered. Maybe honorable lawyers do not feel the need to condescend to my non-lawyer level to answer a question. I would also ask, was this alleged duty created by coercion? If that alleged duty was created by coercion, then why not also impose the duty to pay the fine by coercion and skip the pretense? Why not be consistent? As previously stated, bureaucrats have most people blindly accepting their pretended laws so they don't have to worry about non-compliance. However, in a democracy based on the rule of law and not men, and other such legalistic gibberish, the pretense of a fair trial must be maintained in order to keep those very same people fast asleep regarding the true nature of their so-called system, so they will continue to go on blindly obeying and paying. After all, if a duty can be created by coercion, then how can the crime called armed robbery even exist? For example, you walk into a bank with a machine gun, you fire off a few rounds and inform every employee in the bank that they will die if you don't get all the money stored away inside of their bank. If legal duties are created by coercion, then the people in that bank would have a legal duty to comply, now wouldn't they? If it is, then where's the crime? In fact, what is really crazy here is if the bank's employees refuse to comply, then they've committed a crime and not the guy with the machine gun. In legal land, such heinous crime by the bank employees is called tax evasion. In legal land, violence is honorable, and not complying with that violence is the crime. The really uncomfortable part for a judge is in regards to the second half of a cause of action, i.e. the damage. How can there be any damage if I don't have an ID card in my pocket? The only damage may be to the ego of the man dressed in a costume with a gun and a healthy appetite for violence and domination because I didn't obey his legal order. What they are really accusing me of is disobedience to their pretended authority, not of breaching any duty or causing any damage. Traffic court is a matter of obedience, domination, and money, not a matter of safety, fairness, and justice. They're determined to make sure that I obey the next time around. This is proven by looking at their own so-called law. I can always rely on contradictions when dealing with bureaucrats. A great example in Arizona is found within their so-called constitution. Quote, governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. End quote. Arizona Constitution, Article 2, Section 2. If you think about it, bureaucrats claim to protect everyone's right, yet whose rights are they allegedly protecting if I am charged with not having an ID card in my pocket? In other words, where is the damage if I travel without identification? What about a license plate, for that matter? I have asked for the names of the alleged victims whose rights the fearless prosecutor is valiantly protecting and have never gotten an answer. Why is that? However, one persecutor in Arizona actually claimed he was representing me. Wow, I'm both the plaintiff and the defendant. Before anyone laughs, consider this opinion is not legally defective. It was a lawyer's, a proud member of the Arizona Bar Association, the only people permitted to give legal opinions in legal land. Now you can laugh. If he was really representing me, then I would have been complaining against myself. I could have told him to withdraw the complaint. He was claiming to be standing in the place of me, but I think everyone is aware he did not represent me. If he did, then notwithstanding the complete lack of supporting evidence, there was a serious conflict of interest in my lay opinion. I hardly think that any lawyer, or cop for that matter, could produce any evidence that I, being in Phoenix, have obligations to people in Parker, Arizona, hundreds of miles away. To date, all have refused to try. No, instead, they leave that burden for their exalted partner, the judge, to decide. All that means is that the judge bails them out because the judge can call his little army of non-discretion exercising henchmen, bailiff, cop, deputy, etc., to throw me in a cage for humans with a so-called command, mandate, decree, or order. It's even more difficult, if not impossible, for these bureaucrats to provide the actual rights they are courageously protecting or redressing in a traffic case. I'll elaborate. Bureaucrats allege we have a right to life, liberty, and property. In a case of a car theft, the victim's right to property was violated. In a kidnapping case, the victim's right to liberty is violated. And in a murder case, the victim's right to life is violated. There it's clear which rights the prosecutor is allegedly protecting or redressing. But what if I forget to leave the house with ID? If I live in Phoenix, Arizona, and I leave my home without ID, how are the people at the Grand Canyon injured? Which rights of theirs have I allegedly violated, and how? Was it their right to life, liberty, or property? Oh no, all three? If you laugh, then keep in mind this is supposed to be proven beyond a reasonable doubt. I've asked cops this question, and the best they can do is say, I failed to produce ID. It's a stupid, time-worn mantra. They have no responsive answers because there are none. It's a fantasy to think people are damaged if I don't have ID on me. Why not accuse me of not dressing like the Tooth Fairy? That causes the same amount of damage to other people as not having a picture ID in my pocket. At what point does this senseless violation of rights occur? What kind of person is so cold-blooded and insensitive to the rights of others they actually leave their house without an ID card? Let's take this one step at a time and see if we can pinpoint exactly when the rights are violated. 1. I decide I want to leave my home in Phoenix and get some raisins down the street. I have some cash in my pocket, so 2. I don't take ID with me. 3. I get into my car and travel down the street. 4. A valiant public servant, a cop, ever vigilant to protect the people, senses I don't have ID. 5. Knowing there is a criminal activity brewing, he turns on his emergency lights. And 6. I stop my car. 7. Our conquering hero, the cop, bravely approaches the vehicle and with great confidence, throwing caution to the wind. 8. Asks to see my ID. 9. I tell this courageous, selfless man I have no ID. 10. Our cop informs me that I am now under arrest. And 11. Far greater tragedy to the people of Arizona has been narrowly averted by this altruistic servant of the people. Who knows what might have been the extent of the damage had I been permitted to continue traveling down the street. I could have bought some raisins, or other dry fruit, without ID. Oh, the horror, the horror. And, mind you, bureaucrats do believe that not having ID is a crime warranting jail time. One lawyer from the Phoenix area wanted a judge to put me in jail for 6 months, not because I didn't have ID, but because my ID did not have a picture on it. Quote, Arizona Revised Statutes, Section 28-1595. Failure to stop or provide driver license or evidence of identity, violation classification. A. The operator of a motor vehicle who knowingly fails or refuses to bring the operator's motor vehicle to a stop after being given a visual or audible signal or instruction by a peace officer or duly authorized agent of a traffic enforcement agency is guilty of a Class 2 misdemeanor. B. After stopping as required by subsection A of this section, the operator of a motor vehicle who fails or refuses to exhibit the operator's driver license as required by section 28-3169, or a driver who is not licensed and who fails or refuses to provide evidence of the driver's identity on request is guilty of a Class 2 misdemeanor. The evidence of identity that is presented shall contain all of the following information. ... Close quote. Just how many tragedies has this so-called statute prevented? What on earth did people do in the days prior to picture IDs? No wonder they're called the Dark Ages. There was no flash photography. My question is, at what point did this nefarious crime begin? If you laugh at this suggestion, consider this so-called crime is supposed to be proven beyond a reasonable doubt. Was it at step 1 when I was thinking of going out for raisins, or when I actually decided to go out without ID? If my wife knew I was going out without ID, would she be guilty of aiding and abetting? What if she suggested that I go out without my ID? Would she be guilty of conspiracy to fail to produce ID? Maybe she should have performed a citizen's arrest and prevented me from leaving the house. What if I thought about going out without ID and the phone rang and I didn't go out? Would that be attempted failure to provide ID? At which point did the people of Heber, Arizona start having their rights violated? And which ones? Was it the right to go to sleep at night knowing some lunatic was not out traveling without a picture ID in his pocket? Were the people of Jerome, Arizona damaged at the same time as the people at the Grand Canyon? Are non-citizens and non-residents also damaged, or just citizens? What about people just visiting, or citizens visiting the other side of North America? Is it a vicarious injury? If it damages people 200 miles away, then why aren't people damaged in California and Mexico? Or are they damaged as well and cops just don't care? Where does the senseless carnage end? Could you imagine how much worse it could have been if I didn't have a seatbelt on? If there were 5 people in the car with me, would they be guilty of aiding and abetting? Could we all be charged with a RICO violation? No wonder the great American West was so dangerous 150 years ago. There were no picture IDs. And gasp, no social security numbers. How did the human race survive all those thousands of years without social security? This is like those math problems in every school everyone hated. If person A leaves Chicago at 12 without ID, traveling at 50 miles per hour, and person B leaves Detroit at 1 without ID, traveling at 55 miles per hour, at what time are the people in Seattle damaged? I think the point is made sufficiently. At no point are the people in Heber, Arizona affected in any way if I go out to buy raisins or any other dry fruit without ID in Phoenix. In fact, no one is affected, not even the cop who chooses to violently interfere with my life. Now, how does all that square with the political rhetoric commonly called the Arizona Constitution? Governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. Arizona Constitution, Article 2, Section 2. It doesn't square with it, and no amount of political spin, opinion, or violence can make failure to provide ID factually consistent with this section of Arizona's pretended supreme law. It then follows that the Constitution does not authorize the actions taken against me, so I ask the judge straight out, are there any allegations of damage here? More likely than not, if any duty is claimed to be breached, then it was created by coercion, i.e. violence, and there is no damage. No one is damaged by going down the street without a driver's license, and I have even had cops testify that I have not damaged or even threatened to damage anyone. And I write pretended before supreme law, because if this clause were complied with, bureaucrats could not give out most traffic tickets. You may be asking yourself, how would driving down the street ever be safe again if no one was required to have a driver's license? I addressed that issue in the last chapter. Suffice it to say here, there are accidents caused every day by licensed drivers, and no service or product needs to be provided at the barrel of a gun. Getting back to my collateral attack on the so-called system, a traffic ticket will show there is no victim. So the ticket, on its face, is inconsistent with this section of the so-called Constitution. A good question in this regard is, did I violate any individual rights? If the answer is no, then the next question is, would this prosecution be factually consistent with the purpose of the establishment of this government? In Arizona, it's Article 2, Section 2, cited just above. These questions also apply if I'm accused of a so-called criminal traffic violation. I just go in with a proposed plea of guilty and let the judge know I want to pay the fine and avoid a trial. I just have a few questions I want to ask before paying that fine so I know what is actually going on. In criminal cases, I'm supposed to be informed of the nature and cause of the charges and the proceedings against me. This will usually not happen, though. Bureaucrats want money they have not earned, and they are not interested in fairness. They tend to act as though my alleged right to be informed is a nuisance. Bureaucrats are not in the fairness business. They're in the control, power, and money business. They crave attention, irresponsibility, glory, and domination. To the man who only has a hammer, everything he encounters begins to look like a nail. Abraham H. Maslow.
Chapter 8. What role does the judge really play? I usually find this is a good time to question the judge's role in all of this. I would say, I understand an armed man dressed in a costume, the cop, complained about me. However, I am a little unsure about what the judge is supposed to do. Why is the cop whining to this honorable lawyer? Daddy, Mark won't let me see his baseball, Your Honor. Mark won't let me see his ID. I will ask the judge, who do you represent in all of this?
I like this question because there's no way out of this particular one for the judge. This is really the only question I need to ask to prove the entire proceeding is unfair. It's about as loaded a question as there is, and he may get very upset, and that's fine. The only thing he's accomplishing is throwing his pretense of good faith, fairness, and credibility right out the window. I write there is no way out because the 2 points I made above about physical violence and a fair hearing are used here with maximum effect. This question cuts through all the political window dressing, exposing the trial for the sham it is. A sham, in the lay sense, of course. The judge will not answer this question and may use it as grounds to claim that I'm somehow refusing to plea. The judge would then force me to his political dog and pony show called a trial, despite my intention to plead guilty and pay his fine. That's why I go in with an unsigned plea of guilty for criminal cases or a plea of responsible for civil cases. In either case, I can ask, sir, is that consistent with the facts? There is an unsigned plea of guilty on your bench. Why not inform me of the true nature and cause of the charges and proceedings against me and then take my money? This question is loaded because the judge has to say one of two things or be non-responsive. Either way, he will have a difficult time maintaining his pretense of fairness. In the summer of 2002, I helped someone with a hearing in Phoenix with individuals calling themselves the Department of Revenue. The hearing officer represented the director of the department, as did the individual who made the assessment. Where was the independent and impartial hearing officer? There obviously wasn't one. The hearing was a joke and was only provided to create the appearance of fairness. Could you imagine a mugger using the same language as a lawyer? He sticks a gun in your face and says, "I've just assessed you, now give me your wallet." This may be the judge's first possible response. A. He could say he represents no one. There is almost no chance a judge will say he represents no one. However, if he does, then I would ask, so you are here on your own authority? A yes or no will do. Now things start to get really tough for the judge. The only ways out of this are to throw out this inane charge or start screaming something about contempt. What are the implications for an honorable lawyer if he claims he is there on his own authority? The premise bureaucrats, such as a judge, put forth and need to be accepted is they represent the people of the state as authorized by the Constitution. If he claims he represents no one and is there on his own authority, then this false and erroneous premise is destroyed by his own admission because the judge is appearing pursuant to the Constitution while not appearing pursuant to the Constitution. This particular question undermines any pretense of fairness this violent individual is trying to maintain. The political myth he is a public servant is exposed for everyone present as the nonsense it is. This obviously presents a judge with a serious jurisdictional problem if he is going to claim he is appearing by his own authority. I may ask, is it your opinion you have jurisdiction over me? A yes or no will do. If he answers no, the case is over. This is not likely to happen. A judge will usually angrily snap back that they do have jurisdiction, so then I could ask, is that an arbitrary legal opinion? He'll likely say no, so I can now respond with, so your legal opinion is based upon facts currently within your knowledge. Chances are he will say yes. If not, the case is over. This next question is going to be really tough for the judge. I'm glad those facts are currently within your knowledge. Now, could you please tell me what those facts are and exactly where, when, why, and how you, of your own authority, actually acquired this jurisdiction over me? This lawyer cannot snap back the Constitution without contradicting his previous opinion that he is not representing anyone. He's stuck. Another important question to ask is your jurisdiction based on my consent? The answer I'm looking for is coercion, physical violence. This judge has not asked for my permission, and he will let me know if I ask him questions like this, because the only answer consistent with reality is coercion. I can ask him a question that will make him horribly uncomfortable. Do you equate violence and coercion with fairness and good faith? There is no way out of the box I've helped put the judge in. If he tries to squirm his way out by being non-responsive, I ask, tell me, what would happen if I just walked out of here, threw this so-called ticket away, and ignored all of this? He will probably let me know that some form of physical violence would be used against me, such as a so-called warrant for my arrest will be issued. If he doesn't answer, I will just ask the above question again, or just walk out. By asking what would happen if I turned around and walked away, he'll let everyone present know he is prepared to use physical violence in his own so-called authority. This is a pretty bad spot for him to be in. I would then point out he has claimed he is there on his own authority and has acquired jurisdiction by coercion. By his own admission, his authority is violence, not some alleged delegated authority from a constitution. An admission like that would be pretty damaging and is the reason why I will bring witnesses with me and audio recording equipment. If he is doing all of this by violence, then the question is, can he make an error large enough to shock the conscience of any reviewing lawyers doing business as an appellate court? This raises another interesting question. How do you shock the conscience of an individual who relies on violence to acquire property he doesn't own, viz. a bureaucrat? He obviously has no respect for human life, so how do you shock him? The mere fact that violence is his so-called jurisdiction should be enough to get any case thrown out, but remember, this is not the real world, this is legal land. So it usually doesn't work out that way. In legal land, violence is okay if you have a cool-looking badge or a costume on, such as a uniform or a flowing black robe. If he's there on his own behalf, then to whom does the fine that I paid go? If any money goes to him, there is a serious conflict of interest, and any pretense of fairness and impartiality goes right out the window once again. And if that money goes to the state and the state pays him, there is still a conflict of interest. This conflict of interest doesn't magically go away by labeling it the best system in the world or sneering, well, I'd like to see you do better, Mark. This is why there is never any impartiality in any so-called tax case. All bureaucrats are paid by money stolen, lay sense, from pretended taxpayers. Therefore, the judge in any tax case has a financial interest in each and every case that comes through. Impartiality and independence is a cruel joke. You should also consider the political nonsense the state is everyone in a certain geographic location. This would obviously include the honorable lawyer with the neat robe. How could one of the very people tragically damaged by my reckless act of traveling without ID also sit as a judge? Where's the independence? If the judge is there on his own behalf, then what does this say about his relationship to the cop who came in crying about someone not having a seatbelt on? Why is the cop whining to him? What is his motive? I could really put this judge on the spot by holding up the ticket and asking him, what is the nature and basis of your relationship with this cop who filed this alleged complaint against me? If he has no relationship with him, then why is he taking control over my life and my property of his own authority for him? There is obviously some kind of relationship going on here. At the very least, there is some kind of business relationship. I think that would qualify as a conflict of interest. This line of questioning could really expose the judge and show, beyond a reasonable doubt, there is only a thin pretense of fairness going on here. I know some people, especially lawyers, would complain and allege their adversary system is the best system in the world. My response to that is, yeah, right, great logic. What a strong argument in favor of violence and sham trials that lawyers, by the way, have a vested interest in supporting and perpetuating by assisting the pretended state in your prosecution by acting as your judge or by helping to protect you from the other two lawyers in the courtroom. Get it? Your life, honesty, and fairness are just not as important as their next house, car, or boat. I understand that federal minimum security prisons are much better than state maximum security prisons, but that doesn't mean I want to go to federal prison. A prison is still a prison, for goodness sake. What about Hawaii this year, honey? Are you kidding me? Have you seen this brochure for the federal prison? Let's say there is an election going on here in Arizona, and one guy is running for Attorney General. His platform is that he's the most qualified. Now that's pretty misleading, isn't it? In a class of idiots, a few are bound to be at the head of the class, right? But even the best and brightest among a class of idiots are still considered idiots, aren't they? Now let's take a close look at the judge's second possible response. B. He could say he represents the state or the people of the state. This, the more likely answer he might give, if any at all, presents the judge with a different, though just as deep hole to dig himself out of. Like my last question, there is no way for this lawyer to answer without destroying whatever pretense of fairness, good faith, and impartiality he may have had up until this point. The judge is supposed to be an independent, fair, and impartial decision maker, not in my opinion, but according to the BS public relations bureaucrats put out. There is a serious contradiction here. If he represents the state, or the alleged people of the state, then he also represents the alleged complaining party and the cop, who also just happens to claim to represent the state. Under his own rules, a fair trial is still impossible. Bureaucrats are so compulsive about making rules, they fail to see those very same rules completely hamstring their jobs if applied. Here the judge also represents the cop who filed the complaint, traffic ticket, summons, etc., in the first place. This fact is repeatedly demonstrated throughout this book in the way the judge continually comes to the aid and defense of the cop each and every time I try to get down to the brass tacks truth. I would therefore ask the judge if he does in fact represent this cop. This sets the judge up to contradict himself when he assumes the cop's burden of proof. After admitting he represents the state, I would ask, sure, are you telling me you represent the alleged complaining party? If he says no, I ask him to clarify his position. Please explain how you can represent the state and not represent the state at the very same time.
This is classic legal land nonsense. In legal land, a so-called judge can represent the state and not represent the state at the very same time. In the real world, such a person is called a charlatan, crook, swindler, conman, rogue, etc. But in legal land, he is hailed as a scholar, given a small army at his disposal, and relieved of any and all personal responsibility or liability. Just check your local judge's ethics rules. In all probability, there is absolutely no criminal or civil liability attached to their errors. In legal land, judges do not commit crimes. No, these honorable lawyers commit errors. Just a harmless error, even if you spend time in prison getting gang raped. Judges only have their fellow judges looking over their shoulders, who themselves determine what discipline is to be exercised against any one judge that someone may have complained about, if any. They call this sovereign or judicial immunity. It sure feels good to be the king, doesn't it? Another question is this. Sir, seeing how you represent the alleged complaining party as well, could you please explain when, where, why, and how I'm supposed to get a fair trial under these circumstances? I may also ask when the impartial decision-maker intends on appearing and why the plaintiff's, the state's lawyer, is conducting the so-called arrangement. I would also ask why the plaintiff, the state, requires 2 lawyers. I then remind the judge I'm not a lawyer and don't want a trial, I just want to pay the fine. Before doing so, I just want to know what is going on before I pay, unless of course informing me of the nature and cause of the charges and proceedings is a nuisance. If he still refuses, I ask him, why should I enter a plea when there is no evidence of a complaining party, and you will not answer a few simple questions and inform me of the nature and basis of the charges and proceedings against me? The judge will not be able to maintain any consistency with such questions. If he refuses to answer who he represents, I ask who pays him. The judge wants, no, needs to make it look as if the Constitution, an unsigned written document, allows him to hold me there against my will. As if a piece of paper can authorize anything. Paper and ink does not authorize anything, people do. The paper and ink is only to record their will and intentions. Notwithstanding that, such a position is consistent with his opinion he represents the state, and here the state is also the alleged complaining party. This lawyer represents both the state and the pretended plaintiff, the alleged complaining party, the same so-called state. Get it? In the real world, this is not called justice. This is called crazy or just plain nuts. Not only is this nuts, but this presents a serious conflict of interest under their own so-called ethics rules, if you can even imagine for a moment that a so-called judge actually has any ethics rules under these bizarre circumstances, enumerated both above and below. A. There is no independence. Judicial independence is a very popular myth. There has never been an independent judiciary in U.S. courts. If the judge represents the plaintiff, then this is inconsistent with his ethics code mandating independence. An independent and honorable judiciary is indispensable to justice in our society. Arizona Rules of the Supreme Court, Rule 81, Canon 1. B. There is impropriety. This is obvious. A judge shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Canon 2, Arizona Rules of the Supreme Court. This is ridiculous for several reasons. The judge's own rules permit him to suspend whatever rules he wants, such as Appellate Rule 3 in Arizona. Another is the violence. How is confidence promoted by violence? Yes, I'm confident this honorable lawyer will have me killed if I don't play along with his fantasies. Last, where's the impartiality when the judge is a complaining party? C. There is no impartiality. Again, this is obvious. A judge shall perform the duties of judicial office impartially and diligently. Arizona Rules of the Supreme Court, Canon 3. This is impossible when he represents both the pretended plaintiff and also the defendant at certain times. D. There is no disqualification. This is a big one, and I will quote much of their canon here. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including, but not limited to, instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of disputed evidentiary facts concerning the proceedings. A judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge served as a lawyer in the matter in controversy, or a lawyer with whom the judge practiced law within the preceding 7 years served during which association as a lawyer concerning the matter, or the judge has been a material witness concerning it. Canon 3E. Now, I'm no lawyer, but a judge representing the plaintiff, the state, is a conflict of interest, at least in the lay sense. The judge's representation of the pretended plaintiff is acting as a lawyer and is precluded by their own rules. Not to worry though, this is legal land, so the rules, even those that specifically apply to the judges, don't really apply. They are only PR, public relations, to dupe you for pretense. Yes, the rules apply and they don't apply at the same time. The judge's representation of the plaintiff destroys any perception or illusion of fairness, and fortunately their victims don't have to go to law school in order to see that. This also violates at least 4 of their own ethics rules, and that doesn't include their statutes and constitutions. And here I was only being accused of not providing ID. Remember the old lollipop commercial? How many crimes does an honorable lawyer have to commit to convict someone of not carrying ID? This brings us back to what was written earlier with regards to the rule of necessity. The commentary for this rule includes: by decisional law, the rule of necessity may override the rule of disqualification. Whenever bureaucrats feel it's necessary to disregard their own ethics rules, they will do so, even if this means failing to disqualify themselves over any cause over which their impartiality might reasonably be questioned. Would that be legal anarchy? And as we have seen, this happens all the time. Yes, in their legal minds, it is absolutely necessary to deny me any pretense of fairness so they can steal, lay sense, my money and valuable time. Here we can see their very own commentary on their very own ethics rules makes it perfectly clear. You are going to stand trial whether that trial is fair or not, and whether you like it or not. As we can see, this has nothing to do with fairness and everything to do with taking control of my life, liberty, and property using whatever violence and subterfuge a lawyer thinks is necessary. It's all about control. It's all about obedience. No rational lay individual could read the judge's own commentary on necessity and still claim there is a government of laws, not men. Unless, of course, laughter is their objective. Lawyers can and will claim there is a government of laws, not men, because lawyers will have you believe anything. That's their job, even if the lawyer himself does not personally believe the nonsense he is trying to put over on you. I have spoken to many lawyers and know this to be true. One in particular works for the so-called Attorney General in California. This lawyer told me he would defend a revenue agent's actions that were contrary to his professional legal advice. Let me clarify. This lawyer could advise his client not to do something because the act was illegal. If the agent disregarded the official legal advice of his lawyer and was then sued by the person consequently damaged, then this lawyer would defend the very actions he advised against. If they want to render an honest legal opinion for a change, what the honorable lawyers parading around as courts of justice should say is this: you are entitled to a fair hearing, but only if we feel like granting one. By the way, we never do. We can't. As we can now see, these rules, if applied, make it impossible for an honest judge to conduct a traffic case or any criminal case for that matter. This is yet another example of where bureaucrats, in their zeal to ram rules down everyone else's throats, hamstring themselves right out of a job. Bureaucrats cannot follow their own rules and still function. After all, here the judge represents the plaintiff, for goodness sake, so the trial cannot possibly be fair. In fact, it isn't proper to call it a trial at all. It's a joke, a sham, or a charade, but not a trial. A trial is essentially a test, and nothing here is tested except for the patience of all involved. Calling it a trial is a lie. There is another legal term for this. It's called a kangaroo court. If the judge insists on proceeding further, as he usually will, I could ask, does the complaining party have standing to complain? And if he says yes, then I could ask, how and why? The judge could refuse to answer. I would then ask, okay, is there a cause of action here to plead to? He'll probably confidently say, there is. I would then respond, okay, I'm not agreeing or disagreeing, but would you tell me the elements of a cause of action? What makes the judge so sure? If he is sure, then he must know what those elements are. He's so confident not because there's evidence of a cause of action, but because there's a battery of armed men waiting in the wings to carry me off to jail on a moment's notice. Men that do not exercise any discretion of their own. However, no amount of violence changes what a cause of action is or is supposed to be. Putting me in jail does not reverse Supreme Court opinions as far as I know. A cause of action is a breach of a known legal duty that results in loss, harm, or injury. There are many cases showing this. The following is only one from the United States Supreme Court. Quote, like the prudential component, the constitutional component of standing doctrine incorporates concepts conceitedly not susceptible of precise definition. The injury alleged must be, for example, distinct and palpable, Gladstone Realtors versus Village of Bellwood, and not abstract or conjectural or hypothetical, Los Angeles versus Lyons.
The injury must be fairly traceable to the challenged action, and relief from the injury must be likely to follow from a favorable decision. See Simon v. Eastern Kentucky Welfare Rigs Organization. Allen v. Wright, 468 U.S. 733 in 1984. And from Arizona, it is equally true that before one is entitled to a remedy against an alleged wrongdoer, there must be some duty owing from the wrongdoer towards the injured person. State Compensation Fund versus Superior Court. 15 Arizona, 597, 598, 490, Pacific 2nd, 426, 1972. I may ask the judge, is this cause of action factually consistent with the Supreme Court's opinion as to what a cause of action is? If he says yes, I then ask him if he can tell me what facts are before him to support such an opinion and who presented them. There is no damage done because I travel without a license, ID, or other picture card in my pocket. A license may even have been issued to me, but just because I leave it at home does not mean there is damage or a prejudice to the rights of another man, woman, or child. I guess we all walk a fine legal line between being an innocent person and a vicious, heinous criminal who deserves to rot in a cage for 6 months. The quotes from the above-cited court cases are pretty clear. Not only must there be damage, but that damage must be fairly traceable to the challenged action, and relief from the injury must be likely to follow from a favorable decision. Here we can see yet again the laws imposed on us at the barrel of a gun just don't apply to bureaucrats because, in this particular case, by decisional law, the rule of necessity may override the rule of standing. Obviously, this is not fair. There is no injury to people in Parker, Arizona if I don't have ID on me while I'm in Tucson, so maybe the lawyers who wrote the above opinion actually meant to write, it is equally true that before one is entitled to a remedy against an alleged wrongdoer, there must be some duty owing from the wrongdoer towards the injured person, except for individuals pretending to be the state where no such standard exists. The state has standing against anyone that falls within its sights. The issue of standing is supposed to be very important. Just ask a lawyer. The complaining party is supposed to have standing to complain. Without standing, anyone can sue anyone else for anything. It's common sense. There must be something to complain about, with that complaint coming from someone who actually has the right to complain. Although bureaucrats ignore standing whenever they are the so-called plaintiff, it is their first line of defense whenever a complaint is made against them. Isn't that ironic? File a complaint against a bureaucrat, and their first well-rehearsed reaction is to file a copy and pasted motion to dismiss for failure to state a claim or for a lack of jurisdiction. In California, it's called a demurrer. I know they are copies because they do not always change all the names. Thus, another question designed to undermine the false perception of fairness they try so hard to put over is, what is the nature of the relationship, if any, between us? This question really gets to the heart of the matter and is similar to the questions on jurisdiction. Either the judge answers it or he doesn't. I don't care either way because both work against him. In fact, any answer at all destroys any pretended case this bureaucrat is trying to put over. If he doesn't answer, he's demonstrating bad faith because he's refusing to inform me of the nature of the proceedings so I can defend myself. That's unfair even in the legal sense. If he does answer, it will be revealed that this relationship is based on his coercion and threats of violence. I can then ask if he equates coercion with good faith. If he refuses to answer, I tell him I'll be asking the cop the same question. That is, what is the nature of the relationship between me and the pretended judge? After all, his crying about me not having an ID card in my pocket started this mess. He filed the so-called complaint and is supposed to have the burden of proving jurisdiction. I also tell him by refusing to inform me of the nature of the proceedings, I cannot possibly defend myself. It stands to reason if there is no relationship, I should be able to walk away from his courtroom and not have to worry about any further aggression and violence. Because of this, I may ask, am I free to walk away without further aggression? If not, I ask why. Sooner or later, the true nature of the relationship will be revealed by his words or actions, and it will not be consistent with any rational sense of fairness. A common thief points a gun at you and says, your money or your life, and a judge essentially says the same thing except for the fluffy political lingo. You appear in my courtroom or I'll issue a bench warrant for your immediate arrest. All of this is geared toward exposing the true nature of what is happening. No political opinions, no deletion, no distortion, or adding to reality, just the facts. Most dealings with bureaucrats are based upon violence, so they usually do their best to cover it up, to a point. Some will admit to it, although they may also claim it is a last resort. Great excuse. Most criminals would also say the same thing.
It's possibly true that criminals would probably not use violence, or nearly as much violence, if their victims, citizens, residents, simply rolled over and complied with their demands. Can you imagine how that would look as a so-called law? Arizona Revised Statute, Section 13-1105, First-degree murder classification. A person commits first-degree murder if 1. Intending or knowing that the person's conduct will cause death, the person causes the death of another with premeditation, unless it is done as a last resort by a bureaucrat. To illustrate violence is the modus operandi of bureaucrats. Just imagine what compliance would be like if they could not use violence. Or rather, let's look at how easy their jobs would still be if they weren't helped out by their victims. Maybe it's just me, but isn't it the height of arrogance to not ask permission while asking for help? Who would pull their cars over to the side of the road if the cops weren't bent on using violence by any means necessary to get your car to stop? Would anyone ever appear in court if there was no violent mechanism to force you to be there? Sir, please come to court with me, please. If you don't show up, we cannot fine you and the judge will not get paid. How could the shameless assault and robbery going under the political spin eminent domain be accomplished except by violence? To demonstrate bureaucrats operate by violence and have no respect for human life, I'll cite one of their own opinions. Quote, hence, although the goal of extinguishing Aboriginal title could have been achieved by congressional fiat, see Teton Indians versus United States, Idaho versus United States et al., on writ of certiorari to the United States Court of Appeals for the Ninth Circuit, June 18, 2001. Extinguishing title? Who talks like that? What does that mean? It means you're not the owner anymore. We are. Does it look like the lawyers of the Supreme Court have respect for human life or the property they lie about protecting? This opinion is political gibberish for robbery, the taking of property by force and without the owner's consent. No, Your Honor, this guy's nuts. I didn't carjack him. I just extinguished his title to the car. That's all, I swear. These lawyers also write title to property could have been achieved by congressional fiat. This is more political window dressing I will break down. First, Congress is a group of men and women. Second, fiat is defined as an order or decree. Oxford American Dictionary, page 320. What these lawyers are saying is that title to property, ownership, can be acquired by the mere say-so of a group of 535 men and women. Some men and women, Congress, just have to say it's theirs and poof, it magically is. A little political voodoo and sleight of hand and it's done. What wonderful magic, indeed. If you think I'm being harsh or too critical here, then consider the fact the lawyers doing business as the Supreme Court refer to their very own law as wonderful magic. Quote, we must comment upon the final paragraphs of Part 2 of the concurrence's opinion, which bring on stage in classic fashion a deus ex machina to extract from the seemingly insoluble difficulties that the prior writing has created a happy ending. The concurrence manages to have its cake and eat it too, to hand over state law enforcement officers to the jurisdiction of tribal courts, and yet still assure that the officers' traditional immunity, and hence the state's law enforcement interest, will be protected by simply announcing that in order to protect government officials, immunity defenses should be considered in reviewing tribal court jurisdiction. Post at 16, opinion of O'Connor J. What wonderful magic. Nevada et al. Versus Hicks et al. Certiorari to the United States Court of Appeals for the Ninth Circuit, number 991994, argued March 21, 2001, decided June 25, 2001. Wow, and to think when I want property that doesn't belong to me, I actually pay for it or rent it from the owner. In other words, I only do so with the owner's freely given consent. Pretty radical and extreme concept. It's called trade. And by the way, the functions of a public office are defined as trade or business under the Internal Revenue Code at section 7701(26). How's that for a bold-faced lie? What is being traded when the IRS attacks you? Your money for their sparing your life. That's what.
Who would have ever thought that I could just decree a particular piece of property is mine and thereby avoid having to pay for it? I had no idea I possessed such an awesome power to do that, and to think of it, apparently we all do. Well, that's the political theory bureaucrats desperately want us to believe anyway. Bureaucrats would have us believe the lie that Congress, a group of men and women, exercises a so-called delegated authority. Well, if Congress has the authority to just decree property as theirs, then they must have gotten this awesome power from somewhere or someone else.
The theory or opinion is that this pretended authority comes from we the people. This is a myth as silly as the so-called divine right of kings. It's one thing to claim God gave you the right to dominate other men, women, and children, but to claim the person you are dominating gave you the right? Who would freely volunteer to be dominated by another? Okay, I know if I decree my neighbor's car to be mine, and then I take it without their consent, then I'm a car thief and a nitwit to boot, right? And that's true even if I believe it's necessary for me to have that car, correct? That would mean I lack this awesome superhuman power, doesn't it? I'm pretty sure my neighbor has no authority to do that either. After all, what would be the point of robbery statutes if this were not true? Now, if I lack the authority, then I cannot delegate what I don't have to anyone, even a so-called congressman. Using the simple rules of mathematics, we can therefore eliminate any so-called collective right to commit robbery. After all, if my neighbor and I lack that power or authority, then we gain nothing by getting together and forming a gang called a Congress, do we? The simple mathematical principle, the whole is equal to the sum of its parts, applies here. If my neighbor and I have one rock each, together we have only two, not 1,000, as politicians would have us believe. Now, just imagine someone going into court and using the same legal reasoning or defense bureaucrats use to justify their taking of property by force, such as in the case of a carjacking. I'm not guilty, Your Honor, and why is that? Because the rule of necessity overrode that jerk's property rights. It was necessary for me to have his car, and his title was extinguished. You're right. Would you like me to sanction the previous owner for harassing you with his patently frivolous complaint? This isn't really a joke, though. It's the so-called adversary system being portrayed as a system of justice that's a joke. The joke is also on those who take it seriously. After all, if the so-called authority that is allegedly delegated to the men and women called the government is from the people, then the people themselves must possess that awesome power, right? But do they? Do they really have a collective right to commit armed robbery? Do you think you have a collective right to steal? If you lack the right, then anybody pretending to represent you lacks the right. If the people do have a collective right to steal, then nothing would be a crime, and the need for a so-called government would be gone. After all, if anything can be done out of some mere opinion that it's necessary, then there are no rights to be protected. In that case, the Nazis hung at Nuremberg may have used the wrong legal defense. Instead of arguing we were just following orders, they could have taken a clue from bureaucrats here and argued, by decisional law, Hitler's opinion, the rule of necessity overrode the right of any Jew or other enemy to life, liberty, and property. Do you see how crazy this sounds? In fact, another gross contradiction is the legal opinion politicians hold that their legal right to commit armed robbery is superior to the very rights they claim to be protecting. Quote, the power of eminent domain is superior to property rights. Cole versus United States, 91st U.S., 367 and 371, end quote. Quoted in State of Georgia versus City of Chattanooga, 261st U.S., 472, 480 from 1924. In the bureaucratic fantasy world I call legal land, non-bureaucrats, the productive, do not own anything. After all, what is an owner? Quote, owner, one who has complete dominion over particular property. 42nd American Jurisprudence, Property, Section 37, end quote, from Ballantyne's Law Dictionary, page 906. Stripped of lawyeries and political gibberish, the lawyers doing business as the Supreme Court are saying the power to steal property is superior to the right to own property, or the power of armed robbery is superior to property rights. Do you have complete dominion over everything you think you own? Well, think again. In legal land, you don't. You own nothing, not even the shirt on your back. And even your shirt has to be worn in the manner some bureaucrat prescribes. As it turns out, in the minds of lawyers and bureaucrats, we the people don't really own anything because the power of eminent domain is superior to property rights. Yes, that's right. The power to steal is superior to individual property rights, which, as we'll see later, don't even exist in the minds of bureaucrats. And from where was this awesome delegated power acquired? That's right, it's mere fiat, order, or decree, because some honorable lawyers said so. That's why. Silly me, I thought bureaucrats were supposed to protect property. Maybe protect is a word of art, and in the legal sense means to steal. The people have always some champion whom they set over themselves and nurse into greatness. This and no other is the root from which a tyrant springs. When he first appears, he is a protector. Plato. Let's use an analogy here to further illustrate what these politicians are saying.
You bring some of your valuable property to a private storage facility. After paying the agreed upon price for temporary storage, you come back a few months later and all your stuff is gone. You ask the owner about it and he tells you he took it and sold it all, and by the way, the price increased retroactively, so now you must also pay more money before you are permitted to leave. You must also pay for the next 6 months because your account is now considered in jeopardy. If not, then he'll seize your bank accounts. You ask him why he sold your valuables and he tells you, my right to take it is superior to your property rights. He might even say, by decisional law, the rule of necessity overrode your property rights. As opposed to bureaucrats, at least you would not be compelled to keep putting valuables in that guy's place. However, could you imagine how insane such a situation would be? In fact, the situation with bureaucrats is far worse because, as I just wrote, they don't believe individual citizens own anything. They only acknowledge the statist nonsense and fantasy that bureaucrats own everything. Quote, the ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e. law, amounting to mere user, and that use must be in accordance with law and subordinate to the necessities of the state. End quote. Senate Resolution Number 62 from April 1933. Keep in mind, this is not my opinion, nor was it written by Karl Marx or any other prominent communist. It's the so-called law of the land. Reread that last part. That means a bureaucrat believes he has the right to dictate the way you brush your teeth. And there is that word necessity again. Quote, necessity has no law. Ballantyne's Law Dictionary, page 837. Wow, how does that square with the part about the law above? In part, this means the law applies to everyone except bureaucrats. All of this raises a very interesting question. Remember the question that plagued us in early childhood. Which came first, the chicken or the egg? Which came first, individual property rights or the so-called government? Can you imagine what these senators were like as children? If another kid asked a future senator to play in his sandbox, did the senator stand up declaring, okay, I'll play in your sandbox, but this is now my sandbox and you can only use it in the manner I allow you. If not, you will all be held in contempt. This opinion by the Senate is the mother of what lawyers call a non sequitur, which means it does not follow. Ballantyne's Law Dictionary, page 862. This opinion does not mean I am not the owner of my property. This only means there are men and women among us who have no respect for human life, refusing to recognize I do own property. At least a mugger realizes your money isn't his. He says your money or your life, brimming with the supreme self-confidence that only comes from believing you are an exalted sovereign. Bureaucrats say, our money or your life. Now I ask you, which is worse? There was once a time when many refused to believe the earth was round, but that belief didn't make the earth any less round. If someone wants to deny parts of reality, that's his business. Thinking I'm the Easter Bunny doesn't make me the Easter Bunny, and my delusion doesn't interfere with your life. Just because somebody pays me to dress up as Santa Claus doesn't mean I am Santa Claus. The same is true if a man is paid to pretend to be a judge. The problem is some individuals insist on backing their delusions with violence. When that happens, we are forced to accept or to act upon both negative hallucinations and, in a sense, hallucinations, as well as positive ones imposed upon us by bureaucrats. One such negative hallucination is that individual property rights do not exist, while a positive one is that corporations somehow do exist. Again, the Arizona Constitution boasts, governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. Arizona Constitution, Article 2, Section 2. The word derive means the people and their rights exist prior to the creation of a so-called state, if such a thing even exists. As we have seen, it does not. This is a serious problem for bureaucrats. The Senate and Supreme Court hold the opinion that people have no property rights without the wonderful, benevolent, superhuman men and women prancing around calling themselves a government. What rights did the people have to protect in the first place when they allegedly created the state? If the people have no property rights, as the Senate asserts, then why would they need to have a state in the first place? There is nothing to protect. Conversely, if they did have those rights, then somewhere down the line bureaucrats refuse to accept as particular part of reality. In either case, there is nothing to protect. As we can now see, bureaucrats argue themselves right out of a job. As I have said before, don't bring a knife to a gunfight. Know who you are dealing with. Bureaucrats, through their own actions and legal opinions, demonstrate they not only have no respect for human life, but are also extremely hostile towards the reality people have rights at all. Knowing this, I can frame questions so they will expose themselves for what they are. Back to the relationship between the judge and myself. If the judge gets upset, threatens me, and calls security, then he's just proving by his own actions the relationship is based on violence, and actions always speak louder than words. If this happens, then I always like to ask, are you threatening me with physical violence for doing nothing more than asking you a few simple questions? I sometimes wonder if these judges are this violent outside of their courtrooms when there are no armed men ready to carry out their orders. What happens if they are eating dinner in a restaurant and the waitress forgets to bring them a cup of coffee? Do they start screaming they'll have the waitress held in contempt if she doesn't get that cup of coffee fast enough? When she brings the bill, does he refuse to pay her by claiming the charge is legally defective or a nullity because she's not licensed to serve honorable lawyers? Also, as cops wear their costumes all the time, picture a judge wearing his robe while walking down the street on his lunch break. Could a hot dog vendor hand a hot dog directly to the judge, or would he have to hand it to his bailiff, who would then hand it to the judge? At this point, I would ask the judge again, do you equate physical violence with good faith, yes or no? This is really the heart of the matter. There is no way out of questions like these except to be non-responsive, and that is why so many typewritten court orders offer absolutely no explanation for a judge's so-called decision. Instead, their order will only read, motion to dismiss denied. When a judge has no grounds for his decision, he won't give any. Why else would they fall silent? I had a judge give a 3-minute discourse explaining why he refused to permit a court reporter into the court. However, he then vehemently refused to provide any grounds to support his decision, allowing a lawyer to appear unchallenged. This is true even when you notify the judge in advance that you will need an explanation if your request is denied, so the higher court judges can have something to review instead of mere silence. Quote, while district court's decision to seal court documents is reviewed only for abuse of discretion, it is imperative that district court articulate its reasons for electing to seal or not to seal a record. Without full explanation, Court of Appeals is unable to review the district court's exercise of its discretion. End quote. EEOC versus National Children's Center, 98 Federal 3rd, 1406-1407, D.C. Circuit, 1996. The law means nothing to judges and has never stopped them from refusing to give a basis for their decisions. One example is found in the Arizona Constitution. Justice in all cases shall be administered openly. Article 2, Section 11. So when a judge sneers at me, he doesn't have to provide his grounds. I know he cares not a whit for the very law he took a feigned oath to uphold and comply with. I've also had clerks and judicial assistants tell me judges do not have to provide any grounds for their decisions. It's great to be the king. Could you imagine a mechanic doing that? Visualize getting a $3,000 bill after bringing your car in for an oil change. You ask the mechanic what he is charging you for, and he refuses to tell you. Pay the bill or you don't get your car back. You tell his coworker and he snaps. He's the mechanic. He doesn't have to give you a reason. I would suggest that if it's dishonest for a mechanic to do that, then it's just as dishonest for a lawyer to do the same. Also consider a doctor charging you for an additional operation and refusing to tell you what he did to you. Some may argue you could complain to the Better Business Bureau about such a mechanic. I agree, but who do you complain to if a judge does the same thing? To other judges? You stay in the same vicious circle with lawyers who just don't care. Truth does not involve nonsensical legalese, double talk, and no amount of Supreme Court rhetoric, dictum, fiat, or other forms of legal mumbo-jumbo would be responsive when I ask if he equates violence with good faith. A simple yes or no is all that is required to be responsive. Another problem for the judge is that being non-responsive also destroys his pretense of fairness and credibility. In America, you are supposed to have the right to be informed of the nature and the cause of the charges and proceedings against you, at least allegedly, and he's refusing to be responsive and answer a few simple questions. That's easy enough, isn't it? If I am not informed, then how can I possibly defend myself? What if, on the other hand, I hire one of his fellow lawyers, a full bar member just like him? Will he then finally answer my questions? If he will only answer in that event, then I would have a case for bias and prejudice against me, a mere non-lawyer, and in favor of my representative, Mr. Lawyer. The problem is, at least in my experience, no lawyer will ask questions like this because they would then be stripped of their pretended license to practice law, or maybe they are just afraid they will be disbarred. This is because they would be exposing the fact their entire system is a sham. This may also explain why your friendly lawyer is required to take and subscribe an oath to support the constitutions and laws of the state before getting their license to practice law in the first place. To join in on the racket, you must pledge your support to that racket. This is why lawyers have told me I would be disbarred if I were a lawyer. If enough lawyers and non-lawyers were to start challenging and questioning the philosophical and political underpinnings of the entire adversary system with a few questions like the ones described in this book, then the whole thing might finally come crashing down. Trying to get to the bottom of anything in a courtroom, especially the truth, is like working on an X-file because so much appears hidden and nothing is ever as it appears to be. I am not required by law to have a lawyer represent me in order to be fully informed as to the true nature and cause of the charge and the proceedings against me. If I have a right to defend myself, this includes being informed as to what is really going on. However, here's the beauty of this. The judge cannot inform me as to the nature of the proceedings against me without contradicting his pretense of fairness. Typically, the judge will get ticked off with me by this point and will enter a plea for me. If he does, great. I can really put him on the spot by asking, despite my own proposed plea of guilty, you just entered a plea for me. Are you now representing me? This question is not intended to be sarcastic or disrespectful to the judge in any way. It's merely a logical and reasonable question to ask because he entered a plea for me, even though I have a proposed plea of guilty sitting right on his bench. To really see the lunacy in this, picture a salesman acting the same way. I am interested in purchasing the product if it can do what he claims it can do. I just want it demonstrated first. Instead of demonstrating the product and getting my money, he starts screaming at me for not being interested in his product and playing games. Such an imbecile isn't going to win any sales awards. Once again, this demonstrates that all traffic proceedings and courts in general have nothing to do with consent or anything the defendant says or does. Appearance at any trial enables bureaucrats to maintain their pretense of fairness, but it's still just an illusion. See, he had his day in court. No, he could not defend himself competently. We were uncooperative, non-responsive, and argumentative. But he was there physically in the courtroom, and we treat everyone else the same way, so he received due process and equal protection under the law. Oddly enough, as we have seen, even though the Supreme Court is extremely hostile to individual property rights and human life in general, they nonetheless hold the opinion a hearing must be held, quote, at a meaningful time and in a meaningful manner. Armstrong v. Monzo, 380 U.S. 545 and 552 from 1965. Quoted in Goldberg v. Kelly, 397 U.S. 254 and 268 from 1970. By quoting this or other opinions, I'm not implying the Supreme Court actually believes what they write or that they expect other courts to be consistent with their opinions. I'm only demonstrating the inconsistencies. How meaningful a hearing is it when my questions have been ignored? How meaningful a hearing is it when it's based on violence as demonstrated by the fact the judge clearly refuses to respect that I am a human being in full possession of individual property rights? How meaningful a hearing is it when, in the opinion of lawyers, I am incapable of defending myself? Another blatant inconsistency from the lawyers doing business as the Supreme Court is where they write about the exercise of jurisdiction, in particular, that it should not, quote, offend traditional notions of fair play and substantial justice, unquote. International Shoe Company v. Washington, Supra, at 316, quoting Milliken v. Meyer, 311 U.S. 457, 463 from 1940, quoted in Worldwide Volkswagen Corp. v. Woodson, 444 U.S. 286 and 292 from 1980. Excuse me, I'm no lawyer, but when did rational people start believing violence does not itself offend traditional notions of fair play and substantial justice? To put the question differently, if violence does not offend traditional notions of fair play and substantial justice, what does? Legally defective truth, i.e. anything outside of legal land, offends traditional notions of fair play and substantial justice. The exercise of jurisdiction itself is an act of violence that unquestionably offends traditional notions of fair play and substantial justice, unless, of course, the lawyers who wrote that opinion meant to somehow exclude violence at the hands of their fellow bureaucrats. In that case, it's perfectly okay. If all we did was look at the actions of bureaucrats and change their doing business as or alter ego name from the City of Sacramento to Rizzo's Raisin Company, we would have no problem seeing the act of taking control over a person's life, liberty, and property to be an act of violence that offends any and all traditional notions of fair play and substantial justice, however denominated. If taking control of someone else's life, liberty, and property coercively does not offend traditional notions of fair play and substantial justice, then what else is left for a judge to do during a trial to require the Supreme Court to reverse him? I would also share with you this opinion taken from a group of lawyers doing business as the Arizona Supreme Court. Quote, our Supreme Court has also held the denial of due process is a denial of fundamental fairness shocking to a universal sense of justice. Oshrin v. Coulter, See also Kinsella v. U.S. Ex Relatione Singleton, quoted in State Ex Relatione Romley v. Superior Court, 17-2, Arizona 232. Apparently violently taking control of the life of another human being isn't shocking to these lawyers and their universal sense of justice. They must be unfamiliar with the following precedent so important to lawyers. Quote, "For the very idea that man may be compelled to hold his life, or the means of living, or any material right essential to the enjoyment of life, at the mere will of another, seems to be intolerable in any country where freedom prevails, as being the essence of slavery itself." Yick Wo v. Hopkins, 118 U.S. 356, 370. Evidently not intolerable enough, unless, of course, they were silently exempting themselves again. By decisional law, the rule of necessity overrides the right to life, liberty, and property. Rule 81, Code of Judicial Conduct, commentary for Canon 3E1. It is very telling to compare the Yick Wo opinion above with both the definition of statute from the Supreme Court and previous Senate opinion. Quote, statute, the written will of the legislature, end quote. John P. King, Co. versus Council of Augusta, 277 U.S. 100, quoting Bouvier's Law Dictionary. The ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e. law, amounting to mere user, and that use must be in accordance with law and subordinate to the necessities of the state. Senate Resolution number 62 from April 1933. End quote. First, the Supreme Court ruled the essence of slavery was to be subject to the mere will of another, and then the same group of lawyers is saying a statute is the mere will of another. Draw your own conclusions. Now, getting back to the plea being entered for me, I would also ask, if you can enter a plea for me, then can you continue representing me at trial? It stands to reason, especially if this lawyer sitting 4 feet off the floor wants to remain consistent at all, that if he enters a plea for me, then he must also be able to represent a defense for me at trial. If he can represent me at the arraignment, then why not continue doing so at trial? If he says he entered the plea on my behalf, then I may also ask, can you continue representing me at the trial? If he then insists the plea was not on my behalf, I would also ask, if you didn't enter that plea on my behalf, then on whose behalf did you enter it? This violent lawyer doesn't have many options left at this point. This is probably the reason why they are almost always non-responsive. The plea was either entered, 1, on my behalf, 2, on behalf of the alleged plaintiff, or 3, on behalf of the judge himself. If he did it on behalf of the plaintiff, then once again he has a conflict of interest problem and his pretense of fairness is gone. How could a man acting on behalf of the plaintiff enter a plea for the defendant, and why? In his zeal to be fair, impartial, and independent, he started representing both sides. If he did it on his own behalf, then he is somehow a party to the case. I would ask him if, in fact, he is a party. This raises the fairness as well as the conflict of interest issue. After all, how can an impartial judge enter a plea for me and for himself as well, and at the same time? Also, how do you enter a plea for someone else on your own behalf? This is a rough spot for a judge to be in. He has to maintain a pretense of fairness while at the same time refusing to accept my plea of guilty and entering a plea for me as my lawyer. And this is while also representing the professed plaintiff. By this point in time, my perception of fairness is gone, and I doubt any rational person is buying into his charade any longer. Instead, the judge is starting to strain the patience of all those unfortunately present in his courtroom. I've had a judge say I was refusing to plea when a proposed plea was on his bench. I had been held on a ransom called a release bond and told him I was going to assign the bond over to him for the fine. He still insisted I was refusing to plea and set the matter for a pretrial. If I pulled stunts like that, I might risk being institutionalized and put on medication. In response to this legal babble, I'd object to what the judge is doing and leave the court date in hand, although I might want to consider a change of judge first. The grounds for such a motion would be both the bias and prejudice and conflict of interest already exhibited. Why else would a judge refuse to answer a few questions while refusing to accept a plea of responsible or guilty? Also, how does this judge explain away the fact he represents both the plaintiff and myself at the very same time? In Arizona, if a judge does not disqualify himself under such circumstances, I can file a special action to have his decisions reviewed by a higher court. This usually stops, at least temporarily, a traffic case. It must, however, be noted that it is just not possible for them to give me a fair trial even if they get another judge, because each judge will still represent the alleged plaintiff. If he does not represent the plaintiff, then he's there on his own. In that case, he's nothing more than an individual violently taking control over my life and cannot, for that reason alone, claim the Constitution is his lawful authority. This lawyer with the robe is a cruel one-man show. He represents both the plaintiff and the defendant while pretending to be independent and impartial. No one else really needs to show up to put on a trial because he does it all. It's a no-win situation. If he doesn't represent the plaintiff, then he cannot claim to be authorized by the Constitution without contradicting himself. If he does represent the plaintiff, then the conflict of interest and lack of impartiality is self-evident. In other words, the judge is the ringmaster of a very bad dog and pony show designed to put forth an illusion of justice.
Chapter 9. What role does the pretended cop play? One of the benefits a traffic case has over a lot of other bureaucratic attacks is the face-to-face confrontation still available. You are able to confront your accuser in traffic cases, unlike situations with the IRS, where the accuser is protected by an army of attorneys. Once a majority of people start effectively challenging cops, this confrontation will be denied. This denial will probably be justified with something like this. By decisional law, the rule of necessity may override the rules of cross-examination, evidence, and a fair trial. This has already been started. In most areas, the rules of evidence with regards to so-called civil cases have been completely wiped out. Arizona, for example, has, "The Arizona Rules of Evidence shall not apply in civil traffic cases." At Rule 19, Arizona Rules of Procedure, Civil Traffic Cases. Rule 14 wiped out pretrial discovery. If bureaucrats were truly interested in fairness and justice, they would have never scrapped their rules of evidence. This is proven by reading what they say is the entire purpose for the rules. Keep in mind, this was not written by a bunch of bitter non-lawyers, but by honorable lawyers. Quote, "These rules shall be construed to secure fairness in administration, elimination of unjustifiable expense and delay, and the promotion of growth and development of the law of evidence, to the end that the truth may be ascertained and proceedings justly determined." End quote. This is Rule 102, Arizona Rules of Evidence. Well, we bureaucrats can't have fairness, truth, and justly determined proceedings in traffic court. If we did that, we'd never win a case, so what do? Well, this is what we'll say. The Arizona Rules of Evidence shall not apply in civil traffic cases. Why else would the rules of evidence be scrapped? Let's see. Expediency and cost? No, they say the rules are designed to eliminate unjustifiable expense and delay. This was done to keep the truth from being ascertained and the proceedings to be justly determined. How many civil traffic tickets do you think a cop would give out if he were subject to full pretrial discovery, including depositions, each and every time? In that event, a cop could not give out nearly as many tickets because he would be spending more time in submitting to depositions than giving out tickets. In Arizona, the admitting of evidence is at the sole discretion of the judge or hearing officer. Do you think a man who takes control of another man's life without the latter's consent is going to be fair? No, he's not, especially when he has a financial interest in the outcome of the case. If this politician had any respect for human life and any intention of being fair, then he wouldn't take control of other people's lives by becoming a judge or hearing officer in the first place. Do you like the idea of violently dominating other people? Do you equate that with being fair? And how fair can he be when he represents both the plaintiff and the defendant? There is no merit to any claim the judge is required by the judicial ethics rules to be impartial for no other reason than the fact that, quote, "By decisional law, the rule of necessity may override the rule of disqualification." End quote. Rule 81, Code of Judicial Conduct, Commentary for Canon 3E1. As we have seen throughout this book, the rules mean nothing to these people. It doesn't matter what the rules require when they are ignored, and they can be. Believe it or not, judges even have rules saying they can ignore the rules in the furtherance of justice. This last phrase means to steal property under the guise of protection. Judges ignore the rules because they'd be out of a job really fast if they didn't. All of the questions I put to the judge at my initial appearance, or arraignment as they call it, may now also be put to the cop. After all, this is the individual who made the complaint and started this whole mess in the first place. I intend to make him or her support every single legal opinion made against me. Cops usually sign tickets under penalty of perjury or some other kind of pretended certification. What is important here is the ticket contains the cop's testimony. For example, in Arizona it says, "I hereby certify upon reasonable grounds I believe the person named above committed the acts described ... Believe it or not, lawyers have argued with me claiming the ticket is not testimony. Some have claimed that a revenue agent's so-called assessment was not testimony, and neither was the agent a witness. Go figure that one out. This written testimony typically consists of nothing more than a bunch of legal and or political opinions.
This cop thinks I broke the law. He believes I drove without a license or some other equally inane legal jargon. This means he has formed at least 2 legal opinions. He has determined the law obligated me in some way to have a driver's license, and despite this alleged obligation, I failed to have a license. He has also certified he has reasonable grounds to support his opinions. The cop signs the ticket either as a witness, and in some places such as Arizona, he signs it as the complainant, as if he personally is bringing the complaint against you himself, as if not having his seatbelt on is a crime against him personally. However, once the matter is in court, a little political magic and sleight of hand turns the so-called state into the alleged complaining party. This is why I say the state is just an alter ego for the cop. At the trial, once the case is called, the judge will usually ask if I am ready to proceed. This is only asked to provide the illusion of fairness. The trial will go on regardless of my being ready or not. Despite this, I say I'm not, because I don't understand the nature and cause of the charges and proceedings against me. Therefore, I have a few questions I would like to ask first. This is especially true if there is a lawyer there claiming to be the state persecutor. This lawyer, the so-called prosecutor, does not wear a black robe, though many aspire to. I've noticed many judges are former persecutors. He is not supposed to be a witness or a party to the action. Maybe it's just me, but I don't remember seeing an attorney standing next to the cop during the stop. He is supposed to be representing. Remember, this means to stand in the place of a party. In this case, the alleged plaintiff, the state and/or the cop and/or the judge. This point is extremely important and should not be overlooked. Try and make sense of this. The cop represents the state, which allegedly includes the judge, prosecutor, and me. The prosecutor represents the state, which allegedly includes the cop, the judge, and me. The judge represents the state, which allegedly includes the cop, prosecutor, and me. Even though not a part of a state, the judge still represents me when entering a plea for me. Does this make any sense to you? Still think it's a fair process? I always challenge the plaintiff's right to appear in a representative capacity. Though this may really irritate the persecutor and his lawyer wearing the black robe, it's supposed to be a standard legal challenge. As far as I am aware, every so-called state has a rule equivalent to Federal Rule 9A, allowing anyone to challenge the appearance of both a lawyer and his alleged client. In Arizona, in civil cases, it is called Rule 9A, which states, quote, "It is not necessary to aver the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons that is made a party." Close quote. If you still doubt this is a standard legal challenge, then have your best friend represent you without being a member of a state bar association, your local lawyer's union/labor organization/closed shop protection racket. You'll find out real fast just how passionate judges and lawyers are about someone being qualified to appear in court in a representative capacity. Keep this in mind if you are not permitted to challenge a lawyer's presence. I've had a lawyer from a local prosecutor's office tell me on tape he could not prove he had a client, and at the same time, he also thought that whether he had a client or not was irrelevant. Unfortunately, he did not feel the same way about having a defendant. This lawyer did not believe having a client was relevant. Would an honest judge permit such nonsense? Would you buy such BS? No less than 5 honorable lawyers in Arizona accepted such lunacy. I filed a special action in the Arizona Superior Court against 2 city judges involved in that traffic case. The same prosecuting lawyer showed up for the first hearing. I again challenged his appearance under Rule 9A. The judge refused to permit it and allowed him to appear unchallenged. How's that for favoritism? As he permitted a lawyer to just walk in off the street and appear without a client, this judge stated there were no Rule 9A challenges in his court. I asked him if special actions were civil cases, and he agreed. I then asked him if civil cases were governed by the Arizona Rules of Civil Procedure, and he said, "I'm aware of what rules govern these proceedings. What's your point?" I said, "My point is this. If the Arizona Rules of Civil Procedure govern the proceedings, then Rule 9A applies, and I'm going to challenge this lawyer." The judge was not pleased, and 2 armed deputies suddenly arrived in the courtroom at that point in time in order to observe. Do judges have a panic button under their bench they can press whenever they feel personally threatened by a rule of court they have sworn to comply with? When all was said and done, no less than 4 different judges permitted this lawyer to appear unchallenged. That indicates a pattern. Apparently, in their mind, it was necessary to disregard this rule. After all, a fellow lawyer could not prove he had a client, so to enable him to appear, it was necessary to override Rule 9A. What a concept. A lawsuit without a plaintiff. On appeal from the traffic court, I again challenged the same lawyer's appearance, and the judge, the fifth one, said this lawyer could appear unchallenged. Okay, I thought, no need to argue. I had Moses with me and told the judge I wanted him to assist me. The judge refused to permit Moses to do so. I said, "You're permitting lawyer X to appear unchallenged, yet you challenge his standing to appear in court on my behalf. That's not fair." This judge was not happy either and vacated the hearing, saying I should be shown the door. In other words, as far as this judge was concerned, it was do as I say, not as I do. Bureaucrats do not like to be one-upped at all. With bureaucrats, it's always my way or the highway. This judge then issued a minute entry, a written order sent through the U.S. mail, stating I refuse to address the substantive issues on appeal. So, here he was saying a standard Rule 9a challenge is a way of refusing to address substantive issues in a traffic case when, in reality, it went to the very heart of the case. There was no complaining party other than some cop who didn't know what a licensed city, statute, or state were. What's incredible here is the persecutor knew he could not prove he had a client, yet it did not stop him, and no less than 5 different judges let their fellow lawyer get away with it. Why? Why the consistent pattern of refusing to comply with a basic rule of court? What are the odds this was all an innocent mistake? And why did armed men come into one of the courtrooms? To merely observe? And don't forget, this is not an isolated incident. This happens all the time, and regardless of the geographic location. Why the pattern? And just as important, how? And just in case anyone still thinks this is a frivolous issue, consider the so-called law of the land, to wit. Quote, courts must look behind names that symbolize the parties to determine whether a justiciable case or controversy is presented. End quote. United States versus Interstate Commerce Commission in 1949. Do you see that spewing forth State of Arizona ad nauseum is not responsive to my question asking if there is evidence of a complaining party? The name only symbolizes the alleged party. Exactly what is being symbolized, though? Whatever is being symbolized, this lawyer playing prosecutor is supposedly standing in place of it, and his buddies, judges, will use whatever physical violence is necessary to prevent it from being exposed. If there was evidence of a complaining party, then the lawyer acting out as a prosecutor could and would have complied with his own sacred law and provided it easily. After all, prosecuting is something they do every day. However, no less than 5 judges permitted him to appear unchallenged, and his own testimony proved there was no complaining party other than the cop himself. The only damage that might have been caused by my not providing this cop with ID was that done to his precious ego. How many lawyers would bring a case of bruised ego into court? None, unless it's a case for a pretended state. Cop: but Your Honor, I asked for ID and he didn't have any. Judge: off with his head. Is death really too harsh a punishment for not providing ID on demand to some stranger dressed up like a cop? Is this really so out of the question? Would a bureaucrat kill someone for that? Let's examine that for a moment. Let's just hypothesize a situation where a man has no ID. Although he is not a threat to anyone as he drives around, a cop wants him to stop. This nonviolent man chooses not to stop, though. In fact, he chooses not to cooperate at all. How is the cop going to get this man's car to stop? I need not explain that this will involve violence. This violence could lead to the cop shooting the man. Even if not murdered on the scene, let's say the man is given a ticket and he does not cooperate again by failing to show up in court. He decided he'd just rather eat cereal and watch cartoons that morning. If a so-called bench warrant is then issued, as it will be, cops are now authorized to use deadly force, if necessary, there's that wonderful word again, to get him into that building. I think it's clear to bureaucrats that death is a just punishment for not having ID on you. Or maybe death is really just the punishment for bruising the cop's ego because his demands were not complied with, or not complied with fast enough. Your money or your life, or your ID or your life. What's the difference? Bureaucrats don't kill people for violating laws. No, no, no. That's barbaric. Bureaucrats only kill people to ensure that they stand trial for breaking those laws. Maybe that is how bureaucrats get past the cruel and unusual punishment clause in the Constitution. It was not a punishment in the legal sense. No, it was the natural consequence of his peaceful disobedience. Before proceeding, I ask the lawyer, or the cop, is there evidence of a complaining party? Just a simple yes or no answer will do. If the judge attempts to interfere on behalf of his cronies, I ask the judge, who has the burden of proof here? Judges in traffic courts usually need to be reminded it is supposedly the plaintiff, and not the defendant, us, their victims, that has the burden of proof. If so, I might point out the following rule. Quote, the judge presiding at the trial may not testify in that trial as a witness. No objection need be made in order to preserve the point. End quote. Rule 605, Arizona Rules of Evidence. Perhaps this is the reason why the rules of evidence were thrown out in civil traffic cases. Maybe by doing so it permits the judge to testify against me without submitting to cross-examination. The burden of proof is supposed to be on the complaining party beyond a reasonable doubt in criminal cases and by a preponderance of the evidence in civil cases. The judge, consistent with the rules, common sense and fairness, is not permitted to jump in and answer such questions for the plaintiff. This is true even if he does not represent the plaintiff. Marcia Clark was not permitted to testify for Cato, for goodness sakes. Again, I ask the judge what is his role in this if he insists on helping, representing, the alleged plaintiff. If he insists on having the right to repeatedly jump in and testify, then I will remind him of my right to cross-examine him. I will also remind him of Rule 605. As previously shown, evidence of a complaining party does not consist of merely having the name of that party, such as the state. If that's all they can or will provide, I will tell them that such an answer is non-responsive to a question which only requires a yes or no answer. What in the world is so difficult about answering yes or no? I don't let the cop, judge, or lawyer get off point here. The point is critical in that it does more to expose them than almost anything else I can think of at this point in my experience. That's why I keep asking them, even if they tend to get very upset. It is easier to see why this is so important if you look at it this way. Imagine you get served with a summons and complaint from people you have never heard of before. So you just accept they have standing to complain. Think about this for a moment. Why would politicians get upset just because I am asking for evidence of a complaining party? The reason is because, like the lawyer who said who he was representing was irrelevant, they know they cannot provide any facts to prove there is a complaining party other than themselves. But who are they? Who are these violent strangers presuming to have the right to interfere with my life and that of others without anyone's freely given consent? Bureaucrats act on behalf of themselves under a collective alter ego known as the state, a thinly concealed protection racket. I am exposing the fact that the phrase the state of Arizona or city of San Diego, etc., is just an alter ego shared by the cop, the prosecutor, and the lawyer representing them both, the pretended judge. It is merely an idea, a mental conception or fantasy that has no real, tangible existence outside of someone's head. It's just like Santa Claus. Yes, people can dress up as Santa Claus, but that doesn't make them Santa Claus. Santa Claus is just an idea that may have once seemed very real to you, but as you grew up, it no longer did, and for good reason. There is no state, and that's why judges refuse to comply with Rule 9a and such precedent from the Supreme Court quoted above. Courts must look behind names that symbolize the parties. The difference, however, between Santa Claus and the state is that no one is using a gun to force me to believe in Santa, and if someone did, they wouldn't be hailed as a hero or honorable. Other than their guns and an insatiable appetite for violence and domination, the only thing bureaucrats have are their opinions. For example, I once had a judge in Arizona tell me the state of Arizona was an act of Congress from 1911. Who was I to argue with her, other than pointing out she was testifying against me on behalf of the cop? How is an act of Congress a complaining party? What obligation do I owe, and how did I damage an alleged act of Congress? Better yet, exactly where, when, why, and how was I within or subject to an act of Congress? By her own admission, the state of Arizona was not the ground. That, however, was the cop's only basis to claim that I was within the state. Do you think the cop was thinking of an act of Congress when he testified I was within the state? Yeah, this is Officer Gruden. I'm observing a white male within an act of Congress without ID. Send backup now. Lots of backup. Even if I were to accept the opinion that the state had a tangible existence, such as a group of men and women, why should I accept the opinion this cop or some lawyers represents every one of them? How about their opinion that there was a cause of action against me? How did I damage this group of people? What possible obligations could I have to this group of unidentified people, and why? You see, this is why I question everything. The more you examine what these people say and do, the more it falls apart. The state is not a natural phenomenon. It's man-made and exists only in the mind. There are no naturally created states. They are all artificial. Prior to July 4th, 1776, there were no American states. There were allegedly American colonies. The colonies were magically transformed into states by nothing more than words being scribbled onto pieces of paper called constitutions. However, unless you believe in childish ideas such as magic, then you know that words on paper create nothing. Currently, the summer of 2002, there is a lot of talk about a Palestinian state in the Middle East. The land is there, and the Palestinians are there, but where is their so-called state? A state is nothing more than a state of mind. A nation is nothing more than a hallucination. A country is... starting to get the picture? You see, merely by asking, is there evidence of a complaining party? I'm exposing the fact that there isn't one, at least not a tangible one. There's just an illusion in someone's head. In other words, there is no state. As I like to put it, can I hit a state with a rock? To put the question differently, can I put a government in a wheelbarrow? No, I can't. In stark terms, we can destroy the physical infrastructure of a country, but if the people remain, the state remains because their country, or group identity, was all in their heads to begin with, not their land. They merely associate their country with their land. Many think the state is the ground, that the geographic landmass Arizona is identical in all respects to the state of Arizona. This is not only false, this is absurd, and for many reasons. I will provide only one more example. If the state were the ground and only the ground, just as a table is just a table and not a book on the table, then the complaining party in a traffic case would be the ground. Now that's insane. Obviously, the state is not the ground. A state is not geographic or even tangible. If it's anything, then it's political. The shocking reality behind all of this is, if evidence could be admitted to prove there is a group of individuals out there who entered into some sort of agreement, there is still no evidence I'm obligated to them or have damaged them in any way. To think I can somehow damage someone in Page, Arizona, if I don't have ID on me when driving down the street in Phoenix, Arizona to get a box of raisins or other dried fruit of your choice, is patently insane. Anyone with such a belief would be laughed at as a nutcase. However, put a costume on that same individual, give him a gun, a really cool-looking badge, a car with fancy lights on top, and a total lack of discretion and personal responsibility, and so forth. That is why I may also ask, is there evidence of a cause of action against me? I keep a record of their answers as best I can because the odds are they are going to be non-responsive to each and every question. I also like to point out the contradictions whenever they arise. Being non-responsive is itself proof the so-called trial is unfair. As previously stated, the Supreme Court holds the opinion that to satisfy due process, a hearing must be meaningful. It hardly needs demonstrating that being non-responsive falls far short of being truly meaningful. And on that point, can a trial based on violence be meaningful to begin with? To then add almost complete non-responsiveness to the violence certainly seems extreme and unnecessary, unless, of course, the Supreme Court believes meaningful means sham, charade, joke, etc. Not surprisingly, the judge will usually ignore my questions and pretend I'm not even there. They do this by calling the cop up to the witness stand to testify despite any and all objections I may raise. If you see this in person, you'll know firsthand that these proceedings have nothing to do with fairness. I have had cops admit in depositions they lacked personal knowledge of the facts, and judges have still permitted them to testify. Indeed, these trials resemble a dog and pony show, and a bad one at that. I mean, some of these so-called judges don't even give you pretense of fairness. That's how ridiculous they are. No, to them, naked aggression is the rule. That is why I am never permitted to videotape the proceedings, and there is never a reason given, despite the fact the rules permit it. Even so, in legal land, judges don't have to give reasons for anything. It boggles the imagination when you consider that in the Mesa City Court, so-called criminal proceedings are videotaped every day. Just walk in and you can see several being broadcast in the lobby. During direct examination, if the persecutor or the judge asks the cop a question that assumes facts not in evidence, I object on those grounds. This is basically his entire testimony, though. There is humor somewhere in there, but I'm not laughing. Most of the cop's testimony will consist of rambling, time-worn legal opinions such as his seeing me within a pretended city. Well, unless a city is a particular geographic area and nothing else, it's not, then our cop has assumed facts not in evidence. He has also drawn a legal opinion that is supposed to be based upon facts already in evidence. The judge will really expose his true nature if he overrules this objection. It is unfair to permit a witness to assume facts not in evidence. Just ask a lawyer. A big one is if the lawyer asks the cop a question requiring him to draw a legal opinion or conclusion, such as, did you see Mark commit a crime, or driving without a license? This is a very serious glitch in the system I've exploited for years. They will always allow the cop to testify he saw me commit a crime or violate a so-called statute. However, if I ask questions any more difficult or probing than that, the lawyer and the judge will run to the rescue of their client, partner, and refuse to allow him to answer any such questions. That's exactly the point of the questions, though, to make them run full bore into a corner. If I object to a question requiring the cop to offer an opinion such as, I saw Mark violate a statute, and the judge overrules that objection, I don't worry because I know the judge will contradict himself later on when it's my turn to cross-examine the cop. The judge is headed for a pretty bad time for allowing the cop to continue giving legal opinions because he has permitted the cop to assume facts not in evidence and has overruled my objection that a question called for a legal conclusion. My cross-examination is geared to taking advantage of these rulings by helping the judge back himself into a corner so he will contradict himself and throw out every rule of fairness in his sacred little law books. I know from experience that cops will not be permitted to answer questions such as, what is a statute? This is why I deliberately set them up to contradict themselves. Some lawyers have proudly proclaimed the cop doesn't need to know what a statute is to prove I violated one. Really? Maybe you can also perform brain surgery without knowing the brain is in the skull. Where is the personal knowledge? Without the lawyerese, shouldn't the bare minimum for a witness to be credible be that he at least knows what he's talking about? The point is not to be argumentative, but to get the case thrown out so I can go back to being productive instead of wasting my time with these crooks, dressed in suits, robes, and other idiotic uniforms. Chapter 10. How I Cross-Examine a Bureaucrat. My objective in questioning bureaucrats, whether a pretended cop, revenue agent, or any other imposter, charlatan, swindler, etc., is to show there is no case against me, except groundless legal opinions backed by violence. The only effective way I know of doing this is to ask him what facts his legal opinions are based on. This essentially strips bare all of the deletions, distortions, and additions to reality the cop or other bureaucrat has made. Remember the example with the salesman earlier? If a salesman throws you a line of BS about his product, then the easiest way to prove he's a con man is to ask him to demonstrate it. You just sit back and watch the moron embarrass himself. According to their own bureaucratic rules and precedent, I'm supposed to be able to question the cop on all his prior testimony and any new testimony the judge relies on. This includes challenging any documentary and or other evidence being used against me. Refusal to permit this is supposed to be one of the worst errors judges can make. Quote, undue restrictions on the right to cross-examine strikes at the very heart of the adversary system. A denial of cross-examination without waiver would be a constitutional error of the first magnitude, and no amount of showing of want of prejudice would cure it. End quote. Quoted in Burkhart v. Janus, quoted in Smith v. Illinois, quoted in State v. Hanley. Before any lawyers protest, this is only for so-called criminal cases, please reference the following precedent. Quote, this court has been zealous to protect these confrontation rights from erosion. It has spoken out not only in criminal cases, e.g. Mattox v. United States, Kirby v. United States, or Motes v. United States, but also in all types of cases where administrative and regulatory actions were under scrutiny, e.g. Southern R. Company v. Virginia, Ohio Bell Telephone Company v. Public Utilities Commission, Morgan v. United States, Carter v. Kupler, and Raleigh v. Pincus, quoted in a decision from Green v. McElroy in 1959. This Supreme Court then quoted the following in regards to confrontation. Quote, for 2 centuries past, the policy of the Anglo-American system of evidence has been to regard the necessity of testing by cross-examination as a vital feature of the law. The belief that no safeguard for testing the value of human statements is comparable to that furnished by cross-examination, and the conviction that no statement should be used as testimony until it has been probed and sublimated by that test, has found increasing strength in lengthening experience. Close quote. That is, more truthfully, no statement, unless by special exception, should be used as testimony. Even without these opinions, it's common sense and self-evident that using evidence not subject to challenge is unfair and a mockery of justice, if there is such a thing in these lawyer-made and lawyer-run courts. The whole point of a trial is to give you an opportunity to defend yourself, to essentially test the evidence being used against you. As previously stated, calling it a trial is itself a lie. If one cannot challenge the pretended evidence, then what's the point, and why require my presence at the barrel of a gun? Public relations. I want the lawyer and the judge to say the cop cannot testify because my question calls for a legal conclusion. That is my opportunity to ask the judge if the cop's entire testimony, including the ticket, should be stricken from the record. In other words, treat it as though it never existed and the complaint was never made. I also want to point out the judge's previous ruling where he did not allow the cop's legal opinions to become a permanent part of the record. Always expect contradictions. This is accomplished by purposely asking the cop if he witnessed me commit a crime or a civil violation. I can ask the same question the prosecutor asked earlier, which is, of course, what started this mess in the first place. Chances are there will be no objection to this question, and that is precisely what I want, just one more inconsistency. The cop will say yes, and I might even show him his ticket in order to help him out, assuming he needs the help. I then ask, was that an arbitrary opinion? If he understands what arbitrary means, believe it or not, some cops don't, then he will answer no. Then I ask, so that opinion was based upon facts currently within your knowledge? He will probably answer, yes. This is not an enviable position to be in as a witness. He's just testified that he has facts to support his opinion the law was obligatory on me. However, his entire testimony consists of nothing but inane legal opinions he learned in the police academy and the police department locker room. I have questioned IRS agents in the same way and have been quickly shown the door. In some cases, men and women doing business as the IRS have refused to permit hearings and settlement conferences because they just can't support their barrage of legal gibberish. If they do not or cannot tell me the facts, then both their pretended case and pretense of good faith are gone. They are either concealing evidence or they lied about having it in the first place. Refusing to answer questions is also grounds to get testimony stricken. That is why there is no need to fight or argue. I had a supervisor at the Arizona Department of Revenue tell me his subordinate had every right not to answer questions in regard to a subpoena he served on someone. I then reminded him that I didn't care whether the question was answered or not because the judge then had every right to quash his beloved subpoena. So go right ahead and refuse to answer questions. I then asked the cop, what are those facts? This usually causes the persecutor to immediately stand up, objecting on the grounds the witness may not testify because it calls for a legal conclusion. The same objection I previously made. The judge then obediently sustains the objection, oblivious to the fact I asked for the facts and not another nonsensical legal opinion. At this point, I don't argue with them or say they are wrong, other than to point out I only asked for the facts, so the legal conclusion has already been drawn, again without objection. The judge, as well as the other two bureaucrats in the courtroom, is now in a particularly difficult spot. He may have previously overruled my objection. The witness, the cop, could not draw legal conclusions, and has already permitted the cop to testify that he witnessed me commit a crime or civil violation, which is itself a legal conclusion. He has now sustained the exact same objection with the same witness. The judge's actions are now plainly inconsistent and to my obvious prejudice, so much so that even a non-lawyer can tell it isn't fair. To make the judge even more uncomfortable, I then ask, okay, since the witness may not draw legal opinions, then shouldn't his testimony, including the ticket, be stricken from the record? This is a checkmate for the judge. If he refuses to strike the testimony and ticket, then he may not deny cross-examination. If so, this is supposed to be a huge incurable error on the part of the judge and should be reversed on appeal. I would then ask, are you going to rely on the witness's testimony? He may not answer this question, but his actions will establish whether he is or he is not. If he does strike the testimony, then the case is over because without any testimony there is no evidence, and without any evidence there is no case. Without a case, the judge would be basing his decision entirely upon his own opinion. Despite happening every day in traffic courts, this is unfair because the judge is witnessing against me and I cannot cross-examine the judge. Unless he wants to jump in the witness chair, he shouldn't be pretending to be a witness. Indeed, the judge has nothing whatsoever to do with the case except for the fact that he is now trying to profit off of it. The same holds true for any lawyer who claims to be representing the pretended plaintiff, the intangible so-called state. I also point out that the judge previously overruled the same objection that a question called for a legal conclusion on the part of the cop, and now he is sustaining the exact same objection. Excuse me, Mr. Honorable Lawyer, but which one is it? If you don't believe any of this, try it for yourself during your next encounter with the judge. Watch how the judge toys with you as though he's a great big cat and you're just a little old mouse or a ball of string. For the time being, believe it or not, the same witness can and cannot answer questions that call for a legal conclusion. This is classic legal land nonsense, where the very same objection with the very same witness gets a yes from the same judge in one instance and a no from the same judge in another, and all in the same case. Does this remind you of Alice in Wonderland? This sort of now you see it, now you don't legal trickery is commonplace in American courtrooms. In fact, this reminds me of a line from that classic tale by Lewis Carroll. Quote, nothing would be what it is, because everything would be what it isn't. And contrariwise, what it is, it wouldn't be. And what it wouldn't be, it would. You see? End quote. That's how bureaucrats really talk. Can you imagine if your doctor did his job with the same degree of precision? You need heart surgery. Then again, you don't. You're going to die in 6 months. Well, there's really nothing wrong with you. How about a plumber? How long would he be in business if he acted like these judges? That pipe's busted pretty bad, and, well, it's just not. It is, and, well, it isn't. A plumber couldn't get away with such lunacy because he can't hold his customers in contempt. Imagine going to a store, and you go to the checkout counter with a box of raisins marked $2.99. The cashier tells you the raisins are $150, plus administrative costs for his having to ring you up. You tell him the raisins are marked $2.99, and that's how you're going to pay for them, and only an imbecile would pay $150 for a little box of raisins. The cashier gets angry and says, "It's my register, you're in my line, it's my store, and you're going to pay $150. You tell him, "That's not how you understand it. The box is clearly marked $2.99. He says, "That's your interpretation. It costs what he says it costs, and if you don't like it, hire another grocer to explain it to you." You refuse. Give the raisins back and start leaving so you can buy raisins from a normal person. The cashier then snaps at you that you're now in contempt of store, and you have to pay not only the $150 to be released from the store, but you must also pay the costs of keeping you there. If you don't like it, you can appeal it to the store's managers after you've paid this new bill. If you somehow manage to get away from this nutcase, he might then issue a warrant and give it to store security, who would then be authorized to use deadly force to arrest you and bring you back to his store. And if that's not bad enough, the cashier has no personal liability for his actions because cashiers must be free and independent. Would anyone accept such behavior from a cashier? If not, then why do they accept it from a pack of lawyers? What separates cashiers from lawyers? Why are lawyers able to foist this madness on others while cashiers cannot? Cashiers do not provide their services at the barrel of a gun. Getting back to my cross-examination of the cop. Other questions I may ask have to do with the other legal opinions the cop has already made. Good examples are, I was driving without a license and that I am within a city or a state. It's always a good idea to ask the cop to repeat his prior testimony. For example, is it your testimony that I was driving without a license? This question tends to upset judges and prosecutors. Another is your testimony I was driving while my privilege to do so was suspended? Why get upset? All I am doing is having the cop repeat his prior testimony. After all, he has already claimed it on the ticket, and I am supposed to have the right to confront all witnesses against me. However, judges appear to know the cop cannot provide any facts the opinion was based upon because there are no facts. A great question is to explain what a privilege is factually and do so without using the word license. The judge and the cop's other lawyer will not permit the cop to even attempt to answer such a question. I was once in the Phoenix Superior Court on a new trial for a traffic ticket. The client had impeached the cop in the trial in the Scottsdale Justice Court, and yet the judge said the cop's testimony was irrelevant. How's that for a big surprise? This judge was actually saying a man was guilty of a crime while the judge himself was admitting there was no evidence. Not surprisingly, after this case was lost and appealed, the judge just happened to lose the entire record of the case. That is why the Superior Court had to order a new trial. The charge was driving on a suspended license, whatever that's supposed to mean. All my client did was ask the cop sitting on the witness stand if that was his testimony. The prosecutor, pretending to represent the state, jumped to his feet, objecting on the grounds that answering this question called for a legal conclusion. Apparently, this lawyer failed to recognize this legal conclusion was already on the ticket he so desperately relied on for an ostensible conviction. Just feed their opinions back in the form of a question. The judge refused to permit the cop to answer the question. The client asked why the cop could not verify his own prior testimony, and the judge got furious and started yelling. I stood up and said this was only the charge on the ticket in question, so what was the big deal? Per the judge's order, I was then escorted out of the courtroom by two armed men called deputies. The deputies were stunned at what the judge had just done. They asked me to explain what just happened. They could not understand why the judge refused to permit the cop to answer what the charge was. Those two deputies were ready to use whatever violence was necessary to get me out of that courtroom, and yet they had no idea why. We was just following orders. The reason why the judge did not want the cop to verify his own prior written testimony presented on his own traffic ticket, or to even discuss it, was simple. It was an arbitrary legal opinion. It was pure fantasy, and those two lawyers knew it. I testified at this trial as an expert witness in Arizona criminal and traffic law without challenge. The judge was not happy at all about this. Based on my testimony, the cop was thoroughly impeached as a witness. The cop's legal opinion was supposed to have been stricken and not considered by the judge. The only way it can be considered consistent with fairness and with the rules of court when they are actually being applied is to permit cross-examination of the witness. This was not permitted, which, in and of itself, proves there was no case. It's one or the other. By using this approach, the judge puts himself in a serious bind and has to choose between either exposing the true nature of the trial, that being the taking of property by means of physical violence and nothing more, or maintaining a pretense of fairness. Remember, this is a pretense of fairness. Nothing based on violence is fair. In my experience, one of these two will always be sacrificed in these situations. Which one depends on who the judge is on that particular day. If he sacrifices the perception of fairness and chooses physical violence or threats of violence, then nothing will change his mind, not even having the cop testify on my behalf, which has happened before. The principle at work in such a case is this, quote, contra negantem principia non est disputandum. It is useless to dispute with one who denies principles, end quote. Ballantyne's Law Dictionary, page 265. Such a person cannot and should not be reasoned with because they only understand physical violence. In other words, unless a judge higher up on the political pecking order tells him he's wrong, he's not going to listen to me. He will not even listen to his own witness, so obviously I can't sway him either. In my experience, more often than not, judges choose to sacrifice their pretense of fairness, even if they ultimately throw a case out. This isn't the worst thing that can happen, though, because the subsequent appeal can be quite embarrassing for the state attorney trying to defend this judge's actions. He wants to maintain a pretense of fairness as well. This is why I said by making tangible evidence the central issue, I am able to sanitize a case by removing most of the prejudicial elements against me. This is what I want if I have to appeal. On appeal, I have one critical issue. The judge accepted the cop's testimony without challenge. He ruled the witness could testify, then could not testify, and refused to permit me to cross-examine him. He then relied on that same unchallenged testimony, which consisted of nothing more than arbitrary and incomprehensible legal jargon. You don't have to go to law school to see that it's unfair to accept testimony from a witness not competent to testify. If I cannot win on this issue, then this issue alone, then anything else probably doesn't stand a chance because so-called appellate courts are also a joke. This is why my last appeal memorandum was only a page and a half long. On appeal, the lawyer for the pretended state has to somehow justify what the judge has done. Now put yourself in his shoes. What in the world would you say to justify these contradictory acts on the part of the judge? How do you justify the taking of unchallenged legal opinions? Do you see now why the word judge, cop, and trial are always in quotes? I can't think of any justification for all of this, and that is probably why, in all except one traffic case, the lawyer for the state did not even bother to file a reply brief. In the one recent case where a lawyer from Arizona did file a reply memorandum, he lied by intentionally deleting part of reality. He claimed I never asked the witness about the facts, even though at least 7 witnesses would disagree. In fact, this lawyer also disagreed when I questioned him outside a courtroom. He admitted I had asked the cops about the facts. This and other cases taught me that in legal land, the facts and truth are irrelevant. This also helped me to reinforce my belief there is no way out of a situation like this except for the bureaucrat to lie or just be non-responsive. That's when I know I caught them with their pants down. They either fall silent or start spewing forth verbal diarrhea. Another example is a tax case I helped someone out with in California. There was an administrative hearing before 4 individuals doing business as the Board of Equalization, and the subject was so-called tax assessment. I made an application for subpoenas so the alleged witnesses would appear at the hearing for cross-examination. The application was denied, not once, but 3 times, on the grounds the witnesses lacked personal knowledge of the facts. The first 2 times this decision was made by staff lawyers, so any claim the decision was legally defective and a nullity are without merit and frivolous, according to their own rhetoric, not mine. So what did I do? I didn't argue. I agreed. There can be no personal knowledge of facts that don't exist. In their enthusiasm to steal property, these politicians impeached the very witnesses they relied on. I pointed out that Section 702 of the California Evidence Code made the testimony inadmissible, and I asked for that testimony, which consisted of the so-called tax assessment, to be stricken, thrown out. In classic bureaucratic style, these 4 individuals refused, keeping in mind the opinion the witnesses lacked personal knowledge was theirs and not mine. Why would 4 allegedly neutral individuals all accept opinions they knew were arbitrary? Consider the disregard these 4 men and women had for the divine law they are allegedly sworn to preserve, protect, and defend. These bureaucrats were so eager to rob this man they ignored their very own rulings. Once in court, their lawyer wanted the videotape of that tragic comedy thrown out and stricken from the record. Why? Because it proves this lawyer had no admissible evidence to base her opinions on, and no amount of gyrating and screaming about taxes, liabilities, laws, and whatever else was relevant, because she was not a party or a witness. Think of it this way. Imagine if O.J. Simpson were put on trial with no more evidence than the mere opinions of Marcia Clark and her fellow lawyers pretending to represent a state. There is no Cato and no forensics. In fact, there is absolutely nothing but the opinions of some lawyers who profit from such proceedings. No rational adult would accept this as fair, and yet this is standard and happens every single day in traffic and tax cases, among other bureaucratic attacks. Where are all the public demonstrations? Where is the ACLU? To clarify even further, I will give you several examples of mere legal opinions that somehow pass as tangible evidence in traffic courts and other parts of legal land. I am within the state. I am within the city. I am a resident of the state. I am subject to the jurisdiction of. I violated a law. I violated a statute. I must appear in court. This or that other statute applies. Just the words state and city represent nothing tangible and are only political jargon. In lay terms, they are in and of themselves lies. In regards to traffic cases, these would be the legal opinions of a cop. They are opinions, not facts. They do not qualify as facts any more than my opinions qualify as facts. Think about this because it's important. Very important. The words state and city represent or symbolize nothing more than abstractions with no tangible existence outside of the cop's mind and the minds of his victims, you for example. And keep in mind that what a cop purports to do in place of a licensed attorney is supposed to be a nullity. In the above tax case, the witnesses claimed the person I was helping was within the state. By the Board of Equalization's own admission, the witnesses lacked personal knowledge of the facts. Are you starting to see just how similar Alice's Wonderland and Legal Land really are? If so, is it possible that what you think is real is just a public relations scheme? Are your perceptions and reality one and the same? What if your life is nothing more than a lie rammed down your throat since you were a child? If the ground were the state, and the man I was helping admitted to being physically located in California, then why would these politicians claim the witnesses lacked personal knowledge of the facts? These bureaucrats accuse people of being within the state every day to justify their violence, and yet they are not permitted to testify to the same under oath? What does this tell you about both the people who parade around as a government and the true nature of the so-called state? There is no state. Despite being physically in California, these bureaucrats could not testify the man was within the state because in their opinion they lacked personal knowledge of the facts. They not only impeached the witnesses themselves, denied cross-examination, and accepted arbitrary opinions as tangible evidence, but they sanctioned the man I was helping the maximum allowed by their so-called law. These four politicians claimed both the man's position was patently frivolous and sanctions of $5,000 were warranted. His position was the opinions against him were not supported by facts. This is the same position two staff lawyers and the four bureaucrats themselves held. Only in Legal Land can the exact same position be both frivolous and not frivolous at the very same time. Another example of the political dream world is the word law itself. This word is hypnotic. Most people give it no thought at all and accept it blindly. Some people, like cops, are willing to murder in its name. Indeed, no act is too vicious if it's the law. To help you understand a law is just an opinion backed by violence, think about the process that leads to a pretended law's creation. From a lay standpoint, of course. In other words, let's look at the facts and nothing more without any political spin or rhetoric. Some man or woman prancing around as a pretended legislator says to other men and women pretending to be legislators themselves that, in his or her opinion, everyone must have a driver's license. They count noses, and if a majority holds the same opinion, then that opinion is renamed a law. There is still nothing tangible, though, and it doesn't matter if that opinion is then written up in fancy law books, because you could easily burn those books. Would that be the end of that particular law? After being renamed the law, this mere collective opinion is then forced upon other people by armed troops more commonly known as cops. Think about this for a moment. What if the law was not written down and all the bureaucrats put their guns down? Would this change how easily it was accepted? In addition to that, what if the cop didn't have his costume or uniform on and a neat-looking badge? Let's say he was wearing a t-shirt, sneakers, and reeked of beer. Does this change your perception that he is an alleged authority? Because I know from experience some people will have a problem with the above example and throw up the murder argument, I will provide the following. Some people may think we need laws for things like murder and rape. This, however, neglects reality because I am unaware of laws prohibiting murder and other real crimes, to wit, quote, Arizona Revised Statutes, Section 13-1102, Negligent Homicide Classification. A. A person commits negligent homicide if with criminal negligence such person causes the death of another person. B. Negligent homicide is a Class 4 felony. End quote. Notice this is only a classification and prescribed level of punishment. This appears to be consistent. See also 76-5-201 Utah, 782.04 of Florida as well as others. There is no attempt by a gang of faceless, unproductive men and women, politicians, bureaucrats, to criminalize the above act because it would be redundant. I want to make one last point in regards to the law and its hypnotic power on people because I think this power is lost when it is seen for what it really is. Let's say the men and women who parade around as congressmen pass a law, there would be no more gravity. The legislature finds that without gravity, the cost of shipping would be reduced, thereby helping the economy of the state. Would you happily waltz off the top of Sears Tower? If not, then why? What if they passed a law that rocks were now apples? Would you take a big bite of a block of granite? Shouldn't we respect and comply with all laws, at least until they are declared unconstitutional by the courts or repealed by the legislature? Before you think these are absurd examples, consider the fact that a legislature in the South, I believe it was Alabama, passed a law forbidding a river from rising past a certain level. When you just look at the facts, the law starts to lose its hypnotic dreamlike power. What is important here is a group of men and women are forcing other men and women to accept, or at least act on, their mental conception. What the mental conception is irrelevant and beside the point. The important thing here is the coercion and violence used to get people to accept or at least act on mental conception. To use another example, the alphabet is invaluable to communication and needs no explanation to show why it is valuable to learn it. Now just imagine using violence to teach the alphabet to children. In that instance, the children would not actually learn anything. Instead, they would be conditioned to respond in a certain way to avoid violence. That is how some animals are trained. Choice is taken away and replaced with fear of violence. In my experience, there is a common misconception that a city or a state is a natural phenomenon like an ocean, a mountain, or another part of the earth. As previously discussed, many think it's a geographic area or landmass such as a continent or island. According to lawyers with and without black robes, nothing could be further from the truth. I say that because, in their own words, a state is not a geographic area. There is Arizona, and then there is the state of Arizona. As stated earlier, if the state was the ground and only the ground, then the lawyer playing prosecutor represents the ground. Am I the only one who thinks such a premise is crazy? Fairness requires consistency. The cop has an opinion that I am within the state, subject to his jurisdiction, and I broke the law. These are just opinions or labels and not a statement of facts. The cruelest labels I'm aware of are the words legal and lawful. The following is critical to remember. The words legal and lawful have no real meaning, only a purpose. That purpose is to justify some of the most heinous acts you can think of by men and women pretending to be a state, sort of linguistic subterfuge. Any moral or ethical conviction a man may have is thrown out the window if an act is deemed legal. A good example is slavery. The opposite is also true. Just as people who currently take or sell certain drugs are seen as criminals against whom the government must wage a war on, if the drug laws were repealed tomorrow, those very same people would be instantly converted to honest, law-abiding citizens. There are people who sell drugs every day of the week, and instead of being considered criminals, they are called doctors and pharmacists. Why no war on doctors and pharmacists? The phrase war on drugs itself is a lie, because it's not a war on drugs. It's a war against the people who sell or use them without a state license. I don't use drugs, and I do not advocate their use. However, being a non-violent and peaceful man, I choose not to force my personal beliefs on others. I have to laugh when I drive down the street and see signs such as, drug-free school zone. If that were true, the teachers wouldn't be taking Prozac, and none of the children taking Ritalin. Both are mood-altering drugs. Someone please tell me what the substantive difference is between taking mood-altering drugs such as Prozac and recreational drugs besides the political mantra, one is legal, the other is not. What's the difference between a teacher who uses cocaine as opposed to a teacher who uses Prozac? Drink a six-pack in your living room while smoking cigarettes and watching a baseball game, and you're an all-American guy and good citizen. However, smoke a joint while watching the same game, one house over from the beer-chugging smoker, and you're a felon who belongs in prison. Only in legal land is such nonsense taken seriously. If you accept the premise another person has the right to control what you ingest, such as heroin, then you must accept the premise that another person has the right to force you to eat only certain kinds of foods. If your neighbor has no right to force you not to eat pork rinds, then guess what? That's right. If your neighbor doesn't have such right, then the men and women valiantly representing him don't either. Could you imagine a war on pork rinds? 60 machine-gun-toting pork rind warriors raided an underground convenience store. The only important issue with drugs is that another person is using violence to control what you ingest. For goodness sake, it's very easy for little children to choke on bread and pizza crust. Should there be a war on bread also? It's not a matter of what you are forced to ingest or not. It's being forced that's the issue. Such rank hypocrisy is also demonstrated with the so-called lotteries. When non-bureaucrats ran the numbers, it was a vicious crime against humanity. But have a politician do the exact same act under a new label such as the lottery, and now it's a great benefit for mankind. A little political voodoo magically transforms a heinous crime into a harmless beneficial service. Yeah, what wonderful magic. And what about overturned convictions? A man is put on trial and then convicted. His conviction is deemed legal. If it is overturned on appeal, then the conviction is no longer legal. Magic! Nothing has changed except the label attached. An opinion is just a label attached to the facts. How is an opinion merely a label? Let's say I scream, "I'm going to kill you." I then pick up a chair and break it over your back. Those are the facts. When a lawyer calls that assault and battery, that is an opinion. However, regardless of the opinion or label attached, the facts will not change. Like it or not, facts will not change to fit an opinion. Label it rape if you like. Who cares? The facts are still the same. I screamed I was going to kill you and broke a chair over your back. You can call an orange a diamond, but that doesn't make it any less an orange. No amount of human deletion, distortion, and or adding to reality is ever going to change reality. So the cop formed a legal conclusion I was within the state, or a so-called city, and subject to his jurisdiction. Fine. I don't fight or argue with him. I just ask him to tell me what facts he bases his opinion on. This opinion is no different than if he accuses me of being the Easter Bunny or he thinks I'm a flower. If his accusation is not based on facts, reality, then it's his fantasy. This may be hard to accept, but human deletions, distortions, and add-ons are not real. And this fact does not change just because someone wears a badge or a robe or threatens physical violence. There's an episode of Star Trek, The Next Generation, where a Cardassian is torturing Captain Picard. He keeps asking Picard, "How many lights do you see?" There are 5 lights. Whenever Picard says 5, intense pain is induced in his body. By the end of this torture, Picard later admits to Counselor Troy that he thought he saw 4 lights. This is the only other way bureaucrats can alter your reality, by torturing you to death with all their propaganda. Do you see something that isn't there? How many lights do you see? In my experience, I haven't found one single cop who knew what a state or a city was, nor have any been able to tell me what jurisdiction is. Yes, they will kill me if necessary to get me to acknowledge and act on these ideas, but ask them to tell you what it is, and they run to their fellow bureaucrats like judges to bail them out. If a cop cannot tell me what jurisdiction is, he cannot prove his case beyond a reasonable doubt. Yeah, I know. It's not the cop's job to do that. It's the state persecutor's job. I've had lawyers snarl this at me a few times. However, in doing so, they forget their entire case is built upon the cop's testimony. It follows that if the cop is unable to do so, then the persecutor cannot, unless, of course, he draws from another witness, or the persecutor tries to become a witness himself. And this is effectively what they do. The rules of evidence and fairness be damned. The beauty of all this is that if the cop did know and could somehow prove I am within the state, the judge will not allow him to answer because he is a non-lawyer, trying to form a legal conclusion without having been authorized to do so because he's not a member of any state bar. Also, even if permitted to answer, this does not excuse their use of violence because being within a pretended state does not make coercion and good faith any less contradictory. This is only for sake of illustration anyway, because his legal opinions are based upon this and or that fiction anyway, and not upon facts, tangible, verifiable facts. So what is a city or a state? According to lawyers and other politicians, not me, a city is a corporation, to wit, quote, "City, a municipal corporation of the largest and highest class." Ballantyne's Law Dictionary, page 202. End quote. So, a city is not a tangible physical or geographical location, such as Tucson, Arizona. Therefore, the city of Tucson and Tucson are not synonyms or factually identical. Quote, 1. Incorporation and organization. Classification. Section 1. Municipal corporations shall not be created by special laws, but the legislature, by general laws, shall provide for the incorporation and organization of cities and towns for the classification of such cities and towns in proportion to population, subject to the provisions of this article, end quote. Article 13, Arizona Constitution. Notice, cities are created by general laws, not bricks, mortar, and labor. So, what is a corporation? A corporation, as defined by honorable lawyers, not me, is just another fiction or fantasy. Quote, "Today's new rule emphasizes the dominance of the corporation, a creature of the legal imagination. State Tax Commission of Utah versus Aldrich." End quote. Quote, "A corporation is defined by John Marshall as an artificial being, invisible, intangible, and existing only in contemplation of law." The New York Court of Appeals has said, "A corporation, however, is a mere conception of the legislative mind. It exists only on paper, to the command of the legislature that its mental conception shall be clothed with power." People versus Knapp, also quoting Trustees of Dartmouth College versus Woodward in the quotation of John Marshall's definition of a corporation. So, a city is a corporation, and a corporation is a mental conception. A so-called city is a mental conception. A city or state is a hallucination, or a hallucination. A city doesn't appear to be a physical location anymore, does it? Still think a cop knows what he's talking about if he's claiming I'm within a so-called city? When a cop claims I am allegedly within a so-called city, he is not only inconsistent with reality, he is inconsistent with his pretended law. See State Tax Commission of Utah versus Aldrich immediately above, again, if you are still confused. Just because a man with a gun, a badge, and an antisocial attitude sees me at some intersection doesn't mean I'm in a city, does it? No, it doesn't, because a city is a corporation that exists only on paper in the minds of the men and women cavorting around as cops and so-called legislators. Now that appears to be reasonable doubt, doesn't it? Quote, the idea of a joint, incorporeal being made up of several real persons is nothing but a fiction. It has no reality in it. It is a fiction adopted merely to get rid of the consequences of facts. An act of legislation cannot transform 20 living real persons into one joint, incorporeal being. After all the legislative juggling that can be devised, the company will still be nothing more, less, or other than the individuals composing the company. The idea of an incorporeal being capable of carrying on banking operations is ridiculous. End quote. Lysander Spooner. So what does this really mean if a cop is claiming, under penalty of perjury and upon reasonable grounds, that I am somehow within a mental conception? It means his reality and that of the entire pretended court is all in their heads and nowhere else. The cop, judge, and the persecutor are living in a political dream world they are violently foisting on me and millions of others. Whoa, excuse me, but exactly where, when, why, and how does any man, come within a mental conception? If a city exists only on paper, then how did I ever get within one physically? I never did, and I never will. I can only be in a city within someone's mind and nowhere else. Did Alice take a machine gun and force others to accept her wonderland? If she did, would she be hailed as honorable? Let's try for a moment to suspend reality and think from the standpoint of a traffic cop. What exactly are his reasonable grounds that I am within his mental conception? Remember, though, this is legal land, so a city does not have to be tangible for a cop to see me within one. Just like all of his other opinions, this one is all in his head, a dangerous fantasy or a hallucination. He has seen me at a certain geographic location, however. He might as well claim he is Santa Claus and accuse me of being the Easter Bunny because he has the same amount of tangible evidence. In the real world, hallucinations are not tangible evidence. Because in legal land, hallucinations and other mental conceptions are treated as if they are magically transformed into tangible evidence, that is enough for a traffic court judge to convict someone. After all, there are no rules of evidence or pretrial discovery in traffic court, at least in the state of Arizona, as he can be as biased as he wants, just so long as he does not shock the conscience of his fellow lawyers higher up on the political pecking order. This is also why I wrote earlier that the phrases such as State of Arizona and City of San Diego are, at best, doing business as and alter egos used by men and women who use violence as a way of doing business, whether they're conscious of it or not. Any title or office used by a coercive government, state, agent is merely a doing business as or alter ego. Strip away that title or fancy office and you're looking at men and women who have no more right to control other men and women than you and I do. Take a very close look at what is being written by these lawyers. A city is a mere conception of the legislative mind that only exists through the command of the legislature that its mental conception should be clothed with power. Factually, a legislature is nothing more than men and women. This means a city or state is a figment of their imagination, which other people are then forced to accept or at least act on. I may not believe there is a real city, but because of the violence backing this fantasy by those armed men called cops, I am forced to act as though a city or state is absolutely real. If Alice put a machine gun in your face, you'd act as though you were in Wonderland with her too. What we have here is a group of individual men and women commanding, forcing other men and women to accept a mental conception, idea, or hallucination. Compare this with what has been said about propaganda and how well it matches what lawyers themselves tell us their pretended laws really are. Quote, as generally understood, propaganda is opinion expressed for the purpose of influencing actions of individuals or groups. Propaganda thus differs fundamentally from scientific analysis. The propagandist tries to put something across, good or bad. The scientist does not try to put anything across. He devotes his life to the discovery of new facts and principles. The propagandist seldom wants careful scrutiny and criticism. His object is to bring about a specific action. The scientist, on the other hand, is always prepared for and wants the most careful scrutiny and criticism of his facts and ideas. Science flourishes on criticism. Dangerous propaganda crumbles before it. End quote. Alfred McLuhan Lee and Elizabeth Bryant Lee, The Fine Art of Propaganda, 1939. Could you imagine using the same tactics as bureaucrats to sell lemonade as a kid? Come to think of it, if you sold it the same way, you wouldn't really have to have any actual lemonade to sell, would you? You would just command the other children to accept your mental conception there was some refreshing lemonade they had to buy from you, whether they wanted to or not, because it was for the good of the whole neighborhood. If you were really enterprising, then you could allow other kids to do the same by setting up a licensing scheme franchise, like state bar associations, whereby you could sit back and just collect a cut from each licensee in exchange for your protection of their exclusive license to sell real lemonade. The kids could also be told they had to buy lemonade from licensed vendors approved by you, or they might get cheated because you always maintain strict standards of lemonade purity to protect them. This analogy has more similarities to state-run protection rackets than you may care to know. Commanding me to believe in any mental conception, whether it be a city or a corporation, is really no different than commanding me to believe in Santa Claus, the Tooth Fairy, or the Easter Bunny. In fact, this is what I see whenever I read the law quoted above and notice it does not change the flow of the quote. Today's new rule emphasizes the dominance of the Easter Bunny, a creature of the legal imagination. The Easter Bunny is defined by John Marshall as an artificial being, invisible, intangible, and existing only in contemplation of the law. The New York Court of Appeals has said the Easter Bunny, however, is a mere conception of the legislative mind that exists only on paper through the command of the legislature that its mental conception shall be clothed with power. How do you clothe an idea with power anyway? It's not the particular mental conception I am being forced to accept. It's being forced to accept a mental conception that's the issue. Change your perception for a moment. Do you want to be forced to believe in a religion? Would you personally force someone else to believe in your chosen religion? Does your neighbor have the right to force you to believe in a certain religion? To help understand this, just like in politics to a religion. It doesn't matter if it's a city, state, nation, the Easter Bunny, Santa Claus, Vishnu, Zeus, Horus, or Muhammad. I don't want to be forced or commanded to believe in anything. If likening politics to religion is too uncomfortable for you, then think of politics as a mythology because it is a mythology. If you ever wonder if a bureaucrat has the right to do something, then just ask yourself this question. Does my next-door neighbor have a right to do this to me? If he doesn't, then his pretended delegates, deputies, agents, commissioners, governors, presidents, kings, princes, czars, ministers, secretaries, and servants don't either. It's that simple. An obvious question here is why would an idea, religion, myth, or hallucination have to be imposed by force? Maybe because that's the only way rational people will not only accept the idea, but also act on the ideas if they actually believe it. Violence is the means by which the irrational get the rational to act. What if, like the mental conception called the Easter Bunny, I choose not to accept the idea that I'm within a state or a city? What are the implications? First, it would be safe to assume that no one is willing to murder me because I don't believe in the Easter Bunny. The very opposite is true when it comes to bureaucrats. Bureaucrats actually believe they have a right to kill you if you refuse to accept their mental conceptions, be it a city or the Tooth Fairy. It really doesn't matter. If you don't believe this, read Article 1, Section 2 of the Nevada Constitution directly below. This is such a gem of political doublespeak and statist nonsense that I have to include it in this book about political myths. Quote, all political power is inherent in the people. Government is instituted for the protection, security, and benefit of the people, and they have the right to alter or reform the same whenever the public good may require it. But the paramount allegiance of every citizen is due to the federal government in the exercise of all its constitutional powers, as the same have been or may be defined by the Supreme Court of the United States. And no power exists in the people of this or any other state of the federal union to dissolve their connection therewith, or perform any act tending to impair, subvert, or resist the supreme authority of the government of the United States. The Constitution of the United States confers all power on the federal government to maintain and perpetuate its existence, and whensoever any portion of the states or people thereof attempt to secede from the federal union or forcibly resist the execution of its laws, the federal government may, by warrant of the Constitution, employ armed force in compelling obedience to its authority. Close quote. This is a declaration of war, for goodness sake. Here the government is said to serve the people who are of allegedly the power, and yet the people cannot peacefully withdraw their support without armed forces compelling obedience. Which one is it? Both cannot be true. How many people do you know that are willing to kill their boss just to keep their jobs? Is your job so important you feel it's necessary to kill your boss to stay employed? I think normal people just go get other jobs. Instead of a going out of business sale, politicians start a war against unemployment. Can you imagine a political party that might use the following speeches and campaign slogans? Yes, sir, vote for me, and once in office, if you dare withdraw your support, we'll kill every last one of you if we have to. But vote for me anyway because the other guy will kill you for a lot less. Or, vote for me, Joe Bureaucrat, because Bob Bureaucrat will kill you for doing a lot less. Politicians are not only willing to kill their alleged bosses to keep their jobs, some shamelessly advertise their murderous intent in their own constitutions, like above. This type of content is not hidden. You can go into most libraries or look online. It's one thing for a slave to kill the slavemonger, but it's quite another for the public servant, bureaucrats, to kill their so-called sovereigns. Just how many are they willing to kill to stay employed anyway? 50%? 75%? 90%? And keep in mind that Pol Pot probably didn't write that section of the Nevada Constitution. Think about this. If men, women, and children do not want to participate in politics, i.e. forcing their opinions on others, any longer, some bureaucrats will murder as many of them as they have to in order to keep their jobs. Is that fair? Is that sane, killing children just to keep a job? Is participation in politics so important people should be murdered for deciding to opt out and live a peaceful life? Did you see any mention in that Constitution about a trial? Peacefully withdrawing support is treated as worse than being a terrorist, for goodness sake. At least accused terrorists get a mock trial before they're shot. Did you catch the contradiction here? What about the Fifth Amendment and due process? Isn't that by warrant of the Constitution? Armed force without the nuisance of a trial. That's why I write, it's not about protection, it's about obedience. And what about the part about protection? Doesn't that sound familiar? You're going to be protected whether you want it or not. And let's not overlook the offer you can't refuse. Employ armed forces in compelling obedience to its authority. Apparently, Luca Brasi didn't sleep with the fishes after all. Maybe the above Constitution should read, all political power is inherent in the people, as long as the people means bureaucrats. Government is instituted by bureaucrats for the protection, security, and benefit of the people, whether they want it or not. And they have the right to alter or reform the same whenever the public good may require it, just as long as no bureaucrat is put out of a job. But the paramount, real allegiance of every citizen, i.e. slave, serf, peon, is due to the men and women pretending to be a so-called federal government, in the exercise of all its constitutional powers as the same have been or may be defined by the Supreme Court of the United States. And no power exists in the people of this or any other state of the Federal Union to dissolve their connection therewith or perform any act tending to impair, subvert, or resist the supreme authority of the government of the United States. The Constitution of the United States, although just a mere written instrument no one ever bothered to sign, somehow confers full power, how, we don't know, on the federal government to maintain and perpetuate its existence, and whensoever any portion of the states or people thereof attempt to secede, i.e., peaceably withdraw support from the federal union, or forcibly resist the execution of its laws, i.e., mere opinions, delusions, and fantasies, the federal court may, by warrant of the Constitution, an unsigned written instrument, employ armed forces, i.e., shoot men, women, and children down like dogs in the street, in compelling obedience to its authority. If it's true that all political power is inherent in the people and they choose to peaceably withdraw their support, would they not at the same time be withdrawing their alleged political powers from the so-called government? If so, then under what pretense or authority would the federal government be exercising? If the people just didn't support them anymore, then by what pretended authority would they employ armed force? Getting back to the mental conception and its application in my traffic cases, let's say, for example, I am traveling safely down the street without a so-called license plate on my car. I am not speeding or causing any danger to anyone, and a cop gets behind me and puts his emergency lights on. The cop certainly accepts the mental conception or opinion that when his lights are turned on, the person in front of him is supposed to stop. However, like the idea of an Easter bunny, I don't accept this mental conception and continue minding my own business. What will the cop do? More than likely, he is going to either threaten me somehow with physical violence, or he'll just start using physical violence to stop me on his own. Either way, if I don't stop, he will probably increase the physical violence until I am stopped, including calling additional armed troops, more commonly known as backup. Some of their cars may even ram my car. Once stopped, I will more than likely be approached by several cops, each pointing a loaded firearm directly at my head. Once their firearms are drawn, they are fully prepared to murder, kill me where I sit. Just ask a cop, and he'll confirm this. At this point, it no longer matters that I didn't have a seatbelt on. No, I have done far, far worse. I failed to accept a bureaucrat's mental conceptions by stopping. This is usually taken as a personal affront to their rights to dominate me. Now they're really pissed off. Failing to accept a mental conception certainly warrants the use of violence, doesn't it? After all, isn't violence an acceptable way to get people to believe the same as you? Isn't it legal? It is in legal land. Let's put this in another context. Obviously, no one can really force me to believe in the Easter Bunny, but I can be forced to act on this belief by coloring and hiding eggs at gunpoint, can't I? There is a world of difference between believing something and acting as if you do. Compare this to a traffic trial, because that's how bureaucrats operate. You don't have to believe there is a state, but you will perform as though there is one by getting a license, filing a tax return, putting your children in state-run propaganda mills called public schools, etc. For example, a cop accuses me or anyone else of being within a city and failing to provide ID. This cop might as well accuse me of being in Bunnyland and failing to color and hide eggs. In both cases, mental conceptions are being used. How should such an accusation, opinion, be responded to, if at all? If there were no physical violence to back it up, I would just walk away laughing from this delusional antisocial individual. On the other hand, if I responded at all, I might say, "I'm sorry, but I don't believe in the Easter Bunny." The cop would probably respond that that doesn't matter. Only his belief matters because of his gun and his willingness to use it to get me to act as if his fantasy were real. Regardless of my beliefs, though, he not only believes in the Easter Bunny, he also believes he represents the Easter Bunny, and, because he thinks I'm somehow in Bunnyland with him, I must color eggs and hide them, or get shot. My failure to merely play along with his delusion will result in the taking of my time and money, a fine, or could result in my death. And I'm sure statists would not see anything wrong with such a cold-blooded murder and say he should have just colored those eggs. In this context, it's very easy to see the cop for what he is. He's a man with a gun expressing opinions with no factual support, and, without facts to support those opinions, his beliefs are pure fantasy. In that case, it really doesn't matter if he accuses me of being within a city or Bunnyland, because both are mere mental conceptions, with no tangible existence outside of the head of the legislator, to which all of this nonsense can be traced back. And why does the cop rely on this legislative gibberish? Because he gets a paycheck, a gun, a neat-looking badge, and gets to dominate other people with impunity. On the other hand, there is nothing stopping me from actually believing I'm in Bunnyland and just coloring eggs or paying whatever fine the judge demands I pay. However, getting back to the traffic stop, let's imagine they ask me why I didn't stop. What could I say to such a question? Could I say I didn't realize I was supposed to stop? They could then tell me they put their lights on and I was supposed to stop. This is another great example of a non sequitur. Then I might ask them why I should stop because they put their lights on. Whatever their response is, I could tell them that, like the mental conception idea of the Easter Bunny, I don't believe in such a thing. The bottom line here is this. Bureaucrats use physical violence to force you to act on their mental conceptions, mere ideas in their heads, whether you believe them or not. If you don't believe this, the next time those lights come on behind your car, if you don't want half a dozen or more loaded firearms pointed at you, you will stop your car. And most people know this is true. Your beliefs are just not important. Only the beliefs of the man with a gun are important. I like how Jim Robertson put it. Quote, co-equal decision-making versus following orders and submission. Bureaucrats follow orders. They believe in giving orders to other bureaucrats. If you are not a fellow bureaucrat, you are even lower in status in their eyes. You need to be told what to do, how to earn your money, how to spend your money, what is safe for you, and so on. Bureaucrats believe that most people are like children who need to be told what to do and punished for not following orders. You respect the viewpoint of others and their freedom to hold other viewpoints. Bureaucrats believe only their viewpoint is relevant and that their viewpoint is an order that you must follow. You regard no person as your slave, nor any person as your master. Bureaucrats believe that they have authority to give you orders and that you must be punished if you disagree. They believe your life, money, and body are theirs to regulate and use as they decide. Bureaucrats hate those who respect the viewpoints and decisions of others in a meaningful way. End quote. How Bureaucrats Think and How to Leap Across Them by Jim Robertson. This leads us to a fundamental question. If physical violence is used to force me to accept one opinion, such as my being within a city, then why not use physical violence to force me to accept all the other opinions and mental conceptions, such as the opinion I am guilty of not wearing a seatbelt, in order to avoid a so-called trial? What is the substantive difference between the two, if any? In other words, why not just drop the pretense? What is the point of having a trial when violence is the basis of how they interact with you? It seems inconsistent at best that they should use physical violence to make me accept their opinion that I am required to get a driver's license, but they still put me through a trial to convince me that I am somehow guilty of driving without a driver's license. Why not be consistent and use physical violence openly to have me accept all of their opinions? A so-called trial is unnecessary because bureaucrats do business by coercive means and do not require my consent for anything they intend on doing, not according to me, but according to them. Before you think this is too critical of bureaucrats and that physical violence is a necessary evil to provide valuable services, consider this. When was the last time you were forced to pay the operating expenses for Burger King? Probably never. You have always been completely free to patronize any other fast food business and to even forego fast food entirely. Do you consider physical violence to be a legitimate method of doing business? This is not to say, or to even suggest, that violence under any flag, political banner, or crime family is a legitimate way of doing business. It is not. But seriously, what is the factual difference between a state and a protection racket? Don't say one is legal, the other is not, because that is not a factual difference. That's only a different label, legal versus illegal. The only real difference is that physical violence is not used as openly because politicians are trying to maintain a pretense of fairness. Indeed, they must maintain a pretense of fairness because it's the only thing separating them from their non-legal counterparts. The second, more subtle difference is that coercive states utilize more effective public relations on their victims starting from childhood with compulsory tax, or theft, funded schools. What would your children think of the mob if they were forced into schools run by the mob from the age of 5 to 18? What did Hitler say about children? This is why it really doesn't matter whether I am within the state or not. The only real issue is the violence used to force me to believe their mental conceptions or act as if I do. Bureaucrats use physical violence to get you to comply. More to the point, they use physical violence to actually get you to help them fleece you because without your help, doing their jobs would become virtually impossible. To demonstrate this is true, consider for a moment what a traffic stop would be like if all I did was peacefully refuse to help the cop in any way. I do not stop the car on my own when the lights come on. I refuse to stand up and be handcuffed. I refuse to walk to their car, help them get me in, etc. What would cops do in such case? How much more difficult would their jobs be if I simply refused to help them? How much more violence would they use? Consider the added manpower that would be needed. I don't resist them, I just don't help them. After all, they believe the mental conception they have the right to control my life and property without my consent, right? Okay, I won't disagree or resist you, but go ahead, do your job now. If you don't need my consent, then apparently you don't need my voluntary assistance either. Imagine what would happen if 100,000 people in any major city took the so-called license plate off their cars and refused to stop when cops put their lights on. This alone could effectively stop traffic tickets from being written. Bureaucrats don't bother asking for permission, but they certainly need the help of their victims. Without it, their violent adversary system, as lawyers call it, would collapse under its own dead weight, and no amount of new laws could change that, either if people just don't accept their mental conceptions any longer. What would the politicians do? Pass a law making apathy a crime? And if they did, who would care? Quote, evil tyrants require, indeed they depend upon, willing and unwilling accomplices, good people who would never think of harming a soul themselves. Lenin called such people useful idiots. End quote. What I have learned from the 20th century. Mike Vanderbilt. Quote, from all these indignities, such as the very beasts of the field would not endure, you can deliver yourself if you try, not by taking action, but merely by willing to be free. Resolve to serve no more, and you are at once freed. I do not ask that you place your hands upon the tyrant to topple him over, but merely that you support him no longer. Then you will behold him, like a great colossus whose pedestal has been pulled away, fall of his own weight and break into pieces. End quote. Etienne de la Boétie, Discourse on Voluntary Servitude. Also, aside from not helping a bureaucrat, what would happen if bureaucrats could not initiate the use of physical violence? How could a bureaucrat such as a traffic cop do his job if he could not initiate the use of physical violence? They would have a real problem on their hands at that point in time because their very jobs depend on violence. Jurisdiction is control. Stripped of all political jargon and legal gibberish, jurisdiction is control over men, women, and children. It's what groups of men and women pretending to be governments do. They govern, and govern is control. Quote, govern, to direct and control, to regulate, to restrain, to manage. End quote. Ballantyne's Law Dictionary, page 530. They violently regulate, control, and dominate other men, women, and children. This can be observed even by us uneducated laymen. Think about this for a moment. Have you ever seen a government? Can you hit a government with a rock? What exactly is government? The lay answer is that is just the facts. A government is one man controlling another without the latter's freely given consent. Everything else is just opinions to justify violence taking control of someone else's life vis-a-vis slavery under the guise of protection. Remember the Yick Wo case cited earlier. It would be foolish to deny they control me, at least to a degree, unless of course swift and blinding violence against myself is an objective. If I refuse to cooperate, even peacefully, they will use whatever physical violence is necessary to meet their end goal. If I don't stop my car when the cop flips his lights on, he will eventually use his car to stop me. Having done so, he'll run up to my car, screaming at me to get out, with his firearm pointed directly at my head, ready to murder not a peaceful human being, but what he now believes is a criminal or a perp. See the sick irony in such a situation? The cop is the violent one, and the guy minding his own business, not harming a soul, is somehow the criminal. Yeah, I can hear it now. He should have stopped his car. That's right, blame the victim. Reminds me of the lawyer argument that a rape victim should not have dressed a certain way. I guess he had it coming to him. However, getting back to the cop as a witness, I'll also ask the cop if he had jurisdiction over me during the traffic stop, yes or no. I also ask what jurisdiction is factually. The blank stare I get as a response is the cue for the cop's lawyers to jump to the rescue. To help him out, I might also ask him if he had control over me during the stop. Despite this being a legal conclusion, the lawyers playing prosecutor and judge will allow it, and he'll probably answer yes, because if he is without jurisdiction, the case should be over. You'd be surprised, no, shocked, to see just how far some of these altruistic, honorable lawyers will go to keep a case from being thrown out. If, however, he is not permitted to answer, I again suggest it may be consistent with the rules of evidence to strike his testimony, including the ticket. If he testifies that he did have jurisdiction or control, I ask, did you ask for my permission? He will proudly deny that he most certainly did not. This question is mostly for psychological reasons. I want him to assist me in exposing his true violent nature, so I pump him up with pride. In fact, I want him to snarl back at me with contempt. I'm a cop, you little punk. I don't need your permission to do anything. I want his true nature exposed because it contradicts any pretense of fairness and good faith. If what is being done to me is based upon violence, then it's not being done in good faith and is certainly not fair. Anyone who equates physical violence with good faith has serious psychological problems and is not a stable person anyone should try and reason with, even if they are residents in legal land. No one can get a fair trial from such a person. Once it is out in the open that it was not with my permission, nor was this required, I ask him, okay, other than physical violence, please tell me, factually, the nature and basis of this jurisdiction and exactly where, when, why, and how you acquired it. This is not going to be answered, and with good reason. One in particular is that he was just beating his chest because he doesn't need my permission to do anything. If he even offers a responsive answer, he won't. Then he is looking at being impeached as a witness for his inconsistent testimony. At this point, the cross-examination is over, and it hasn't lasted more than a couple of minutes. It is always interesting to ask them at what particular point in time this jurisdiction was acquired, because this will really make the cop and two lawyers protecting him start to think. Was it before he saw me, 100 yards away, etc.? These questions are very difficult to get out of, so the judge will probably not permit his sidekick, the cop, to answer. That's fine because, quote, a denial of cross-examination without waiver would be constitutional error of the first magnitude, and no amount of showing of want of prejudice would cure it, end quote. Brookhart versus Janus. I once had a cop in a pretrial deposition tell me his badge was his authority over me. I said, really, is that piece of metal magic? Can I put your badge on and have jurisdiction over you? What is ironic is that he accused me of mocking him. I wonder if he also believes a crown would make him a king, or a scalpel makes him a brain surgeon. I may help the cop out by asking, is your jurisdiction over me based upon your coercion or based upon my freely given consent? If he says coercion, I can then ask him, do you equate coercion with good faith and fairness? This is a great question I have never had answered because they realize answering would open up too big a can of worms for them. For example, I worked with someone in Phoenix with regards to a Department of Revenue hearing. The woman representing the director testified to being qualified to draw legal conclusions and having jurisdiction over a friend I was helping. The hearing officer, a lawyer, agreed. My friend asked the woman if this alleged jurisdiction was acquired by his consent, and she answered no. He then asked her if she equated coercion with good faith, and the hearing officer, who also represented the director, would not allow her to answer because it called for a legal conclusion. Huh? I can always count on a bureaucrat to contradict themselves. This is because the outcome is always determined in advance, so their actions must conform to that predetermined outcome. Remember the magic bullet theory of the so-called Warren Commission? Another good question is, since this jurisdiction is not based on my consent, does it extend to the Cayman Islands? Think about this for a minute. If his control over me is not based upon my consent, then why can't he follow me to the Cayman Islands and control me over there too? Another good point, that you may want to consider is this. If the cop's so-called jurisdiction is really just coercion and physical violence, then it has nothing to do with any so-called constitution, a mere written instrument no one ever bothered to sign anyway. If I don't accept his opinion he has jurisdiction over me, then this doesn't matter, does it? He'll just use whatever physical violence is necessary to reach his objective. He doesn't need me to agree with him or even believe him. This has nothing to do with consent and good faith, the way rational people interact with each other. Given that fact, why is a so-called trial necessary? My input is irrelevant and not required, and he has probably told me this already. What has changed after the traffic stop? This applies equally to the judge's opinions. He controls my life without my freely given consent. In other words, his so-called jurisdiction is not based on coercion, it is coercion. I may not believe his opinion that he has any jurisdiction over me, but because the cops at his disposal blindly accept that he does, I have to act as if he does or else get shot. Because he uses violence and threats of violence, e.g. a so-called warrant for my arrest to ensure my presence in his building, then why doesn't he use the same level of open violence to ensure I just pay the fine he wants to impose and just skip the whole damn trial? What is fair and just about violence? It's bad public relations. As previously stated, bureaucrats must maintain a false perception of fairness and good faith, because if they don't, they will be seen for who and what they really are. They don't want their true nature to be seen because people would withdraw their support, and no amount of threats from the Nevada Constitution or otherwise would keep those politicians in power. This is why there are even more lawyers doing business as appellate courts who review a judge's actions to ensure that a pretense of fairness is maintained by the lower court judge. That is to say, the trial judge used good PR. If not, the case could be sent back to that judge or remanded. Not to administer justice, however, but to make the theft of my time and property look good. This is why I put bureaucrats on the spot. If none of this has to do with my consent, then why is a so-called trial even necessary? What is a trial supposed to accomplish when they can always force or command me to accept their opinions, mental conceptions, anyway? Look at the inconsistency here. The following opinions, lies, are not subject to my challenge or consent. I must have a license plate on my car. I must stop my car for a cop. I must comply with the cop's orders. I must appear within their building. I am within their state. I am within their city. I am subject to their jurisdiction. Then, at trial, only one opinion appears under their pretense to be subject to challenge. I am guilty of not having a license plate on my car. But if I cannot challenge the opinion I need the plate on my car, then you can't see this cruel game is rigged from the start. Can you see the difference between this and a case of rape? In a rape case, they are proving a certain act was committed as opposed to proving whether I was obedient to the written will of individuals I have never met. What makes this particular opinion any different from the other opinions I was forced to accept? One thing, the pretense of a fair trial necessary to maintain good public relations. My challenge is superficial at best and for appearances only. That is why the cop can throw out opinion after opinion ad nauseum, and when I ask him to provide the facts those opinions are based on, both of his lawyers, the prosecutor and the judge, will not permit him to testify. If I can be forced to accept one mental conception, then I can be forced to accept any mental conception whatsoever. The point here is the violence. If they can quite literally force me to accept and act upon the mere mental conception that I am within a state, then they can force me to accept and act on the mental conception there is a tooth fairy and have me place my teeth under my pillow as a result. Your geographic location determines which fantasy or laws you're forced to accept. I know some lawyers might hear that and say, that's ridiculous to compare a state or a city to the tooth fairy. You're mixing apples and oranges, Mark. My first response is, what if the opposite were true? Is it possible that what's ridiculous is a labeling a man a citizen as if that label in and of itself now means this hapless victim no longer has control over his own life and property? That he must also pay for this privilege of being violently dominated? That if he doesn't pay, then he'll get locked in a cage? Thinking you may forcibly control another person for no other reason than labeling yourself a government and your victim a citizen is what is ridiculous. Plainly described, this is unrighteous dominion. The enslavement of men, women, and children of African descent was itself a form of government. My second response is I have not described a city as a mental conception. No, as shown previously, that was a gang of honorable lawyers when I cited a Supreme Court opinion called State Tax Commission of Utah versus Aldrich. Who would deny the tooth fairy is a creature of the imagination? The tooth fairy and a city are both mental conceptions, whether lawyers agree or not. The only substantive difference between a city and the tooth fairy is the lack of violence being used to force me to accept and act upon the existence of a tooth fairy.
Lawyers may look at the Aldrich quote and just sneer, "Oh, that is just dictum anyway." And who am I to argue with that? Everything politicians have to say is dictum and opinion. The only difference between dictum is the violence used to ram it down my throat. Lawyers wanting to be judges have dictum envy. Even the cop spews forth dictum as well as the attorney with the robe. There is no difference except for the violence behind each one. That is why it is so important not to disagree with honorable lawyers or other well-armed bureaucrats. It makes no sense to argue with people who use violence to do business. As the maxim goes, contra negantum principia non est disputandum. In other words, it is useless to argue with one who denies principles. I don't argue. Instead, I let them sacrifice either their use of physical violence or their pretense of good faith and fairness. A good example was a court case I was involved with in Arizona. I arrived at the building for the so-called arraignment very early and took a seat beside some friends. I always get there early so I can note the judge's demeanor. Despite being kind and patient with everyone before me, he lost it when it was my turn. I handed him a copy of a proposed plea of guilty. All I had to do was sign it and have the release bond, ransom, assigned to cover the fine. This judge went nuts because I said I was intending to plead guilty and I just wanted to know the nature and causes of the charges and proceedings. This is the only way a plea of guilty may be accepted under Rule 17 of the Arizona Rules of Criminal Procedure. Quote, a plea of guilty or no contest may be accepted only if voluntarily and intelligently made. He refused to tell me anything and screamed for security to come in. I asked him what rules, if any, apply to these proceedings. This only made him angrier and is probably the reason why the security guard appeared so confused about why he was called and for who. I then asked the judge, do the Arizona Rules of Criminal Procedure apply? He lost all patience and entered a plea for me and told me to wait for a pretrial date. I then asked the security guard next to me, what can be done if the judge is breaking the law? He answered, oh, he's the judge, he can do whatever he wants. If you doubt this, then just go to any court and ask a cop or security guard the same question. Then I said, really? What happens if he takes out a gun and starts shooting people? He replied, well, he can't do that. I responded, great. Now we've drawn a line in the sand and we know he can't do whatever he wants. Let's see if he crossed the line this time. He was not amused at all. The last thing I asked the judge was, is there evidence of a complaining party here? This was all he could take. His face went crimson and he called the police to have me thrown out of his court. What is ironic is that this judge said I was a difficult man to deal with. Imagine that. He resorts to violence because I asked a question and here I'm the difficult one. Irony, it seems, is not lost on bureaucrats. It's also ironic because judges are supposed to be of good moral character and keep their jobs through good behavior. Do you equate good moral character with getting violent because someone asks a question? Another example involved a judge that was not also a lawyer. Most are. I came in and sat down at the defendant's table with my books. The judge suggested I come up to the bench. I said I would prefer to sit at the table where I could take notes. He flipped out and started screaming at me to come up to the bench or he would throw me in jail. I told him again, I prefer to sit at the defendant's table. It was at this point in time he noticed my friend Dinah was videotaping him. He screamed at her to stop, but she just kept on taping. To my great disappointment, we later found out she was not actually recording. The judge threw several books at me and then ran off the bench in disgust. It was hilarious. I filed a complaint with the typically useless Judicial Conduct Commission, and this judge was retired. I wrote useless because most complaints to that commission are not taken seriously. It's about as vain and pointless as filing a complaint against a lawyer with the bar. There is a good reason why a record is rarely kept in traffic courts. What happens in cases I am involved with never leaves any doubt in the minds of everyone present what is going on. That is a really bad dog and pony show. Judges always sacrifice any semblance of good faith and fairness. Each one usually resorts to violence in the first instance. Quote, violence is the last refuge of the incompetent. End quote. Isaac Asimov, Foundation Trilogy, The Mayor's Book, 1, Part 3. Violence is what happens when a bureaucrat feels they're losing their control and dominance over you. They tend to find this extremely frustrating. I've noticed that bureaucrats don't treat people as humans to be reasoned with, and certainly not as equals. Cops treat people like animals during traffic stops. Their victims have no rights and must blindly follow their orders. It's important to keep in mind that bureaucrats, especially cops, are trained to dominate and be in control of situations, or at least to believe they are supposed to be. Just ask any cop. If they feel they're losing control in a traffic stop, they'll call backup and threaten to hurt you in order to maintain control. During a traffic stop in Arizona, I asked the cop, except for physical violence, what is the nature of your jurisdiction over me? His response? He looked real puzzled, stuttered a bit, and then ordered me to stay where I was and called backup. This same individual swore I was within a city, yet he didn't know what a city is. I like what Jim Robertson said about individuals like this. Quote,
Not being in control of those we have authority to give orders to strikes at the very core of their jobs and the reason for living. They resent it. They believe their purpose in life is to smash an iron fist in the face of anyone who they perceive as infringing on their right to control you. End quote. How Bureaucrats Think and How to Leap Across Them by Jim Robertson. On a traffic stop, the cop believes he is in control, so I have to do whatever he demands, or else. If he wants to see my license and registration, then I must obey his order without question or get shot. After all, he owns me, and what I thought was my life is now his to control. Just ask any cop who's in control during any traffic stop, and they'll tell you. It's certainly not the one considered a so-called perp, that's for sure. How do you think a cop would respond if, instead of blindly obeying his orders, I calmly asked, "Excuse me, but I need to establish what my relationship with you is, if any, before we go any further"? No cop or judge I have encountered has ever answered this question beyond, "I'm a cop," or "I'm a judge." Another question is, "Excuse me, but do I have to obey you, and if so, why?" More than likely he will respond by threatening violence right away or forthwith. He will inform me that he will arrest and cage me, take me to jail. Our relationship is based on violence. I am not in control nor an equal. The cop is in control, and he took that control without my freely given consent. Seeing how he doesn't need and never asked for my consent, what are the limitations on the cop's actions and why? The cop can do whatever he wants with impunity. The only fly in his ointment is his pretense of good faith. His public relations scheme must be maintained. So what you have here is a relationship based on violence that is commonly accepted as legitimate. If it's legitimate for a cop to control me without my consent, then can a cop ever go too far? Apparently I have no rights at all if he may control me against my will. The question about the relationship is great to ask cops while cross-examining them because it'll seem strange to them and will probably confuse them a great deal. It will not be answered. It cannot be answered without exposing how they go about their business. Their charade of fairness cannot be maintained with their violent nature. This question exposes the sham whether the question is answered or not. That is the beauty of not arguing with them. I don't even need the question answered. Some may argue that cops don't need to know such things. I agree. Cops don't need to know what they are talking about, unless of course they are being relied on as witnesses. I find it incredible that cops use violence to stop your car, violence to search your vehicle, violence to take your property, and violence to put you in a cage. But if they fail to read you your rights before putting you in that cage, then they've done something wrong. Your Honor, I was violently ripped from my car, forced to the ground, hogtied, thrown into a patrol car, taken out, and beaten within an inch of my life, and then put into a cell. Officer, when you arrested this punk for not having a seatbelt on, did you read him his rights? Yes, Your Honor, I did. Looks good to me. Maybe it's just me, but it appears to be rank hypocrisy to read someone their rights while callously disregarding every one of them, using violence to stop their car, violence to search their car, violence to take their property, and put them in a cage. Actually, it's cruel. It's tantamount to putting a knife in someone's back while kissing them. To make matters worse, these same violent individuals then promise you a fair trial. This is an example where the words being used are not congruent with the actions taken. If he's taking control over my life and property without my consent, then it's clear this individual does not believe I have any rights, except whatever rights he in his mercy wants to extend me. This is usually expressed by the time-worn, status phrase, consistently rejected by rational people. You have all the rights the Constitution gives you. Isn't that also true of any slave? Slaves have as many rights as the master in his benevolence wishes to extend the slave. And exactly how does an unsigned written instrument, Constitution, give anyone rights anyway? Is my right to life really dependent on a 200-year-old written instrument no one bothered to sign? That would mean we would all instantly die if the Constitution were set on fire. Interesting concept. Again, pieces of paper do not create anything or convey property rights. People do. The paper and ink, commonly called a contract, is merely evidence that two or more people conveyed property rights to each other and under what terms. To further prove that bureaucrats think, or at least act as though they own everything and everyone, let's look at the definition of owner. Quote, owner, one who has complete dominion over particular property. 42nd American Jurisprudence, 1st edition, Property, Section 37, end quote, from Ballantyne's Law Dictionary, page 906. While you may argue a cop does not have complete dominion over you and your property during a traffic stop, one thing is clear, you certainly don't. If you don't have complete dominion, you are not the owner. How does a cop get his dominion over my property? He doesn't ask for permission, after all, he's a cop. He doesn't need my permission to do anything. It's by violence, either actual or threatened, express or implied. He does not ask for consent, nor will he wait for it. If you read legal opinions on searches conducted by cops, lawyers, and other bureaucrats, claim the officer was fully within his rights to search the vehicle. How bizarre. The legal definition of owner is one who has complete dominion. If a cop has a right to search my car, then he has dominion, and I'm no longer the owner. Maybe I'll get lucky and he'll give me my car back, or maybe it'll be forfeited in the interests of justice. This is an example of status nonsense where you own the property but you don't own the property. If the cop has dominion, then he owns it, so let him make the car payments from now on and not me. Here, take it, it's yours. Just stop screaming and put the damn gun down. Exactly how did this cop acquire his dominion or his right to search my vehicle? Let's see. Was it violence or an obscure written instrument neither one of us has signed? Another example is a so-called grand jury subpoena, let's say for my books and records. If I own the books and records, then I have complete dominion over that particular property. This means for someone else to use my property, I have to give my freely given consent because I have complete dominion. Remember, if it's not recognized that I am the owner, then a so-called subpoena would not be in my name requiring me to bring in the property. Instead, some bureaucrat would just come by and take what he felt was his. Maybe those bureaucrats just want my assistance in bringing their books and records to the court without having to pay me. To be consistent with the definition of owner, I should have no obligation to comply with the subpoena. This is not the case in legal land. If I don't comply, then armed troops will just take me and the books and records. Now if they have the right to use violence and just take what they feel they are entitled to, then why the facade of a so-called subpoena? In other words, I own the property and don't own the property at the same time. Maybe the grand jury owns the books and records. I guess they could just sell them, couldn't they? Why give them back? Some may argue the grand jury needed my private records for trial out of necessity, as if their need somehow terminated my property rights, that is, my complete dominion. I hope a grand jury doesn't need 5 pints of my blood. There are many people in need of a new kidney. Do they just cut a potential donor open and take what they feel they need? After all, necessitas non habet legem. Necessity has no law, from Ballantyne's Law Dictionary, page 837. If charged with mutilation, can that person laugh as a defense? Necessitas vincit legem. Legum vincula iridit. Necessity supersedes law. It laughs at the fetters of law. Ballantyne's Law Dictionary, page 837. What if my friendly neighbor needs a ride to work? Can he just then steal my car out of necessity? We have a 2003 Lexus here, and we have 3 ways to get you into this car. You can buy, lease, or just take it if you think it's necessary. Lawyers would write, by decisional law, the rule of necessity may override the rule of property rights. Maybe the definition of owner should be amended. Owner, one who has complete dominion over a particular property, unless a bureaucrat thinks he needs it. However, if property rights are not acquired by need or necessity privately, then it follows there is no authority to then delegate to such an alleged public body. A grand jury is just 18 or more individuals who gain no more right to my property only by appending a silly label to themselves. You see, in legal land, it's not just 18 men and women with the same rights as you and I. No, it's a grand jury with a collective right to steal. Just delete, distort, and add to reality to justify the violent taking of property. There's no merit to any claim that such an alleged right, necessity, was surrendered to the individuals strutting around as so-called government either. If property rights are magically lost through necessity, then there are no property rights to then hire a government to protect and maintain. Also, if rights are surrendered to the government, then what is left for protection? What an inane premise. In order to have your rights protected, you must surrender them first. In order for you to enjoy those pork rinds, you have to give them to me. Imagine private individuals doing business the same way bureaucrats do. You want your business protected by a security company, but in order to protect your business, you first have to give the entire business to the security company. Or maybe this is not so insane after all. It just sounds that way. If you have no property rights, then you have no rights to be violated. And if you don't own property, then you can't legally have anything stolen from you, can you? You see? Again, this is legal land, where logic is totally divorced from reality. It's kind of like the relationship with the cop. If it's all ultimately based on violence anyway, then how can the cop do anything wrong in a bureaucrat's mind, or in the minds of those who accept their premise? The notion that the king can do no wrong is the basis for his so-called sovereign immunity. So, having said that, try to imagine the same exact traffic stop without the emergency lights, the badges, and the costumes. Instead, just the guns, the men, and the cars. What would be the difference between that and highway robbery? Only one. Not all cops accept a credit card at the stop. If you accept the premise I must perform any activities for this man, such as stopping my car and showing him traveling papers despite having a productive life lead, then what are the limitations on what else he may demand of me? If I must stop my car, then why not wash his patrol car and paint his house also? Since none of this has to do with my freely given consent, then why not order me to mow his lawn while we're at it? Why not just arrest me and have me scrub toilets at his police department? Isn't it a well-accepted mental conception that I can be held for 24 hours without being charged? The issue is not the actual activity forced to perform, it's being forced to perform. Remember what the lawyers doing business as the Supreme Court wrote. Quote, "For the very idea that man may be compelled to hold his life, or the means of living, or any material right essential to the enjoyment of life, at the mere will of another, seems to be intolerable in any country where freedom prevails as being the essence of slavery itself." End quote. Yickwo versus Hopkins, 118th U.S., page 356 and 370. Doesn't this describe every situation with a bureaucrat, especially on so-called traffic stops? Maybe the lawyers who wrote this silently exempted themselves? Maybe slavery is slavery only if done without lawful authority. The point is, because the relationship is based on violence, there isn't a limitation on what he can do to me except maintaining an illusion of legitimacy. If you accept the premise a cop has a right to control you without your freely given consent, then you are in no position to complain if he orders you to shine his shoes. If cops started going too far beyond the accepted norm on a regular basis, their illusion of legitimacy would suffer and then disappear as more and more people withdraw their pretended or actual support. A case in point is what happened to a Haitian immigrant, Abner Louima, in Brooklyn, New York, in 1997. A cop stuck a wooden stick in this man's rectum, causing severe internal injuries for no other reason than being suspected of a crime. Where were the state lawyers crying sovereign immunity over that one? The king can do no wrong, right? After all, this king was working on the job at the time, and didn't he have every right to hold Abner against his will? Maybe that cop should have hired the U.S. attorneys who defended Lon Horiuchi, the FBI sniper who killed Vicki Weaver in 1992 by shooting her in the head while she stood in the doorway of her cabin holding her nursing baby in her arms. Horiuchi was on a government payroll at the time, and he got away with murder, lay sense. So why complain about having a wooden stick rammed in your butt? Bureaucrats go through a lot of trouble trying to convince people what they do is legitimate. A good example is compulsory attendance in a bureaucrat's propaganda mill, commonly referred to as public schools. From the time we are 5, we have this nonsense forced on us. We learn to be a good citizen starting at age 5. How many 5-year-olds know what allegiance is? Is it any wonder that so-called schools bought and paid for through violence end up having such violent episodes such as the one that happened at Columbine High School? This BS public relations scheme is why they give you a trial, whether you want one or not. It's political sleight of hand that distracts you this way and that while they perform their magic, concealing the true basis of their so-called authority. Like a magician, bureaucrats give you a trial to distract you from the truth, while they conceal the violence underlying it all, the truth and sole basis of their pretended authority. Then they can say, you had your day in court, your equal protection, and your due process. Cops don't know this, of course. Most cops I've met don't know more than what they've been told. But the higher up on the political pecking order you go, the more state agents seem to know. From my experience, many lawyers know the system is a sham, especially the honorable ones wearing black robes. The majority won't tell you this because it means losing their jobs and all that goes with it: money, power, dominance, prestige, circle of friends, irresponsibility, etc. The beauty, the Achilles heel of this entire scam is that because these phony trials are so idiotic and contradictory, they can very easily be exposed for what they are. A judge always sacrifices one of the two ways by which he operates, either the physical violence behind all their actions or their pretense of fairness and good faith. It is one or the other. While my questions don't always result in a pretended case getting thrown out, it's the most effective method I've seen for exposing these phony proceedings for what they are: public relations propaganda concealing violence. Once it is openly revealed the underlying jurisdiction is violence, then the entire trial is seen as a mere pretense and sadistic sham. And this may be the reason why lawyers and judges refuse to permit a cop to answer most questions. That's fine, whatever, be non-responsive. One of their methods of operation is being sacrificed, the pretense of fairness. That's because although the entire so-called case is based upon this cop's legal opinions, the judge will not permit me to question him about the supporting facts. Not being permitted to question the sole witness against me sounds like a really fair trial. As stated previously, the refusal to permit a cross-examination is about the worst error the black-robed lawyers can commit, even in legal land. Isn't it interesting that if a judge refuses to permit cross-examination and cages me in any way, it's just considered an error, but if I did the same thing, it would be a crime? If the cop is permitted to testify, and he admits our so-called relationship is based upon violence and not on my consent, then the question next is, do you equate violence with good faith? Another variation of this question is, if our relationship is based on your violence, then what does your alleged jurisdiction have to do with the Constitution? And then there is, are you trying to maintain a perception of fairness on a foundation of violence? I have never gotten an answer to these questions in any court, and for good reason. How does one maintain a pretense of fairness while admitting the relationship is based on violence? How do you equate violence with good faith? It can't be done. And that's why any bureaucrat that hears this question quickly realizes he has no case. To get back to the cross-examination of the cop, if the judge will not allow him to testify, I will ask the judge. If he can't testify, aren't you supposed to strike his testimony? This puts the judge into an extremely uncomfortable position. He has refused to allow the only witness against me to testify, and he knows, or should know, that the testimony should now be stricken. He also knows by striking the cop's testimony that he has to dismiss the case. This means he cannot collect any blood money from me. In spite of that, it's incredible to witness a judge striking a cop's entire testimony, including the ticket, and still refuse to dismiss the case. There are two main reasons for this. First, the trial is subterfuge, political voodoo. And second, according to the laws that they've created for themselves, judges have no personal accountability. I know the outcome of these so-called trials is determined in advance because judges consistently accept testimony from cops they themselves determined are not competent to testify. This is done regardless of the geographic location of the court. Think of the odds that there is no connection here. This is not only grossly unfair, this is also considered an incurable error according to their very own Supreme Courts, even if one excuses the violence underlying the entire proceeding. Judges are not held accountable for their crimes, lay sense of the word that is, as long as those crimes are committed while on the bench, doing their job. That is one of the reasons why they just don't care if they make glaring errors, such as obstruction of justice. That is also why they will often snap at you. You can appeal. Judges have their rulings reversed all the time, and nothing is done to them, i.e., they are not held accountable or punished in any way, even if a man is sent to jail maliciously. Judges do not lose a dime of their salary for being reversed. They lose nothing when they are clearly wrong, and yes, Virginia, it is possible for bureaucrats and honorable lawyers to be wrong, dead wrong. Quote, lastly, the meaning that the government attaches to Congress's silence in Rule 32 is completely opposite to the meaning that this court has attached to silence in a variety of analogous settings. End quote. Burns v. United States from 1991. What kind of people want to control others with no personal accountability? Read what this state defense lawyer in Phoenix, Arizona wrote if you still don't believe these lawyers both can and do get away with murder every day of the week. Quote, the rule of judicial immunity is that judges of courts of general jurisdiction are not liable in civil actions for damages for their judicial acts, even when such acts are in excess of their jurisdiction or are alleged to have been done maliciously or corruptly. Acevedo v. Pima County Adult Probation Department. 142, Arizona 319, page 690, Pacific 2nd, 38. There you have it, lawyers defending malicious and corrupt acts even in excess of their jurisdiction. That would include an Arizona judge driving drunk in California, wouldn't it? Would this lawyer defend malicious actions committed against her? I'll bet this lawyer's reality is dictated by who's paying her. With their license to commit crimes, judges don't have to give a damn about you and me because they know their fellow honorable lawyers will not permit them to be held accountable. It's one thing to not have any respect for human life, but to then take away all personal responsibility while providing a small army and a slew of defense lawyers? Gosh, I guess it's nice to be the king. This is why in legal land, judges can set aside their sacred constitutional provisions such as justice in all cases shall be administered openly and without unnecessary delay. Article 2, Section 11, Arizona Constitution. This constitutional PR, if it were honest, would actually say, justice in all cases, except in cases where judges act in excess of their jurisdiction or are alleged to have acted maliciously or corruptly, shall be administered openly and without unnecessary delay. Excusing for a moment the underlying violence just to make a point, what kind of service is going to be provided by an individual who knows ahead of time he is going to be paid regardless of how he does his job?
Add to this the license to commit crimes with impunity, and what kind of individual do you have? Just what kind of individual actually seeks out such an exalted position? Is it really honorable to maliciously and corruptly damage people with no accountability? Who do these lawyers think they are? Kidding. Could you imagine a brain surgeon with the same mentality? Would you go to a brain surgeon who claimed he is immune for anything he may do to you during the course of an operation, even malicious injuries? A brain surgeon is free to conduct his business in such a manner. However, he'd probably be looking for other work if he were upfront with potential victims. Let's replace judicial with medical and brain surgeons for judges in the above quote from a Phoenix defense lawyer. The rule of medical immunity is that brain surgeons are not liable in civil actions for damages for their medical acts, even when such acts are in excess of their jurisdiction, such as injuries to the foot, or are alleged to have been done maliciously or corruptly. Crazy, isn't it? Especially when you consider how valuable a service brain surgeons provide. If you are familiar with the deposition scene from the movie Malice with Alec Baldwin, then you'll really understand what I mean. I know lawyers and other bureaucrats in defense of their cash cow may argue judges must be immune to ensure judicial independence, neutrality, and so forth. However, such an argument is patently frivolous for at least 3 reasons. 1. There is no judicial independence to begin with. 2. To have such alleged immunity, the power had to be delegated to them from the people. And 3. How does independence excuse anyone from committing crimes against the very people they are supposed to be protecting? Judicial independence or neutrality is a myth. This is because in a traffic case, the judge represents the alleged plaintiff, the so-called state, and is also paid by the state. That itself destroys any claim of independence. The judge is also on the same team as the cop who filed the ticket in the first place. They call their team the state. Yeah, I know. Lawyers would gyrate and genuflect in defense of honorable lawyers arguing necessity, necessity. But that doesn't make it any less of a conflict of interest and an unfair trial. I'm sure in his mind, David Chapman felt it was necessary to gun down John Lennon. This only proves a fair trial is impossible and bureaucrats know it. But they neither respect the rights of others nor their own laws. And why should they? They're sovereign, remember? They are the new kings. The very same people who impose the law violently on others refuse to subject themselves to it. Why? Because they would be the first ones they would have to throw in prison if they had to follow their own so-called laws. Violent people not complying with their own rules. Scandalous, isn't it? Shocking. On the other hand, if the judge were truly independent, then he's only an individual violently taking control, so-called jurisdiction, over my life and property. Remember, no judge asks for permission. He has no legal sanction for his violence because he's allegedly independent and not exercising a delegated authority. By definition, someone exercising a delegated authority is not independent. What utter nonsense, an independent servant. This doesn't mean I believe the BS that judges are public servants. It just proves it's a transparent lie. What is amazing is this monstrous lie can be told with a straight face. A servant is defined as follows. Quote, servant, a person employed to perform personal service for another in his affairs and who, in respect of his physical movements in the performance of the service, is subject to the other's control or right to control, definitely one who is not an independent contractor. 27th American Jurisprudence, First Contracts, Section 2, quoted from Ballantyne's Law Dictionary, page 1163. Let's not forget the claims by the lawyers doing business as the Arizona Supreme Court, to wit, quote, an independent and honorable judiciary is indispensable to justice in our society. End quote. Canon 1, Rule 81, Rules of the Supreme Court. I agree. Independence is indispensable to justice. But how is that squared with the claim judges are public servants exercising an alleged delegated authority? It's not. They're bald-faced lies from a group of men and women incapable of or unwilling to tell the truth. Judges are neither independent nor are they servants of the people they lie about protecting. What does all this mean? With the pretended legal sanction, he's not independent, and without the legal sanction, he's a base criminal. This is a problem for the bureaucrats. There's no way to resolve this issue. It's a catch-22. The solution? In legal land, it's intimidation, violence, and the time-worn political snarl. If you don't like it, just appeal it. This is a great line to hear, especially when review by appellate courts is discretionary. In litigation, without an overt government litigant, independence is a joke. The judge has a political oath of allegiance, just as the plaintiff's attorney and the defendant's attorney.
How can there be any true independence when the judge shares the same exact allegiance with the very same system that's attacking you in the first place, or supporting and facilitating the process of that attack? Also, if there is any such judicial immunity in force, then where on earth did it come from? It was either a delegated authority, as they call it in legal land, or it was usurped, that is, hallucinated into the real world. The political theory is that all of the powers exercised by bureaucrats have been delegated to them by the people. That's where that massive political lie, government of, by, and for the people, comes from. This means that all so-called judicial power was delegated by, from, and for the people. The question is, how many individuals, collectively known as we the people, are considered immune from the consequences of their own malicious and corrupt acts? This does not mean I think anyone should be immune. This just proves this isn't a delegated power. On the other hand, there is no immunity for so-called traffic violations, because the immunity that was allegedly delegated to these independent judges was only for malicious and corrupt acts, whereas traffic is inherently harmless and innocent. This is an example of what lawyers call mala prohibita, wrong only as forbidden by positive law. 21st American Jurisprudence, 2nd Crime, Section 25, Ballantyne's Law Dictionary, page 767. This is a legalese way of saying, it's wrong because I said it's wrong. Not surprisingly, because bureaucrats regard citizens as retarded children, parents patriae, this closely resembles what parents often say, yell, usually, at their children. Why? Because I said so. Because I'm telling you, that's why. Think about this inconsistency. You look at the Declaration of Independence and the Arizona Constitution, and we see the bureaucrats' claim as to why the government was created. They claim, quote, governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. Arizona Constitution, Article 2, Section 2. Well, how do you square that with mala prohibita laws? If something isn't wrong in the first place, then how can making a law against it be consistent with the alleged purpose of a so-called government, at least according to bureaucrats? What about the so-called crime of not having ID on you? Whose rights are violated if you walk around without ID? This so-called law is not consistent with the alleged purpose of the so-called government. This is just one more contradiction, another political lie rammed down our throats at the barrel of a gun. I've asked politicians if their claim of jurisdiction is factually consistent with this section, Article 2, Section 2, of their Constitution, and have never gotten an answer except what I call the three-monkey defense. The reason is obvious. They don't want to admit they have no valid case on the record or anywhere for that matter. This is probably why judges threaten violence whenever such questions are asked, as if by being violent they cover up the fact the proceedings are not fair or it's a responsive answer to the question. The last point in regards to the myth of judicial independence is the justification for violence. Why should a judge be immune from liability if he maliciously and corruptly damages the very people he is ostensibly protecting? Who wants to go to court if that's the case? I think they really mean that a judge cannot do his job without maliciously and corruptly damaging the unfortunate people in his courtroom. How would you sell such a service? Imagine a mobster using the immunity defense. I'm protecting the neighborhood, and to do so effectively, I have to be immune from any personal liability. I guess that's part of the offer I can't refuse. During a July 2001 trial, a judge in Arizona sustained an objection a witness could not draw legal conclusions. I walked the judge, the prosecutor, and the cop through to this point. Prior to this moment, I told the judge I only asked for the facts the cop's legal opinion were based on, and Paula sustained it anyway. Great, this is exactly where I wanted things. I then put the ticket on the bench and told the judge if the witness was not competent to testify, then all his legal opinions, including the ticket, should be stricken from the record. I also suggested the entire case should be dismissed so I could go home unmolested. The judge denied the request and said the witness was now competent to testify. I said, "Really? Okay, then he can answer the question." The judge had had enough at this point and said the cop could no longer testify and the cross-examination was over. Big surprise there. It was no less a surprise that she didn't care. Denial of cross-examination is considered an incurable error, at least in some parts of legal land. Here was a classic comedy of errors unfolding in this courtroom, because the cop was going from being considered competent to incompetent, back to competent, and then incompetent once again. This is to be expected when the opinions of total strangers are supported by nothing but violence. Contradiction after contradiction is exposed until the judge finally breaks down and sacrifices either 1, the use of physical violence, or 2, the pretense of fairness. One or the other has to go. The two cannot coexist, no matter how hard the honorable lawyer sitting 4 feet off the floor may try. This is why bureaucrats, like the state's lawyer or the judge, continually try to get me off point by arguing whether I did or did not do the act complained of, or just threatening me with contempt for doing anything else that deviates from their asinine program. Bureaucrats are also notoriously non-responsive, as if they believe their pretense of fairness and good faith can be maintained by refusing to be responsive. Recently, I helped a friend in California with a problem with the Franchise Tax Board, or rather some individuals forcibly taking, robbing, property under that particular doing business as label. These individuals doing business as the FTB were of the opinion that they had a right to this man's property. I wrote a few sentences in a letter essentially stating no position was being taken. Quote, I am neither admitting nor denying anything at this time. Please provide me with the facts your opinions are based on. End quote. True to form, there was no responsive answer, just another threat of violence from the so-called FTB. I called the number on the threatening letter, was informed this friend had been labeled a so-called tax protester, and no response was to be given except, of course, further threats of violence. This was done despite no protest or position of any kind. Who would have imagined such a thing, a non-responsive bureaucrat? So here was another clear example that these individuals were only interested in taking property by force, and nothing was going to stand in their way, not even taking the time to answer a few questions from a man who did not even disagree with them. Justice is not first on their list, or on their list at all. Lawyers think justice means complying with the law, no matter what the law may happen to be. Quote, justice, nothing more or less than exact conformity to some obligatory law. End quote. Borden v. State. From Ballantyne's Law Dictionary, page 696. To demonstrate how absurd this is, consider this question. Which came first, justice or the law? Also, weren't the men hung at Nuremberg complying with German law? This, of course, is not meant as a defense of the atrocities committed in the name of Hitler's law. It only demonstrates how insane the idea is that justice is conforming to law. I spoke to a Bernadette with the Taxpayers Advocate's Office in Sacramento, California. This woman told me, while she knew she was being taped, there was no rational basis to conclude the law was being properly applied to the friend I was helping. Despite having no rational basis, she adamantly refused to stop the proceedings despite that being her only job description. In addition to that, I had Roger, the state agent who did the so-called assessment, and each of his 4 supervisors admit on tape there was either no evidence to support the assessment or they were not qualified to make an assessment. Lisa, the top supervisor, told me, without a hint of shame or embarrassment, the law is binding because it's the law. I don't owe anything because I don't owe anything. And to top it off, despite all this, the members of the Board of Equalization, or BOE, still believe there was sufficient evidence to affirm this so-called assessment. I guess in California, evidence really means no rational basis. My question is, where is this evidence? The man who did the assessment admitted he had nothing. What is amazing is these bureaucrats gave no credibility to the very witness they relied on. The man said he had no evidence, and they did not believe him. This experience, and many others like them, taught me that bureaucrats consider their opinions to be evidence and a substitute for a witness's testimony. After all, they do have the guns to get you to comply. This is why I say a political law, as opposed to a natural law that is an observation anyway, not the whim of a man, is just an opinion backed by a gun. This inane way of doing business is equivalent to having every eyewitness to an alleged crime testify they didn't actually see anything, and still being convicted on only their testimony. When lies pay better than truth, expect lies. Author unknown. Chapter 11. Conclusion. Have you ever tried to justify a tax assessment or traffic ticket or any so-called trial without using political words and phrases such as government, law, constitution, statute, state, city, license, and jurisdiction? Try it. Take a minute and try it. Just use the facts. Describe what jurisdiction is factually without using the word jurisdiction or the others listed. In my personal experience, no bureaucrat has ever been able to do so, and I personally don't think a tax or traffic case can be justified, let alone proven, beyond a reasonable doubt, on just the facts. This is why bureaucrats blindside you with inane legal opinions ad nauseum, which means, quote, to a disgusting extent, end quote, from Ballantyne's Law Dictionary, page 36. This gives an appearance, rather a pretense or illusion of validity. But it's still just a pretense, a real flimsy public relations scam. Lawyers appear not to even know the difference between facts and legal opinions, as demonstrated by this recent nonsense I received from a Phoenix lawyer. Quote, heading Statement of Facts. Mr. X's wages and his compensation for services were taxable under the Arizona Constitution and the applicable Arizona statutes, particularly those in Title 42. End quote. Do I really need to point out this is not a statement of facts but a legal opinion? This constant barrage of legal gibberish you encounter once you enter legal land is not unlike Alice's experience once she enters Wonderland, because both here and there, words mean whatever a bureaucrat says or thinks they mean. Quote, "No, no, no. We're not stealing your car, we're taxing you." End quote. Quote, "This isn't slavery. It's called selective service." End quote. Quote, "You're not being held against your will. This is investigative detention." End quote. Quote, "You are free to earn a living and support your family doing whatever you want, just as long as you have a license for it." End quote. In legal land, words have no concrete meaning like we use in the real world. In legal land, bureaucrats make words mean whatever they want them to mean on a case-by-case basis. Legal land is where rocks are roses, dogs are cats, white is black, black is white, cold-blooded murder is acting within the scope of his employment, and armed robbery is taxation. For example, the Arizona Constitution restates the Declaration of Independence's basic principle with regards to governments governing by consent, which bureaucrats interpret to mean majority consent instead of the obviously correct individual consent. When they said by consent, they meant their consent, not yours. Couldn't that also be said of any race that was enslaved by this or that foreigner? Those prospective slaves never actually gave their consent. Some slave monger did. This point has an even broader application. Imagine this quote. Quote, "It is well established that before a binding contract is formed, the parties do not have to mutually consent to all material terms. Hill-Schaefer Partnership versus Shilson Family Trust." Close quote. Can you just imagine if the above precedent was twisted in order to say that instead? Well, when it comes to bureaucrats, it has been. They say citizens have formed a social compact, a contract, to do or not do this or that as part of their civic duty. The problem is politicians provide no evidence of anyone ever actually agreeing to do anything. I had an IRS lawyer tell me there was a real social compact. I asked him what social compact he planned on entering into evidence, and he told me the U.S. Constitution. I asked him if he was now claiming the Constitution was an agreement. His response? "No, that's not what I'm saying." Really? Then what was this lawyer saying? Quote, "Compact. Noun. A contract. Green versus Biddle. Particularly a contract of an important and serious nature." Close quote. From Ballantyne's Law Dictionary, page 232. This IRS lawyer named Richard didn't know what he was saying. Apparently he is capable of spewing forth legal jargon faster than he can comprehend it. And to think most people would consider this lawyer an authority on the law. Maybe there are people, call them bureaucrats or something else, that have the power to bind others to contracts. But if there are those who can, for example, consent to a constitution for me, then why don't they consent to all sorts of other things for me, such as my participating in Amway or even this or that religion? What is the limit of their vicarious consent? Another example of how bureaucrats use legalese and political language in an effort to bring about a different or alternate reality is with the act of stealing. The lay meaning of stealing is, quote, "Steal, to take another person's property without right or permission, to take dishonestly." End quote. Oxford American Dictionary, page 897. Now compare that with the legal land meaning. A person commits theft if, without lawful authority, such person knowingly, 1. Controls property of another with the intent to deprive him of such property, close quote. Arizona Revised Statute, section 13-1802. Maybe it's just me, but doesn't it look as though this so-called lawful authority grants bureaucrats a license to steal? In the lay sense, theft is theft, but not in the legal sense. In the legal sense, if you do have lawful authority, you can control the property of another with the intent to deprive them of that property. In other words, theft with lawful authority is magically not theft. What complete and utter nonsense. In the lay sense, it's a dog, but legally it's a diaper. If it isn't theft, then what is it? Politicians are coming right out and saying lawful authority is their license to steal. That is what a license is, the permission to do something that, without the license, would be considered a crime. Sometimes it really pays off to just pay attention to what lawyers and bureaucrats are telling you. Pay close attention to what politicians themselves say. Quote, "License, the privilege conferred by a public body on a person for doing of something which otherwise he would not have the right to do." 33rd American Jurisprudence License, section 2, close quote, from Ballantyne's Law Dictionary, page 736. So, to them, theft is wrong unless you have a license to do it, which they call lawful authority.
Read again to how Lysander Spooner put it. Quote, "If taxation without consent is not robbery, then any band of robbers have only to declare themselves a government, and all their robberies are legalized." Close quote. Lysander Spooner, letter to Grover Cleveland. To demonstrate further this same exact type of legal gibberish, I have placed the following two statutes from the Arizona Revised Statutes side by side for comparison. Read them very carefully. Quote, Section 13-1405, Sexual Conduct with a Minor Classification. A person commits sexual conduct with a minor by intentionally or knowing engaging in sexual intercourse or oral sexual contact with any person who is under 18 years of age. Close quote. Quote, Section 13-1407, Defenses. A. It is a defense to a prosecution pursuant to Section 13-1404 and 13-1405 involving a minor if the act was done in furtherance of a lawful medical practice. A lawful medical practice? To have sexual intercourse with a minor? What are they saying? That it's okay if a doctor does it? Did you notice that word lawful again? Before anyone accuses me of taking this out of context or somehow misinterpreting this to mean something other than it's not a crime to have sexual intercourse with a minor if the perpetrator is a doctor, please reference the following. Quote, A. A person commits unlawful imprisonment by knowingly restraining another person. B. In any prosecution for unlawful imprisonment, it is a defense that 1. The restraint was accomplished by a peace officer acting in good faith in the lawful performance of his duty. Close quote. Arizona Revised Statutes, Section 13-1303. Notice this is also a state-granted license to falsely imprison someone. Apparently these legislators believed there are lawful medical practices involving adult male doctors having sexual intercourse with children. Quote, 3. Sexual intercourse means penetration into the penis, vulva, or anus by any part of the body or by any object, or masturbatory contact with the penis or vulva. Close quote. Arizona Revised Statutes, Section 13-1401. The issue of lawful authority to do this, that, or the other thing presents yet another contradiction. If a person has no inherent right to do something, such as theft, the forcible taking of another's property, then it stands to reason that he gains no right to do so by getting together with some of his neighbors who don't have such a right either. It is self-evident there is no collective right to steal. If the whole body of people in a given geographical area were to get together and agree on any issue, they still wouldn't have any collective right to steal because each person only brings with him his individual rights. It's a basic mathematical principle that the whole is equal to the sum of its parts, except in legal land. In legal land, 2 plus 2 is whatever a legislator commands you to believe. Without an individual right to steal, there is no so-called collective right to steal. Without a collective right to steal, there is no right to then delegate to another body, whether that body is labeled public or private. Because no such body has any right to steal, no license may then be conferred by that body to any so-called state agent. It also follows there is no alleged lawful authority to steal. Now, having said all that, let's take another look at that statute where bureaucrats in fact succeed at legalizing theft. Quote, a person commits theft if, without lawful authority, such person knowingly, 1. Controls property of another with the intent to deprive him of such property. Close quote. Arizona Revised Statutes, Section 13-1802. So what is this alleged lawful authority? This lawful authority is nothing more than violence and threats of violence organized under a pretense of good faith and fairness. Remember, a law or statute is nothing more than an opinion backed by a gun. This presents yet another contradiction when placed side by side with the Senate opinion shown earlier stating that there is no so-called private ownership of property. If you don't own the property, then it's not being stolen from you, but from the bureaucrats who believe they own everything anyway. Perhaps this would help to explain why theft cases are brought in the name of the state. When I am allegedly within the state, I am in legal land, where words can and do mean whatever a bureaucrat needs or wants them to mean. This is why law dictionaries are constantly being revised. Quote, a word is not a crystal, transparent and unchanged. It is the skin of a living thought and may vary greatly in color and content according to the circumstances in which it is used. Written by Justice Oliver Wendell Holmes in Town v. Eisner, close quote, from the Foreword to Ballantyne's Law Dictionary, 3rd edition. Really? Maybe it's just me, but if a person uses the word raisin to describe a cat, he's not hailed as a scholar, but is called an idiot. Yes, the jury technically found you not guilty, but in the legal sense, you're still guilty. If I accept what Mr. Holmes wrote above, then how could I enter into a contract? How could there possibly be a meeting of the minds? How about certainty with the law?
What's the point of having any precedent when words mean whatever they want them to mean? This brings up yet another contradiction. The following is a declaration from a group of men and women strutting around as so-called legislators in Arizona. Quote, "It is the declared public policy of this state and the general purpose of the provisions of this criminal title are 1. To prescribe conduct that unjustifiably and inexcusably causes or threatens substantial harm to individual or public interest. 2. To give fair warning of the nature of the conduct prescribed and of the sentences authorized upon conviction." Close quote. Arizona Revised Statute, Section 13-101. How can there be fair warning when the words used are the skin of a living thought and may vary greatly in color and content depending on the context? Remember what lawyers have declared. Quote, "By decisional law, the rule of necessity may override the rule of disqualification." Close quote. Rule 81, Code of Judicial Conduct, Commentary for Canon 3E1. In other words, the written word ultimately means nothing to bureaucrats and lawyers unless it is being used as a justification for stealing property in the name of a non-existent state. If a law, statute, or rule gets in their way, they override it, claiming necessity, and continue with their raping, pillaging, and plundering. This happened in an IRS case in Arizona. The IRS lawyer admitted the agent had stolen this man's property through fraud. In addition, they admitted that none of the so-called statutes governing assessments and collections were followed. This U.S. attorney argued the IRS was not required to follow the assessment and collection statutes laid out in Title 26 of the United States Code, and yet enjoyed absolute immunity for crimes committed while on the job. What happened to 26 U.S.C. 7414, the statute making it a felony for revenue agents to oppress, extort, and not comply with the so-called revenue laws? That's right, by decisional law. Another lawyer, this one pretending to be a federal district court judge in Arizona, agreed with this nonsense, so an appeal was made to other lawyers doing business as the Ninth Circuit Court of Appeals. True to form, those lawyers also agreed the IRS is not required to follow the assessment and collection statutes of Title 26 of the USC. Is it any wonder this opinion was then labeled by these same lawyers as not to be published, not to be cited as precedent? Welcome to legal land. Another bureaucrat, this one from California, vehemently claimed, "We have a valid assessment against Joe Schmo, Mark." I responded, "Okay, how many elements are there in a valid assessment?" This not only took the wind completely out of her sails, but it abruptly ended the conversation because she couldn't answer this easy question. Instead, she refused to try and answer and asked me to put the question in writing. She also promised she would be responsive, and so I sent her the letter. She then sent me a form letter 4 months later containing nothing but inane ramblings about the constitutionality of the tax laws and other non-responsive legal mumbo-jumbo. So I called her and asked why she was not responsive to my questions, and she said, "Because your arguments were frivolous and completely lacking in merit. They're ridiculous." I responded, "Susan, there were no arguments, just a few questions you asked me to put in writing which you promised you'd be responsive to." She stuttered and finally said, "Well, your questions were frivolous." I had to ask her, "Susan, how can a question be frivolous?" For some reason, Susan couldn't or wouldn't answer me. It didn't matter that she had asked me to send them to her. To a bureaucrat, anything other than a complete surrender to their professed authority is considered frivolous. Frivolous means so lacking in merit as to require no demonstration. So why would she feel compelled to send me a form letter at all? Susan claimed there was a valid assessment, so I didn't argue or disagree. Instead, I asked her how many elements there were to a valid assessment. If she is so confident there is a valid assessment, then she should have been able to tell me how many elements there were. I hardly think such a question was frivolous. I don't think any relevant question is frivolous given its definition. It's not the question that's frivolous. It's the nonsensical bureaucratic answers, if any answers at all. However, this was legal land where the bureaucrats are always correct and the non-violent productive people they are fleecing are always wrong. Because of that, if I ever want to make a bureaucrat uneasy, I ask them if it's possible their opinion could be wrong. Not that it is wrong, just the possibility it could be wrong. This typically produces an emphatic no on their part. However, it sets up a contradiction in a situation like the one above with Susan. They are super confident they cannot be wrong ever, and yet they adamantly refuse to discuss the facts to support their legal opinions, which is classic legal land. Let's just do away with those pesky little facts now, shall we? I called another California bureaucrat recently and told her I was not admitting or denying anything at this time. I only wanted to know the facts her legal opinions were based on. She said, "Well, Mark, the law says..." I cut her off and told her I was not interested in what the law says. I just wanted to know the facts her opinions were based on. She said again, "The law says..." I had to cut her off yet again, and repeated I was not interested in any more legal opinions, just the facts. This comedy routine continued another 2 times until she finally gave up and said she had no idea what you're talking about, Mark." I would say she was really admitting she had no idea what she was talking about. The good news is, at least in that case, she had enough sense to drop her pretended claim. In my experience, most bureaucrats don't drop groundless cases even when they admit they have no evidence. This is because bureaucrats have plenty of heavily armed troops on the payroll and are always long on opinion and short on facts, and they don't like to be questioned. They especially hate being questioned on their phony authority, their alleged right to dominate other men, women, and children. In legal land, the opinions and mental conceptions held by bureaucrats are the law, and those opinions are never incorrect. If you don't believe me, then ask a bureaucrat who intends on taking your property and time. That's why any challenge from any productive person is labeled patently frivolous, specious, or spurious. Only in legal land can a question be a groundless legal argument and frivolous. I've wondered if there is a certain school for U.S. attorneys where they are actually taught to respond to IRS challenges each and every time with just, "The petition contains nothing but frivolous legal arguments," no matter what a petition actually says. I write this because I've seen this so many times. Only in legal land can you own property and not own property at the same time. Only in legal land can you be forcibly taken out of your car, forcibly handcuffed, taken away against your will, and caged for a ransom while simultaneously being read your rights as if you had any they gave a damn about. Only in legal land is it possible to have a so-called fair trial based entirely upon violence where the so-called independent and impartial judge not only represents both the very same party bringing the charge and the defendant, but also testifies against the defendant as if he were a real witness. Only in legal land would children be mercilessly gunned down for doing absolutely nothing except peacefully withdrawing their actual or pretended support of the mythology known as politics. And last but not least, only in legal land is violence equated with good faith and fairness, where violently taking control of another human being does not offend traditional notions of fair play if you label such violence as jurisdiction. Lawyers and other bureaucrats whose very jobs depend entirely upon violence, they do call it the adversary system, will probably defend their jobs tooth and nail, but that is to be expected. After having spoken to so many bureaucrats and researched their laws and court opinions, I'm probably familiar with most political justifications for organized violence. It is very rare for me to hear or read about a justification for the violence that surprises me, although I did get a new one recently, in the summer of 2002. This was in the same opinion mentioned earlier where 3 California Court of Appeals lawyers justified a denial of cross-examination by presuming there were even more witnesses the man I was helping could not cross-examine. These lawyers justified the refusal of the trial court judge to take mandatory judicial notice of facts. To do so, they really pulled out the legal absurdities all over again. First, they mislabeled the facts as legal opinions and stated the trial judge had no obligation to take notice of legal opinions. Then, in a footnote to this dementia, they claimed that based on this reasoning, there was no obligation to take notice of these facts. Try and follow their Alice in Wonderland-like gibberish here again. 1. A judge is asked to take judicial notice of certain facts. 2. Lawyers label these facts legal opinions. 3. Judicial notice does not need to be taken of legal opinions. 4. Because of this, judicial notice of these facts is not required. Only in legal land can facts become legal opinions and then go back to being facts all over again within the same opinion. This is so a host of lawyers acting as judges can ignore the truth and contradict their own rules and sacred laws. In the real world, such actions can get you committed in a mental institution as insane, but in legal land, you are hailed as an officer of the court, a scholar, and honorable. It's not surprising these 3 lawyers pretending to be judges didn't want their written legal opinion published so that it might be cited as so-called precedent. That, however, will not stop me from making it available for others to read and expose it for what it is, legalistic gibberish. Speaking of legalistic gibberish, the lawyer I mentioned earlier recently wrote, quote, "Examples of the irrational legal theories and requests of petitioner may be found in all documents sent to the respondent, one of which, the petitioner's request for admissions, was attached to the motion to dismiss and is also attached hereto as Respondent's Exhibit 1. See, for example, Request 14. The United States government is just a group of men and women." Close quote. Irrational. Then what is the United States government? Reptiles? Sharks? Leeches? Obediently surrender 40% of the money you earn and don't you dare question who or what you are paying it to. This same lawyer who thinks it's irrational to consider the United States government as a men and women is so worried about having to make such an admission or denial, he'll seek a protective order instead of making a simple objection. And what does this lawyer mean by irrational? My law dictionary defines rational as capable of reasoning, sane. Ballantyne's Law Dictionary, page
1057. I would guess that insane was what he probably had in mind. He thinks it's insane to believe the United States government is a group of men and women. Let's not consider simple, everyday observation here for a moment. Let's look at what politicians call organic law, to wit. Quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." Close quote. Declaration of Independence of July 4th, 1776. I'll let you decide who the irrational one is. To help make this decision easier, let me give another example. This same IRS lawyer also claimed the following is an irrational legal theory, to wit, "The Constitution is a written instrument." Who am I to disagree? I agree. In one sense, this lawyer is correct. However, in his zeal to label everything irrational, so his cronies could steal someone's property, he neglected to check the source of the statement. Again, forget about common everyday observation to prove the Constitution is a written instrument, and consider I didn't write the statement. I only quoted it, without the source, which just happens to be the honorable lawyers doing business as the United States Supreme Court, to wit. Quote, "The Constitution is a written instrument." Close quote. South Carolina versus United States, 199 U.S. 437 at page 448. Think about what this lawyer is really saying. Bureaucrats consider these opinions to be the supreme law of the land. This lawyer wrote, "The supreme law of the land is an irrational legal theory." Why would I disagree with a lawyer who's starting to see eye to eye with me? I would like to hear him explain how some irrational legal theory creates obligations. The last example, some people may accuse me of making up. However, it's true and was written by a lawyer representing the IRS. This is also part of a request for admissions that was directed to several IRS employees who are material witnesses in a court case. Quote, "I have a duty to correctly apply the IRC," close quote, the IRC being the Internal Revenue Code. They were to either admit or deny this. As stated previously, their lawyer claimed that this was an irrational legal theory. Why does this experienced lawyer think this? Who knows, maybe he thought I, a mere layman, wrote it. However, all I did was paraphrase the following. Quote, "The function of the Internal Revenue Service is to administer the Internal Revenue Code. It is the duty of the service to carry out that policy by correctly applying the laws enacted by Congress." Close quote. Internal Revenue Procedure 64-22. Thinking the IRS has a duty to correctly apply the law is an irrational legal theory. Do you think the men and women doing business as the IRS have a duty to correctly apply the law? In legal land, bureaucrats get away with saying black is white and white is black because of the violence backing their opinions. In light of this, how can anyone expect a fair trial when a so-called judge calls facts opinions and opinions facts? And, to make matters worse, it's not that they don't really know the difference, it's done deliberately. The bottom line here is this. Don't expect fairness and good faith from individuals doing business at the barrel of a gun. In plain English, don't expect fairness from the agents of any coercive state, because to them, we are cows to be milked. Quote, "The fact that an opinion has been widely held is no evidence whatever that it is not entirely absurd. Indeed, in view of the silliness of the majority of mankind, the widespread belief is more likely to be foolish than sensible." Close quote. Bertrand Russell. Chapter 12. Final Thoughts. This book shouldn't end without some explanation of an alternative to a coercive state and the mythology supporting it. People only need to provide better services and products than bureaucrats do. This, in a sense, could put them out of business, to finally and forever put to rest the nonsense that services need to be provided on a compulsory basis. It doesn't take violence to put this dinosaur called politics to rest. Apathy and better services provided on a mutually voluntary basis would. As you can tell, I'm no fan of coercive business practices. I am sure you would agree that no service or product needs to be administered at the barrel of a gun. However, I do not need to reinvent the wheel. There are many books already out dealing with the subject, and I highly recommend the writings of Murray Rothbard, and in particular, Sic Iter ad Astra by Andrew J. Galambos. Maybe you've never looked at what a so-called government does as a service or product before. Isn't that all these men and women are supposed to be doing? They weren't hired to be self-appointed gods, were they? What else is meant by the Declaration of Independence? Quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed." Close quote. Protecting, quote, life, liberty, and the pursuit of happiness, close quote, is a service provided by men and women like you and me. There is nothing magical or special about it, and there is nothing indicating this type of service should be canonized and administered at the barrel of a gun. Lysander Spooner put it this way, quote, if A were to go to B, a merchant, and say to him, Sir, I am a night watchman, and I insist upon your employing me as such in protecting your property against burglars, and, to enable me to do so more effectively, I insist upon your letting me tie your own hands and feet, so that you cannot interfere with me, and also upon your delivering up to me all your keys to your store, your safe, and to all your valuables, and that you authorize me to act solely and fully according to my own will, pleasure, and discretion in the matter. And I demand still further that you shall give me an absolute guarantee that you will not hold me to any accountability whatever for anything I may do, or for anything that may happen to your goods while they are under my protection. And unless you comply with this proposal, I will now kill you on the spot. If A were to say all this to B, B would naturally conclude that A himself was the most impudent and dangerous burglar that he, B, had to fear, and that if he, B, wished to secure his property against burglars, his best way would be to kill A in the first place, and then take his chances against all such other burglars as might come forward. Close quote. Lysander Spooner, Letter to Grover Cleveland. Consent means individual consent. If the Declaration did not mean individual consent, then the Declaration is nothing more than political rhetoric and not worth the paper it is written on. Consent means you are free to accept the service or not, without conditions attached or coercion of any kind. Some may argue there must be compulsory payments, or people would not pay for valuable services and products. I'll bet you pay for many valuable services without having to be threatened first. Such bureaucratic jargon is used to perpetuate a coercive protection racket ran by individuals who refuse to or are incapable of interacting with other people on a mutually voluntary basis. It also demonstrates a lack of understanding of economics and human relations. There are many successful and profitable businesses offering services and products on a purely voluntary basis. They are still profitable even if a percentage of their customers do not pay. It is a part of business. Get over it. Just because a few people may not pay is no reason the service should become provided at the barrel of a gun. Some may argue there would be additional chaos if there were no compulsory political laws. This myth is laughable and really needs no explanation. Do you have any idea how many millions of political laws there are? Neither do I, and I really don't care. But let's use California as an example. If you live in Los Angeles, you have the Los Angeles City Code, the State Code, and the Federal Code you are allegedly required to know and comply with. Each is accompanied by a set of regulations. Have you ever read them all? Then consider the millions of court opinions interpreting and reinterpreting all those laws. If that were not enough, politicians are constantly making new laws and new interpretations every day. No one could keep up with that. The point is that no one knows or could know the law. If there is chaos, it's in the courtrooms when someone is seeking the truth. As I've shown, if I am accused of violating one statute, a lawyer pretending to be a judge has to break at least 8 of his own laws to put me on trial. And don't forget, judges can suspend their rules any time they want. The bottom line is that protecting life, liberty, and property is a service as any other. There's nothing special about this particular service. It's provided by men and women just like other services are provided. What makes this all the more worse is the plain truth that politicians do not acknowledge any obligation to protect anyone anyway. There are many opinions to prove this. The following is just one. Quote, the Constitution is a charter of negative liberties. It tells the state to let the people alone. It does not require the federal government or the state to provide services, even so elementary a service as maintaining law and order. Close quote. Bowers v. DeVito, 686 Federal 2nd, 616. There you have it, politicians, bureaucrats, or whatever you call them, openly admitting they have no duty to protect anyone. Reread the last part again about maintaining law and order being a service. I'll place the following laws together to see which politicians are lying. Quote, governments derive their just powers from the consent of the governed and are established to protect and maintain individual rights. Close quote. Arizona Constitution, Article 2, Section 2. Quote, the Constitution is a charter of negative liberties. It tells the state to let the people alone. It does not require the federal government or the states to provide services, even so elementary a service as maintaining law and order. Close quote. Bowers v. DeVito, 686 Federal 2nd, 616. Notwithstanding the lies inherent in all politics, the protection of life, liberty, and property is a service.
There is no reason why this particular service should be set apart from others and provided at the barrel of a machine gun. What a business concept. No sales, no accountability, and everyone is a paying customer whether they want to or not. And why aren't these services provided on a mutually voluntary basis? Quite simply, the loss of dominance and control over the people. Can you picture a world without legal land? That was the end of the reading of Adventures in Legal Land. It was written by Mark Stevens and read by Jace Johansson.